Preliminary title. Art 2, General Principles, Criminal Law, Characteristics 1988 Number 1. A. What are the limitations upon the power of Congress to enact penal laws? C. State the characteristics of criminal law and explain each. Answer. The limitations upon the power of Congress to enact penal laws are as follows. 1. Congress cannot enact an ex post facto law. 2. Congress cannot enact a bill of attainder. 3. Congress cannot provide for a cruel punishment. However, other limitations may be considered like 1. Congress cannot enact a law which shall punish for a condition. Congress shall punish an act and 3. Not the condition or status. Robinson vs. California. 2. Congress should consider Article 21 of the Revised Penal Code, which provides that penalties that may be imposed. No felony shall be punishable by any penalty not prescribed by law prior to its commission. C. The characteristics of criminal law are as follows. 1. Generality, that the law is binding upon all persons who reside to sojourn in the Philippines, irrespective of age, sex, color, creed, or personal circumstances. 2. Territoriality, that the law is applicable to all crimes committed within the limits of Philippine territory, which includes its atmosphere, interiors, waters and maritime zone, Art 2. 3. Prospectivity, that the law does not have any retroactive effect, except if it favors the offender unless he is a habitual delinquent, Art 22, or the law otherwise provides. Article 2. If the Revised Penal Code however provides for the following exception. A. Treaty stipulations or by a law of preferential application. Art 2. General Principles, Diplomatic Immunity 1975 No. 3. The American consul accredited to the Philippines while driving his car recklessly and imprudently along Roxas Boulevard bumped a pedestrian who was crossing the street, and the latter died as a consequence of his injuries. Prosecuted in court for the crime of homicide through reckless imprudence, the consul claimed diplomatic immunity, alleging that he is not subject to Philippine laws and regulations. Is his defense tenable? Why? Answer. Under the principle of public international law, only sovereigns, or heads of states, ambassadors, ministers plenipotentiary and ministers resident enjoy diplomatic immunity. Consuls do not enjoy immunity from criminal prosecution. Representative Act No. 75, Skenicherberger v. Moran, 63 Philosophy 250. Art 2, General Principles, Features of Principles of Criminal Law 1978 No. IA. Discuss concisely the cardinal features of principles of criminal law. Give an exception to each principle and explain the same. Answer. The cardinal principles of criminal law are generality, territoriality and prospectivity. Generality means that a penal law applies to all persons who live or sojourn in Philippine territory, subject to the principles of public international law and treaty stipulations. A penal law does not therefore apply to duly accredited foreign ambassadors and ministers in the Philippines, since under international law they enjoy diplomatic immunity. Territoriality means that a penal law is enforceable within the territory of the Philippines. However, under Article 2 of the Revised Penal Code, its provisions shall be enforced outside of the jurisdiction of the Philippines against those, among others, who should commit an offense while on a Philippine ship or airship. The exception will apply if the Philippine ship or airship is registered under the laws of the Philippines. The registered Philippine ship at the time of the commission of the crime must be in the airspace not within the jurisdiction of a foreign country. Prospectivity means that a penal law does not have any retroactive effect. Otherwise, it will become an ex post facto law. However, if a penal law is favorable to the accused, it may be given retroactive effect, unless the accused is an habitual delinquent or the law otherwise expressly provides. Art 2, General Principles, Laws Defining Classes of Crimes 1978 No. IB. Penal laws define distinct classes of crimes. Discuss and elucidate on their distinctions. Answer. In general, penal laws refer to the revised penal code and special laws. Crimes punished in the revised penal code are called felonies and those punished in special laws are called offenses. A felony as a rule is an act mala in se which is wrongful from its very nature, while an offense is an act mala prohibits, which is a wrong only because of the law punishing it. The revised penal code also classifies felonies as intentional, if dolo or malice is present, and culpable, if there is culpa or fault. According to gravity, felonies are grave, if the penalty is capital or afflictive in any of its periods, less grave, if the penalty in its maximum period is correctional, and light, if the penalty is arresto menor or a fine not exceeding p. 200.00, or both. Art 2, General Principles, Schools of Thought in Criminal Law 1996 No. 1. 1. What are the different schools of thought or theories in criminal law and describe each briefly. 2. To what theory does our revised penal code belong? Answer. 1. There are two schools of thought in criminal law, and these are, a. The classical theory, which simply means that the basis of criminal liabilities is human free will, and the purpose of the penalty is retribution, which must be proportional to the gravity of the offense, and b. The positivist theory, which considers man as a social being and his acts are attributable not just to his will but to other forces of society. As such, punishment is not the solution, as he is not entirely to be blamed. Law and jurisprudence should not be the yardstick in the imposition of sanction, instead the underlying reasons would be inquired into. 2. We follow the classical school of thought, although some provisions of eminently positivist in tendencies, like punishment of impossible crime, juvenile circumstances, are incorporated in our code. Art 2, General Principles, Territoriality, Exceptions 1982 No. 1. Article 2 of the Revised Penal Code states that the provisions of the said code shall be applicable to crimes committed not only within the territorial jurisdiction of the Philippines, but also outside thereof, in the 5 instances mentioned therein. What are the underlying reasons behind, or rationale for, each of those 5 instances? Explain fully one by one. Answer. The 5 instances provided in Article 2 of the Revised Penal Code in which its provisions are applicable outside the territorial jurisdiction of the Philippines and the underlying reasons behind each of said instances are the following. 1. When the offender should commit an offense while on a Philippine ship or airship. For this exception to apply, the Philippine ship or airship must be registered under Philippine laws. As such, it is considered an extension of Philippine territory. 2. When the offender should forge or counterfeit any coin or currency note of the Philippines or obligations and securities issued by the government. The reason is to protect Philippine currency notes and obligations or securities issued by the government in order to preserve the financial credit and stability of the government. 3. When the offender should be liable for acts committed with the introduction in the Philippines of obligations and securities mentioned in paragraph 2. The reason is to protect the economic interests of the Philippines, as the introduction of such forged or counterfeit obligations and securities into the country is as dangerous, if not more, as the forging or counterfeiting of the same. 4. When the offender, while being a public officer or employee, should commit an offense in the exercise of his functions. The offense committed by the public officer affects the integrity of the office and is against public administration of the Philippines. The law should follow the public officer wherever he may be. If such is not punished by the laws of the country where the public officer is at the time of its commission, or is not treatable by its courts, the absence of this exception would not make the provisions of the code applicable, since the crime is committed outside of Philippine territory. 5. When the offender should commit any of the crimes against the national security and the law of nations. The reason is to safeguard the existence of the state. Art 2, General Principles, Territoriality 1994 No. 12. Abe, married to Liza, contracted another marriage with Connie in Singapore. Thereafter, Abe and Connie returned to the Philippines and lived as husband and wife in the hometown of Abe in Calamba, Laguna. 1. Can Abe be prosecuted for bigamy? Answer. 1. No, Abe may not be prosecuted for bigamy since the bigamous marriage was contracted or solemnized in Singapore, hence such violation is not one of those where the revised penal code, under Art. 2 thereof, may be applied extraterritorially. The general rule on territoriality of criminal law governs the situation. Art 2, General Principles, Territoriality, Generality, Irretrospectivity 1998 No I. What are the 3 cardinal features or main characteristics of Philippine criminal law? 5% 1. Answer. The 3 main characteristics of Philippine criminal law are: 1. Generality or its being binding to all persons who live or sojourn in Philippine territory subject to certain exceptions. 2. Territoriality or its having force and effect only within Philippine territory, subject to certain exceptions also. 3. Irretrospectivity or its application only to acts and omissions committed/incurred after the effectivity of the law. Art 2, General Principles, Territoriality, Exception 1986 No. 1. Aaron is the defendant in a civil case being tried in the Manila Regional Trial Court. Together with his lawyer, Aaron went to Singapore to take the deposition of a witness who, Aaron hoped, would support his defense. The deposition was taken in a function room of the Singapore Hotel before Mr. Aguila, the Philippine Consul General. Neither plaintiff nor his counsel attended the proceeding. After the deposition taking, Aaron, not satisfied with the results, persuaded Aguila to make substantial changes in the transcripts of stenographic notes. Aaron offered $5,000 in Singaporean currency which Aguila readily accepted. Leona, vacationing daughter of Aguila, was given $200 by Aaron when she made the alterations in the transcripts. The deponent, with neither notice nor knowledge of the alterations, signed the deposition. May Aaron, Aguila, and Leona be prosecuted in a Philippine court for offences punishable under our revised penal code? What are the offences, if any? Explain. Answer. Only Aguila can be prosecuted before the Philippine court. Being the Philippine Consul General in Singapore, as a public officer, the provisions of the revised penal code can be given extrajudicial application, as the crime committed by him is related to the duties of his office. Aaron and Leona, being private persons, cannot be prosecuted before the Philippine court because regarding the offences committed by them, the provisions of the revised penal code cannot be given extraterritorial application. Aguila committed bribery and Aaron corruption of a public officer. Leona committed falsification of a public document as a principal by direct participation and Aaron as a principal by inducement. Art 2, Revised Penal Code. Art 2, General Principles, Territoriality, Jurisdiction over Vessel 2000 No I. After drinking 1 case of San Miguel beer and taking 2 plates of pulutan, Binoy, a Filipino seaman, stabbed to death Siomai, a Singaporean seaman, aboard M/V Princess of the Pacific, an overseas vessel which was sailing in the South China Sea. The vessel, although Panamanian registered, is owned by Lucio Sy, a rich Filipino businessman. When M/V Princess of the Pacific reached a Philippine port at Cebu City, the captain of the vessel turned over the assailant Binoy to the Philippine authorities. An information for homicide was filed against Binoy in the Regional Trial Court of Cebu City. He moved to quash the information for lack of jurisdiction. If you were the judge, will you grant the motion? Why? 5%. Suggested answer. Yes. The motion to quash the information should be granted. The Philippine court has no jurisdiction over the crime committed since it was committed on the high seas or outside of Philippine territory and on board a vessel not registered or licensed in the Philippines, US vs Fowler, 1 Phil 614. It is the registration of the vessel in accordance with the laws of the Philippines, not the citizenship of her owner, which makes it a Philippine ship. The vessel being registered in Panama, the laws of Panama govern while it is in the high seas. Felonies. Art 3, Common Law Crimes 1988 Number 1. B. Are there common law crimes in our jurisdiction? Answer. B. There are none. The rule is, nullum crimen, nulla pona sine lege, there is no crime if there is no law punishing it. Art. 3, Criminal Intent 1978 No ID. Is malice or criminal intent an essential requisite of all crimes? Explain. May criminal intent be presumed to exist? Discuss. Answer. Malice or criminal intent is not an essential element in all crimes. It is essential only in crimes which are mala in se. In an offense which is mala prohibita, criminal intent is not an element. Criminal intent is presumed to exist if the act is unlawful. However, in some crimes, a specific intent cannot be presumed because it is an integral element thereof. For example, in frustrated homicide, the specific intent to kill is not presumed. If it is not proved, the crime will not be frustrated homicide but serious physical injuries. Art. 3, Dolo vs Culpa 1978 No IC. Discuss the distinctions between dolo and culpa. Give an example of each. Answer. Dolo implies deliberate intent. It is equivalent to malice. Culpa means fault, that is, there is no intent or malice. The wrongful act is the result of imprudence, negligence, lack of skill or lack of foresight. A felony is committed by means of dolo or culpa and must be voluntary. Art. 3, Mala in se vs Mala Prohibita 1997 No L. Distinguish between crimes mala in se and crimes mala prohibita. May an act be malum in se and be, at the same time, malum prohibitum? Answer. Crimes mala in se are felonious acts committed by dolo or culpa as defined in the revised penal code. Lack of criminal intent is a valid defense, except when the crime results from criminal negligence. On the other hand, crimes mala prohibita are those considered wrong only because they are prohibited by statute. They constitute violations of mere rules of convenience designed to secure a more orderly regulation of the affairs of society. Yes, an act may be malum in se and malum prohibitum at the same time. In People v Sunico, et.al. Ca 50 Aug 5880, it was held that the omission or failure of election inspectors and poll clerks to include a voter's name in the registry list of voters is wrong per se because it disenfranchises a voter of his right to vote. In this regard it is considered as malum in se, since it is punished. Under a special law, Sector 101 and 103, Revised Election Code, it is considered malum prohibitum. Art. 3, Mala in se vs Mala Prohibita 2001 No 7. B. Briefly state what essentially distinguishes a crime mala prohibita from a crime mala in se, 2%. Suggested answer. B. Crimes mala prohibita are distinguished from crimes mala in se as follows, to wit. In crimes mala prohibita, the acts are not by nature wrong, evil, or bad. They are punished only because there is a law prohibiting them for public good, and thus good faith or lack of criminal intent in doing the prohibited act is not a defense. In crimes mala in se, the acts are by nature wrong, evil, or bad, and so generally condemned. The moral trait of the offender is involved, thus, good faith or lack of criminal intent on the part of the offender is a defense, unless the crime is the result of criminal negligence. Correspondingly, modifying circumstances are considered in punishing the offender. Art. 3, Mala in se vs Mala Prohibita 2003 No I. Distinguish, in their respective concepts and legal implications, between crimes mala in se and crimes mala prohibits. 4%. Suggested answer, in concept. Crimes ma/i in se are those where the acts or omissions penalized are inherently bad, evil, or wrong that they are almost universally condemned. Crimes mala prohibita are those where the acts penalized are not inherently bad, evil, or wrong but prohibited by law for public good, public welfare or interest, and whoever violates the prohibition are penalized. In legal implications. In crimes mala in SE, good faith or lack of criminal intent/negligence is a defense, while in crimes mala prohibita, good faith or lack of criminal intent or malice is not a defense, it is enough that the prohibition was voluntarily violated. Also, criminal liability is generally incurred in crimes mala in SE even when the crime is only attempted or frustrated, while in crimes mala prohibits, criminal liability is generally incurred only when the crime is consummated. Also in crimes mala in SE, mitigating and aggravating circumstances are appreciated in imposing the penalties, while in crimes mala prohibita, such circumstances are not appreciated unless the special law has adopted the scheme or scale of penalties under the revised penal code. Art. 3, Mala in SE vs Mala prohibita, Criminal Intent 1988 No. 2. A. Distinguish crime mala in SE from crimes mala prohibita. B. May a crime be committed without criminal intent? Explain. Answer. A. There are three distinctions between mala in SE and mala prohibita. 1. A crime mala in SE is a natural wrong. On the other hand, an offense mala prohibita is a wrong only because it is prohibited by law. 2. In the commission of a crime mala in SE, intent is an element, whereas in the commission of an offense mala prohibits, criminal intent is immaterial, and 3. Crimes mala in SE are punished by the revised penal code, although the revised penal code may cover special laws, while offense mala prohibita are punished by special laws. B. A crime may be committed without criminal intent in 2 cases, 1 offense, punishable as mala prohibita, and 2 felonies committed by means of culpa. Art. 3, Mala in SE vs Mala prohibita, Motive vs Intent 1999 No. 4. A. Distinguish mala in SE from mala prohibita, motive from intent. 3%. B. When is motive relevant to prove a case? When is it not necessary to be established? Explain. 3%. Suggested answer. A. In mala in SE, the acts constituting the crimes are inherently evil, bad, or wrong, and hence involves the moral traits of the offender, while in mala prohibita, the acts constituting the crimes are not inherently bad, evil, or wrong but prohibited and made punishable only for public good. And because the moral trait of the offender is involved in mala in SE. Modifying circumstances, the offender's extent of participation in the crime, and the degree of accomplishment of the crime are taken into account in imposing the penalty. These are not so in mala prohibita, where criminal liability arises only when the acts are consummated. Motive is the moving power which impels a person to do an act for a definite result, while intent is the purpose for using a particular means to bring about a desired result. Motive is not an element of a crime, but intent is an element of intentional crimes. Motive, if attending a crime, always precede the intent. B. Motive is relevant to prove a case when there is doubt as to the identity of the offender, or when the act committed gives rise to variant crimes and there is the need to determine the proper crime to be imputed to the offender. It is not necessary to prove motive when the offender is positively identified or the criminal act did not give rise to variant crimes. Art. 3, Mala prohibita or special laws, generally only consummated stage punished. 2000 No. 16. Mr. Carlos Gabizi, a customs guard, and Mr. Rico Ito, a private individual, went to the office of Mr. Diether Ocuarto, a customs broker, and represented themselves as agents of Moonglow Commercial Trading, an importer of children's clothes and toys. Mr. Gabizi and Mr. Ito engaged Mr. Ocuarto to prepare and file with the Bureau of Customs the necessary import entry and Internal Revenue Declaration covering Moonglow's shipment. Mr. Gabizi and Mr. Ito submitted to Mr. Ocuarto a packing list, a commercial invoice, a bill of lading and a sworn import duty declaration which declared the shipment as children's toys, the taxes and duties of which were computed at P60,000.00. Mr. Ocuarto filed the aforementioned documents with the Manila International Container Port. However, before the shipment was released, a spot check was conducted by Customs Senior Agent James Bandido, who discovered that the contents of the van, shipment, were not children's toys as declared in the shipping documents but 1,000 units of videocassette recorders with taxes and duties computed at P600,000.00. A hold order and warrant of seizure and detention were then issued by the District Collector of Customs. Further investigation showed that Moonglow is non-existent. Consequently, Mr. Gabizi and Mr. Ito were charged with and convicted for violation of Section 3(e) of RA 3019, which makes it unlawful, among others, for public officers to cause any undue injury to any party, including the government, in the discharge of official functions through manifest partiality, evident bad faith or gross inexcusable negligence. In their motion for reconsideration, the accused alleged that the decision was erroneous because the crime was not consummated but was only at an attempted stage, and that in fact the government did not suffer any undue injury. A. Is the contention of both accused correct? Explain. 3%. B. Assuming that the attempted or frustrated stage of the violation charged is not punishable, may the accused be nevertheless convicted for an offense punished by the revised penal code under the facts of the case? Explain. 3%. Suggested answer. A. Yes, the contention of the accused that the crime was not consummated is correct. RA 3019 is a special law punishing acts mala prohibita. As a rule, attempted violation of a special law is not punished. Actual injury is required. B. Yes, both are liable for attempted estafa through falsification of commercial documents, a complex crime. Art 3, Motive vs Intent 1996 No. 1. 3. Distinguish intent from motive in criminal law. 4. May crime be committed without criminal intent? Answer. 3. Motive is the moving power which impels one to action for a definite result, whereas intent is the purpose to use a particular means to effect such results. Motive is not an essential element of a felony and need not be proved for purpose of conviction, while intent is an essential element of felonies by dolo. 4. Yes, a crime may be committed without criminal intent if such is a culpable felony, wherein intent is substituted by negligence or imprudence, and also in a malum prohibitum or if an act is punishable by special law. Art 3, Motive vs Intent 1984 No. 5. A. Distinguish intent from motive. B. When does proof of motive become a crucial consideration in a criminal prosecution? C. What categories of crime do not require criminal intent? Answer. A. Furnished by Office of Justice Palma. A. Motive is the reason which impels one to commit an act for a definite result, intent is the purpose to use a particular means to effect such a result. Intent is an element of a crime, whereas motive is not. B. It becomes a crucial consideration in criminal prosecution when there is doubt as to whether or not the accused committed the crime. C. 1. Felonies committed by means of culpa. 2. Offences punishable as mala prohibita. B. Comments and suggested answer. 1. Motive is the reason which impels one to commit an act for a definite result, while intent is the purpose to use a particular means to effect such a result. Motive is not an element of the crime, while intent is an element of the crime committed by dolo. 2. Proof of motive is a crucial consideration in a criminal prosecution if there is doubt whether the accused committed the crime or not, or whether the evidence on the commission of the crime is circumstantial or inconclusive, or the identity of the accused is in question. 3. Criminal intent is not required in felonies committed by negligence or impudence and in offences which are mala prohibita. Art 3, Motive vs Intent 1978 No. 2a. Is motive indicative of criminal intent? Is lack of motive proof of innocence? When is it necessary to prove motive? Explain your answers. Answer. Motive may be indicative of criminal intent. The fact that the accused were losing heavily in their business operations indicated the motive and therefore the intent to commit arson for the purpose of collecting the insurance on their stock of merchandise. USU. Go Fu Sui, 25 Philosophy 125. However, it is not sufficient to support a conviction if there is no reliable evidence from which it may deduce that the accused was the malefactor. People vs. Marcos, 70 Philosophy 468, People vs. Martinez, 106 Phil 597. Lack of motive is not necessarily proof of innocence because motive is not an essential element of the crime. A crime may be committed just for the sake of committing it due for example to the extreme moral perversion of the accused. People vs. Tainio, 58 Philosophy 255. It is necessary to prove motive when the identity of the person accused of committing the crime is in dispute. People vs. Del Rosario Murray, 105 Philosophy 591, or when there are no eyewitnesses to the crime and where suspicion is likely to fall upon a number of persons. People vs. Mario, CAGR No 371R, July 21, 1949. Art 4. 1996 Number 4. 1. Alexander, an escaped convict, ran amok on board a Superlines bus bound for Manila from Bicol and killed 10 persons. Terrified by the incident, Carol and Benjamin, who are passengers of the bus, jumped out of the window and while lying unconscious after hitting the pavement of the road, were ran over and crushed to death by a fast-moving Desert Fox bus tailing the Superlines bus. Can Alexander be held liable for the death of Carol and Benjamin although he was completely unaware that the two jumped out of the bus? Explain. Answer. 1. Yes, Alexander can be held liable for the death of Carol and Benjamin because a felonious act of running was the proximate cause of the victim's death. The rule is that when a person, by a felonious act, generates in the mind of another a sense of imminent danger, prompting the latter to escape from or avoid such danger and in the process, sustains injuries or dies, the person committing the felonious act is responsible for such injuries or death. U.S. vs. Valdez, 41 Phil, 1497, People vs. Opera, 27 SCRA 1037. Art 4. 1996 Number 9. Vicente hacked Anacleto with a bolo but the latter was able to parry it with his hand, causing upon him a 2-inch wound on his right palm. Vicente was not able to hack Anacleto further because 3 policemen arrived and threatened to shoot Vicente if he did not drop his bolo. Vicente was accordingly charged by the police at the prosecutor's office for attempted homicide. 25 days later, while the preliminary investigation was in progress, Anacleto was rushed to the hospital because of symptoms of tetanus infection on the 2-inch wound inflicted by Vicente. Anacleto died the following day. Can Vicente be eventually charged with homicide for the death of Anacleto? Explain. Answer. Yes, Vicente may be charged of homicide for the death of Anacleto, unless the tetanus infection which developed 25 days later, was brought about by an efficient supervening cause. Vicente's felonious act of causing a 2-inch wound on Anacleto's right palm may still be regarded as the proximate cause of the latter's death because without such wound, no tetanus infection could develop from the victim's right palm. And without such tetanus infection the victim would not have died with it. Art 4. 1997 Number 2. While the crew of a steamer prepared to raise anchor at the Pasig River, A, evidently impatient with the progress of work, began to use abusive language against the men. B, one of the members of the crew, remonstrated saying that they could work best if they were not insulted. A took B's attitude as a display of insubordination and, rising in a rage, moved towards B wielding a big knife and threatening to stab B. At the instant when A was only a few feet from B, the latter, apparently believing himself to be in great and immediate peril, threw himself into the water, disappeared beneath the surface, and drowned. May A be held criminally liable for the death of B? Answer. Yes. A can be held criminally liable for the death of B. Article 4 of the Revised Penal Code provides in part that criminal liability shall be incurred by any person committing a felony although the wrongful act done be different from that which he intended. In U.S. vs. Valdez 41 Philosophy 497. where the victim, who was threatened by the accused with a knife, jumped into the river, but because of the strong current or because he did not know how to swim, he drowned. The Supreme Court affirmed the conviction for homicide of the accused because if a person against whom a criminal assault is directed believes himself to be in danger of death or great bodily harm, and in order to escape jumps into the water, impelled by the instinct of self-preservation, the assailant is responsible for the homicide in case death results by drowning. Art. 4. 1999 No. 2. During the robbery in a dwelling house, one of the culprits happened to fire his gun upward in the ceiling without meaning to kill anyone. The owner of the house, who was hiding thereat, was hit and killed as a result. The defense theorized that the killing was a mere accident and was not perpetrated in connection with, or for purposes of, the robbery. Will you sustain the defense? Why? 4%. No, I will not sustain the defense. The act being felonious and the proximate cause of the victim's death, the offender is liable therefore, although it may not be intended or different from what he intended. The offender shall be prosecuted for the composite crime of robbery with homicide, whether the killing was intentional or accidental, as long as the killing was on occasion of the robbery. Art. 4 2001 No. I. Luis Cruz was deeply hurt when his offer of love was rejected by his girlfriend Marivela one afternoon when he visited her. When he left her house, he walked as if he was sleepwalking, so much so that a teenage snatcher was able to grab his cell phone and flee without being chased by Luis. At the next LRT station, he boarded one of the coaches bound for Baclaran. While seated, he happened to read a newspaper left on the seat and noticed that the headlines were about the sinking of the super ferry while on its way to Cebu. He went over the list of missing passengers who were presumed dead and came across the name of his grandfather, who had raised him from childhood after he was orphaned. He was shocked and his mind went blank for a few minutes, after which he ran amok and, using his bally song, started stabbing at the passengers, who then scampered away, with 3 of them jumping out of the train and landing on the road below. All the 3 passengers died later of their injuries at the hospital. Is Luis liable for the death of the 3 passengers who jumped out of the moving train? State your reasons. 5%. Suggested answer. Yes, Luis is liable for their deaths because he was committing a felony when he started stabbing at the passengers, and such wrongful act was the proximate cause of said passengers jumping out of the train, hence their deaths. Under Article 4, Revised Penal Code, any person committing a felony shall incur criminal liability although the wrongful act done be different from that which he intended. In this case, the death of the 3 passengers was the direct, natural, and logical consequence of Luis' felonious act, which created an immediate sense of danger in the minds of said passengers who tried to avoid or escape from it by jumping out of the train. People vs. ARPA, 27 SCRA 1037, US vs. Valdez, 41 Philosophy 497. Art. 4. 2001 No. 2. Mary Jane had 2 suitors, Felipe and Caesar. She did not openly show her preference, but on 2 occasions, accepted Caesar's invitation to concerts by Regine and Pops. Felipe was a working student and could only ask Mary to see a movie, which was declined. Felipe felt insulted and made plans to get even with Caesar by scaring him off somehow. One day, he entered Caesar's room in their boarding house and placed a rubber snake which appeared to be real in Caesar's backpack. Because Caesar had a weak heart, he suffered a heart attack upon opening his backpack and seeing the snake. Caesar died without regaining consciousness. The police investigation resulted in pinpointing Felipe as the culprit, and he was charged with homicide for Caesar's death. In his defense, Felipe claimed that he did not know about Caesar's weak heart and that he only intended to play a practical joke on Caesar. Is Felipe liable for the death of Caesar, or will his defense prosper? Why? 5%. Suggested answer. Yes, Felipe is liable for the death of Caesar, but he shall be given the benefit of the mitigating circumstance that he did not intend to commit so grave a wrong as that which was committed. Art. 13, PAR 3, RPC. When Felipe intruded into Caesar's room without the latter's consent and took liberty with the latter's backpack where he placed the rubber snake, Felipe was already committing a felony, and any act done by him while committing a felony is no less wrongful, considering that they were part of plans to get even with Caesar. Felipe's claim that he intended only to play a practical joke on Caesar does not persuade, considering that they are not friends but in fact rivals in courting Mary Jane. This case is parallel to the case of People vs. Puga, et al. Alternative answer. No, Felipe is not liable because the act of frightening another is not a crime. What he did may be wrong, but not all wrongs amount to a crime. Because the act which caused the death of Caesar is not a crime, no criminal liability may arise therefrom. Art 4. 2003 No v. The conduct of wife A aroused the ire of her husband B. Incensed with anger almost beyond his control, B could not help but inflict physical injuries on A moments after B started hitting A with his fists. A suddenly complained of severe chest pains. B, realizing that A was indeed in serious trouble, immediately brought her to the hospital. Despite efforts to alleviate A's pains, she died of heart attack. It turned out that she had been suffering from a lingering heart ailment. What crime, if any, could B be held guilty of? 8%. Suggested answer. B could be held liable for parricide because his act of hitting his wife with fist blows and therewith inflicting physical injuries on her, is felonious. A person committing a felonious act incurs criminal liability although the wrongful consequence is different from what he intended. Art 4, PAR 1, Revised Penal Code. Although A died of heart attack, the said attack was generated by B's felonious act of hitting her with his fists. Such felonious act was the immediate cause of the heart attack, having materially contributed to and hastened A's death. Even though B may have acted without intent to kill his wife, lack of such intent is of no moment when the victim dies. However, B may be given the mitigating circumstance of having acted without intention to commit so grave a wrong as that committed. Art 13, PAR 3, Revised Penal Code. Art 4. 1976 No. 7a. X and Y ran amok on board a train and killed 10 persons. 4 persons out of fear jumped out of the train while the same was running and died. Are X and Y liable for the deaths of the 4 persons who jumped out of the train? Reason. Answer. X and Y are also liable for the deaths of the 4 persons who jumped out of the train. By running amok on board the train and killing 10 persons, the acts committed by X and Y are felonious and they are responsible for the direct, natural, and logical consequences thereof. Art 4, PAR 1, RPC. These acts of X and Y created fear in the minds of those 4 persons which caused them to jump out of the running train which resulted in their deaths. The rule is that if a man creates in another man's mind an immediate sense of danger which cause such person to try to escape and in so doing injures himself, the person who creates such state of mind is responsible for the injuries which result. People vs. Tolling, 62 SCRA 17, People vs. ARPA, 27 SCRA 1037, US vs. Valdez, 41 Phil 1497. Art 4. 1994 Number 5. Bay eloped with Scott. Whereupon, Bay's father, Robin, and brother, Rustam, went to Scott's house. Upon reaching the house, Rustam inquired from Scott about his sister's whereabouts, while Robin shouted and threatened to kill Scott. The latter then went downstairs but Rustam held his, Scott's, waist. Meanwhile Olive, the elder sister of Scott, carrying her 2-month-old child, approached Rustam and Scott to pacify them. Olive attempted to remove Rustam's hand from Scott's waist. But Rustam pulled Olive's hand causing her to fall over her baby. The baby then died moments later. Is Rustam criminally liable for the death of the child? Answer. Yes, Rustam is criminally liable for the death of the child because his felonious act was the proximate cause of such death. It was Rustam's act of pulling Olive's hand which caused the latter to fall on her baby, Had it not been for said act of Rustam, which is undoubtedly felonious, at least slight coercion, there was no cause for Olive to fall over her baby. In short, Rustam's felonious act is the cause of the evil caused. Any person performing a felonious act is criminally liable for the direct, natural, and logical consequence thereof, although different from what he intended. Art 4, PAR 1, RFC, People vs. Puga, et al., GR number 74324, November 18, 1988. Art 4. 1975 No. 4. The accused ran amok aboard a moving train and killed 8 persons. Terrified by the happening, 4 passengers jumped out of the train and died as a result of their fall. Can the accused be held liable for the death of the 4 although he did not even know that they jumped? Why? Answer. The accused can be held liable because by running amok aboard the train and killing 8 persons, he committed acts which are felonious. The death of the 4 passengers who jumped out of the train because they were terrified by the happening is the direct, natural, and logical consequence of the running amok of the accused. Art 4, PAR 1, Revised Penal Code, People v. ARPA, 27 SCRA 1037. Art 4, Impossible Crimes 1976 No. 9a. X, a domestic servant of Y, has been nurturing a grudge against him for long. One day, while Y was seated on his favorite rocking chair, X suddenly fired a volley of shots towards Y. It turned out, however, that Y has been dead from a severe stroke an hour ago. For what crime can X be held liable? Reasons. Answer. X is liable for an impossible crime of murder. The reason is the inherent impossibility of killing Y since he has been dead due to a severe stroke 1 hour before X shot him. The acts of execution would have been a crime against persons were it not for the inherent impossibility of its accomplishment. Art 4, PAR 12, RPC. Subjectively, X is a criminal although objectively, no crime is committed. X cannot be liable for trespass to dwelling because being a domestic servant, his entrance to the house of Y cannot be against the will of the latter. Art 4, Impossible Crimes 1993 No. 12. Explain and illustrate the following: 1. Aberratio ictus, 2. Impossible crime, and 3. Subornation of perjury. Answer. 2. Impossible crime, killing a dead person. Art 4, Impossible Crimes 1994 No. 10. J.P., Aries, and Randall planned to kill Elsa, a resident of Barangay Pula, Laurel, Batangas. They asked the assistance of Ella, who is familiar with the place. On April 3, 1992, at about 10 o'clock in the evening, J.P., Aries, and Randall, all armed with automatic weapons, went to Barangay Pula. Ella, being the guide, directed her companions to the room in the house of Elsa. Whereupon, J.P., Aries and Randall fired their guns at her room. Fortunately, Elsa was not around as she attended a prayer meeting that evening in another barangay in Laurel. J.P. et al. Were charged and convicted of attempted murder by the Regional Trial Court at Tanayan, Batangas. On appeal to the Court of Appeals, all the accused ascribed to the trial court the sole error of finding them guilty of attempted murder. If you were the ponent, how will you decide the appeal? Answer: if I were the ponent, I will set aside the judgment convicting the accused of attempted murder and instead find them guilty of impossible crime under Art. 4, PAR 2, RPC, in relation to Art. 59, RPC. Liability for impossible crime arises not only when the impossibility is legal, but likewise when it is factual or physical impossibility, as in the case at Bar. Elsa's absence from the house is a physical impossibility which renders the crime intended inherently incapable of accomplishment. To convict the accused of attempted murder would make Art. 4. PAR 2 practically useless, as all circumstances which prevented the consummation of the offence will be treated as an incident independent of the actor's will, which is an element of attempted or frustrated felony, Untold VSCA, 215 SCRA 52. Art 4, Impossible Crimes 1998 No. 14. Buddy always resented his classmate, June. One day, Buddy planned to kill June by mixing poison in his lunch. Not knowing where he can get poison, he approached another classmate, Jerry, to whom he disclosed his evil plan. Because he himself harbored resentment towards June, Jerry gave Buddy a poison, which Buddy placed on Jun's food. However, June did not die because, unknown to both Buddy and Jerry, the poison was actually powdered milk. 1. What crime or crimes, if any, did Jerry and Buddy commit? 3%. 2. Suppose that, because of his severe allergy to powdered milk, June had to be hospitalized for 10 days for ingesting it. Would your answer to the first question be the same? 2%. Answer. 1. Jerry and Buddy are liable for the so-called impossible crime because, with intent to kill, they tried to poison June and thus perpetrate murder, a crime against persons. June was not poisoned only because the would-be killers were unaware that what they mixed with the food of June was powdered milk, not poison. In short, the act done with criminal intent by Jerry and Buddy would have constituted a crime against persons were it not for the inherent inefficacy of the means employed. Criminal liability is incurred by them although no crime resulted, because their act of trying to poison June is criminal. 2. No, the answer would not be the same as above. Jerry and Buddy would be liable instead for less serious physical injuries for causing the hospitalization and medical attendance for 10 days to June. Their act of mixing with the food eaten by June the matter which required such medical attendance, committed with criminal intent, renders them liable for the resulting injury. Art 4, Impossible Crimes 2000 No. 17. A. What is an impossible crime? 2%. B. Is an impossible crime really a crime? 2%. C. A, B, C and D, all armed with armalite, proceeded to the house of XY, a neighbor of X who happened to be passing by, pointed to the 4 culprits the room that X occupied. The 4 culprits peppered the room with bullets. Unsatisfied, A even threw a hand grenade that totally destroyed X's room. However, unknown to the 4 culprits, X was not inside the room and nobody was hit or injured during the incident. Are A, B, C and D liable for any crime? Explain. 3%. D. Carla, 4 years old, was kidnapped by Enrique, the tricycle driver paid by her parents to bring and fetch her to and from school. Enrique wrote a ransom note demanding P500,000.00 from Carla's parents in exchange for Carla's freedom. Enrique sent the ransom note by mail. However, before the ransom note was received by Carla's parents, Enrique's hideout was discovered by the police. Carla was rescued while Enrique was arrested and incarcerated. Considering that the ransom note was not received by Carla's parents, the investigating prosecutor merely filed a case of impossible crime to commit kidnapping against Enrique. Is the prosecutor correct? Why? 3%. Suggested answer. A. An impossible crime is an act which would be an offense against person or property, were if not for the inherent impossibility of its accomplishment or on account of the employment of inadequate or ineffectual means, Art 4, PAR 2, RPC. B. No, an impossible crime is not really a crime. It is only so called because the act gives rise to criminal liability. But actually, no felony is committed. The accused is to be punished for his criminal tendency or propensity although no crime was committed. C. Yes. A, B, C and D are liable for destructive arson because of the destruction of the room of X with the use of an explosive, the hand grenade. Liability for an impossible crime is to be imposed only if the act committed would not constitute any other crime under the revised Penal Code. Although the facts involved are parallel to the case of Untold vs. Court of Appeals, 215 SCRA 52, where it was ruled that the liability of the offender was for an impossible crime, no hand grenade was used in said case, which constitutes a more serious crime though different from what was intended. D. No, the prosecutor is not correct in filing a case for impossible crime to commit kidnapping against Enrique. Impossible crimes are limited only to acts which when performed would be a crime against persons or property. As kidnapping is a crime against personal security and not against persons or property, Enrique could not have incurred an impossible crime to commit kidnapping. There is thus no impossible crime of kidnapping. Art 6, Desist Ans 2003 No 3. A and B, both store janitors, planned to kill their employer C at midnight and take the money kept in the cash register. A and B together drew the sketch of the store, where they knew C would be sleeping, and planned the sequence of their attack. Shortly before midnight, A and B were ready to carry out the plan. When A was about to lift C's mosquito net to thrust his dagger, a police car with sirens blaring passed by. Scared, B ran out of the store and fled, while A went on to stab C to death, put the money in the bag, and ran outside to look for B. The latter was nowhere in sight. Unknown to him, B had already left the place. What was the participation and corresponding criminal liability of each, if any? Reasons. 8%. Suggested answer. There was an expressed conspiracy between A and B to kill C and take the latter's money. The planned killing and taking of the money appears to be intimately related as component crimes, hence a special complex crime of robbery with homicide. The conspiracy being expressed, not just implied, A and B are bound as co-conspirators after they have planned and agreed on the sequence of their attack even before they committed the crime. Therefore, the principle in law that when there is a conspiracy, the act of one is the act of all, already governs them. In fact, A and B were already in the store to carry out their criminal plan. That B ran out of the store and fled upon hearing the sirens of the police car, is not spontaneous desistance but flight to evade apprehension. It would be different if B then tried to stop A from continuing with the commission of the crime. He did not. So the act of A in pursuing the commission of the crime which both he and B designed, planned, and commenced to commit, would also be the act of B because of their expressed conspiracy. Both are liable for the composite crime of robbery with homicide. Alternative answer. A shall incur full criminal liability for the crime of robbery with homicide, but B shall not incur criminal liability because he desisted. B's spontaneous desistance, made before all acts of execution are performed, is exculpatory. Conspiracy to rob and kill is not per se punishable. The desistance need not be actuated by remorse or good motive. It is enough that the discontinuance comes from the person who has begun the commission of the crime but before all acts of execution are performed. A person who has began the commission of a crime but desisted, is absolved from criminal liability as a reward to one, who having set foot on the verge of crime, heeds the call of his conscience and returns to the path of righteousness. Art 6, Stage of Execution 1976 No 3b. X, a physician, wanted to kill his wife. He gave her food with poison. After eating the food, the wife became unconscious. Bothered by his own conscience, X gave her medicine to counteract the effects of the poison and the wife was saved. X is prosecuted for frustrated parricide. Is he guilty of the charge? Reason. Answer. X is not liable for frustrated parricide. Although he has already performed all the acts of execution to kill his wife, because she ate the food with poison which he gave her, she however did not die due to the medicine which he administered, after she became unconscious and because his conscience bothered him. The death of the wife, therefore, did not result due to a cause which depended upon the voluntary will of X. In a frustrated felony, the offender performs all the acts of execution which would produce the felony as a consequence but which, nevertheless, do not produce it by reason of causes independent of the will of the perpetrator. Art 6, 2nd PAR, RPC. Art 6, Stage of Execution, Desistance 1985 No. 5. Intending to kill his estranged wife Myrna, Anthony mixed poison in her coffee which would have normally killed her. After drinking the coffee, Myrna felt nauseated and vomited. Appalled by the suffering and helplessness of his wife, Anthony took pity on her and gave her an antidote. Myrna recovered completely after 10 days. Discuss with reasons the criminal liability, if any, of Anthony. May he invoke desistance in his favor? Answer. Anthony will not be liable for frustrated parricide. Although the wife, Myrna, had drank the poisoned coffee, and all the acts of execution to kill her were already committed, she did not however die due to the antidote administered by Anthony. The crime was therefore not produced due to the voluntary act of Anthony. In a frustrated felony, the acts of execution have been performed which would produce the felony as a consequence but nevertheless do not produce it by causes independent of the will of the offender. So, if the perpetrator himself prevented the consummation of the crime, it is not frustrated. In that sense, when Anthony gave the antidote to his wife, when he saw her suffering after drinking the poisoned coffee, such act may be considered desistance in killing her, although as a rule, desistance refers to acts of execution. The facts of the problem merely state that after the administration of the antidote, the wife recovered after 10 days. It may be presumed that she was ill during that period. Since there is no mention of medical attendance nor incapacity from work, the offence will be slight physical injuries under PAR 2 of Art. 266 of the Revised Penal Code. Art 6, Stage of Execution, Homicide 1979 No. 15. X and Y had a heated altercation and then exchanged blows. X pulled out a knife and stabbed Y in the abdomen. Y ran away but before he could reach his house was struck by lightning and died. The fiscal filed homicide against X. Decide. Answer. X is not liable for homicide but for the crime constituting the stabbing of Y in the abdomen. Since the injury was mortal, the liability of X is for frustrated homicide. The death of the victim was caused by the lightning which struck him. Although a felony was committed by X, such was not the direct and proximate cause of the death of Y. The lightning was an efficient intervening cause. People vs. Rockwell, 39 Michigan 503. The rationale of the rule is that the cause of the cause is the cause of the evil caused. People vs. Ural, 56 SCRA 138. Art 6, Stage of Execution, when punishable 1977 No. IB. Acting under the impulse of hunger, Jose tried to steal the 2 pesos, 2 bill in the breast pocket of a stranger. But before he could get the money, he was seen and eventually apprehended by a policeman. Later on, Jose was charged of the light offense of attempted theft for P2.00. Was Jose correctly charged considering that light offenses are punishable only when consummated? State 4 reasons. Answer. Jose was correctly charged for a light felony of attempted theft of P2.00 because theft is a crime against property and is punishable even though it is not consummated. Art 7, RPC. Art 7, Light Felonies 1988 No. 2. C. When are light felonies punishable and who are liable in light felonies? Answer. C. Light felonies, according to Article 7 of the Revised Penal Code, are punishable only when they have been consummated, with the exception of those committed against persons or property. Article 16 of the Revised Penal Code provides that the following are criminally liable for light felonies. 1. Principals. 2. Accomplices. Art 8, Conspiracy 1976 No. IB. X, Y, and Z fired their guns almost simultaneously at the principal victim, resulting in his death and his driver. Is there conspiracy among the accused in the commission of the crime? Reason. Answer. There is conspiracy among the accused X, Y, and Z. The fact that the 3 fired almost simultaneously at the principal victim shows that they have acted in concert pursuant to a common criminal objective. Define conspiracy. There is, therefore, a unity of action and intention, People v. San Luis, 86 Phil 485, to establish conspiracy. Proof of previous agreement is not necessary. It is enough that if at the time of the commission of the crime, all the accused have the same purpose and were united in its execution. People v. Benasing, et al., 63 OG 5208. Art 8, Conspiracy 1977 No. 2a. When L, a notorious robber in the neighborhood, was apprehended by an irate crowd, and while L was being held from behind by M, N stoned L, hitting him on the head. O hit him on the knee with a piece of wood, and P stabbed him on the chest, which stabbing was the cause of the death of L. Said acts were committed almost simultaneously, to the surprise of M. What criminal liability, if any, was incurred by M, N, O and P? Reason fully. Answer. M has no criminal liability for what N, O and P did because their acts surprised him and, hence, M was not aware of what they would have done. The criminal liability of N, O and P is individual and not collective. The facts of the problem show that these offenders did not act concertedly in pursuance of a common purpose. They had no knowledge of each other's criminal intent. There is no unity of action and intention to hold that the act of one is the act of all. Mere simultaneousness of acts does not of itself indicate concurrence of will, nor the unity of action and purpose, which are the basis of the opportunity of two or more persons. People vs. Ibanez, 77. Philosophy 664. Art 8, Conspiracy 1980 No. 4. H made a bet of P10 with I in a game of Beto. H won, but I refused to pay the amount. A dispute arose between them, which culminated in a fist fight. J, the father of H, and K, the brother of H, intervened. When the fight began, H held the hand of I, J seized the front part of I's shirt, and while they were dealing blows on one another, K came with a balisong and stabbed I, inflicting upon him a mortal wound. H, J, and K were charged with homicide. Is it proper to hold all the accused responsible for the fatal wound inflicted upon the victim by K? Answer. It is not proper to hold H and J liable for the fatal wound inflicted upon the victim by K because of the absence of conspiracy. He and J are not co-principals of K in the killing of the victim. The liability of H, J, and K is not collective but individual. They have not acted conceitedly for the realization of a common criminal objective. H and J, who dealt blows on the victim without causing any physical injury, could be liable for ill treatment. Art 266, PAR 3, RPC. Art 8, Conspiracy 1988 No. 11. B. At a pre-wedding celebration where plenty of people were milling and walking about or standing close together, a mad killer shot up the wedding party. The three appellants were convicted by the owner court as co-conspirators of the killer because they were allegedly with him before, during, and after the shooting. It was proven conclusively that the appellant were friends of the killer, that they went together with the killer to the celebration, and that they left at the same time with the killer, after the shooting. However, the appellants had no guns and passively witnessed the shooting, without intervening in the killing in any way nor shielding killer. Is there conspiracy among them? Why? Answer. B. There is no conspiracy among them because, as the problem has stated, they passively witnessed the shooting. No overt act was committed, therefore the element that the conspiracy must be proved as the essence of the crime itself is N9T present. Art 8, Conspiracy 1990 No. 1. Aki and Ben, while walking together, met Kaloui. There was an altercation between Ben and Kaloui so that Ben chased and stabbed Kaloui with a knife, hitting his right arm, thereby causing slight physical injury. Ben desisted from further assaulting Kaloui, but Aki lunged at Kaloui and felled him, this time with a bolo which mortally wounded Kaloui. Thus, he died. A. What is the criminal liability of Aki? How about that of Ben? Explain your answers. B. Assuming conspiracy is established, will your answer in problem A be the same? Explain your answer. Answer. A. Aki is liable for homicide because, while it is clear that he intentionally caused the death of Kaloui, none of the circumstances attendant to murder are present. Intent to kill is clear, as Aki lunged at Kaloui, after the latter was inflicted a wound at the right arm, and gave him a mortal wound. Ben is guilty only of slight physical injuries, as it is evident from the wound he inflicted upon Kaloui that he did not intend to kill the latter. Also, there was no other act on the part of Ben to show such intent. b. No, there being no conspiracy, each will be liable for their own individual act. This time both will be liable for homicide because in conspiracy, the act of one is the act of all. People v. Damiso, G.RNOSL 30116-7, November 20, 1978. Art 8, Conspiracy 1991 Number 9. During a fiesta, Simeon Marco, brandishing a knife, asked Constancio whether he was the one who slapped his, Simeon's, son the year previous. Vicente, father of Constancio, shouted at Constancio and his other son, Bienvenido, telling them to run away. When Bienvenido passed by Rafael Marco, brother of Simeon, Rafael stabbed him. Bienvenido parried the blow but fell down, his feet entangled with some vines. While Bienvenido was lying on the ground, Rafael continued to stab him, inflicting slight injuries on the shoulder of Bienvenido, after which Rafael stood up. At that moment, Dulcisimo Beltran, no relation to the Marco brothers, came out of nowhere and, together with Simeon, stabbed Bienvenido. Both of them inflicted fatal wounds resulting in the death of the victim. A. Discuss the criminal liability of Dulcisimo, Simeon, and Rafael. B. Supposing Dulcisimo is a convict out on parole, will the aggravating circumstances of quasi-recidivism be appreciated against him? Answer. A. Simeon and Dulcisimo will be liable for the death of Bienvenido as the fatal injuries sustained by the victim were inflicted by the two. Rafael is not liable for slight physical injuries as conspiracy was not present, and there was no apparent intent to kill when he inflicted the slight physical injuries on the arm of the victim. Alternative answer. Dulcisimo, Simeon, and Rafael will all be liable under the principle of conspiracy, where the act of one becomes the act of all. Art 8, Conspiracy 1992 Number 3. As Sergio, Yoyong, Zoolo, and Warlato engaged in a drinking spree at Heartthrob Disco, Special Police Officer 3, SPO 3, Manolo Yabang suddenly approached them, aimed his revolver at Sergio, whom he recognized as a wanted killer, and fatally shot the latter. Whereupon, Yoyong, Zoolo and Warlato ganged up on Yabang. Warlalo, using his own pistol, shot and wounded Yabang. A. What are the criminal liabilities of Yoyong, Zoolo, and Warlato for the injury to Yabang? Was there conspiracy and treachery? Explain. B. In turn, is Yabang criminally liable for the death of Sergio? Suggested answer. A. If they have to be criminally liable at all, each will be responsible for their individual acts, as there appears to be no conspiracy, as the acts of the three were spontaneous and a reflex response to Yabang's shooting of Sergio. There was no concerted act that will lead to a common purpose. Art 8, Conspiracy 1993 Number 6. As a result of a misunderstanding during a meeting, Joe was mauled by Nestor, Jolin, Reedon, and Arthur. He ran towards his house, but the four chased and caught him. Thereafter, they tied Joe's hands at his back and attacked him. Nestor used a knife, Jolin, a shovel, Arthur, his fists, and Reedon, a piece of wood. After killing Joe, Reedon ordered the digging of a grave to bury Joe's lifeless body. Thereafter, the four left together, convicted for the killing of Joe. Arthur now claims that his conviction is erroneous, as it was not he who inflicted the fatal blow. 1. Would you sustain his claim? Why? 2. What was the crime committed by the four assailants? Discuss with reasons. Answer. 1. No. Arthur's claim is without merit. The offenders acted in conspiracy in killing the victim and hence, liable collectively. The act of one is the act of all. The existence of a conspiracy among the offenders can be clearly deduced or inferred from the manner they committed the killing, demonstrating a common criminal purpose and intent. There being a conspiracy, the individual acts of each participant is not considered because their liability is collective. 2. The crime committed is murder, qualified by treachery. Art 8, Conspiracy 1994 Number 9. At about 9:30 in the evening, while Dino and Rafi were walking along Padre Fares Street, Manila, Johnny hit them with a rock, injuring Dino at the back. Rafi approached Dino, but suddenly, Bobby, Steve, Danny and Nonoe surrounded the duo. Then Bobby stabbed Dino. Steve, Danny, Nonoe and Johnny kept on hitting Dino and Rafi with rocks. As a result, Dino died. Bobby, Steve, Danny, Nonoe and Johnny were charged with homicide. 1. Is there conspiracy in this case? 2. Can the court appreciate the aggravating circumstances of nighttime and band? Answer. 1. Yes, there is conspiracy among the offenders, as manifested by their concerted actions against the victims, demonstrating a common felonious purpose of assaulting the victims. The existence of the conspiracy can be inferred or deduced from the manner the offenders acted in commonly attacking Dino and Rafi with rocks, thereby demonstrating a unity of criminal design to inflict harm on their victims. Art 8, Conspiracy 1996 No. 2. 2. Jose, Domingo, Manolo, and Fernando, armed with bolos, at about 1 o'clock in the morning, robbed a house at a desolate place where Danilo, his wife, and 3 daughters were living. While the 4 were in the process of ransacking Danilo's house, Fernando, noticing that one of Danilo's daughters was trying to get away, ran after her and finally caught up with her in a thicket somewhat distant from the house. Fernando, before bringing back the daughter to the house, raped her first. Thereafter, the 4 carted away the belongings of Danilo and his family. A. What crime did Jose, Domingo, Manolo, and Fernando commit? Explain. B. Suppose, after the robbery, the 4 took turns in raping the 3 daughters of Danilo inside the latter's house, but before they left, they killed the whole family to prevent identification. What crime did the 4 commit? Explain. C. Under the facts of the case, what aggravating circumstances may be appreciated against the 4? Explain. Answer. 2. A. Jose, Domingo, and Manolo committed robbery, while Fernando committed complex crime of robbery with rape. Conspiracy can be inferred from the manner the offenders committed the robbery, but the rape was committed by Fernando at a place distant from the house where the robbery was committed, not in the presence of the other conspirators. Hence, Fernando alone should answer for the rape, rendering him liable for the special complex crime. People vs. Cancheria et al., GR 108490, June 22, 1995. B. The crime would be robbery with homicide. Implied, there is still conspiracy. Art 8, Conspiracy 1997 No. 4. A had a grudge against F, deciding to kill F. A and his friends, B, C, and D, armed themselves with knives and proceeded to the house of F, taking a taxicab for the purpose. About 20 meters from their destination, the group alighted and after instructing E, the driver, to wait, traveled on foot to the house of F. B positioned himself at a distance as the group's lookout. C and D stood guard outside the house. Before A could enter the house, D left the scene without the knowledge of the others. A stealthily entered the house and stabbed F. F ran to the street but was blocked by C, forcing him to flee towards another direction. Immediately after A had stabbed F, A also stabbed G, who was visiting F. Thereafter, A exited from the house and, together with B and C, returned to the waiting taxicab and motored away. G died. F survived. Who are liable for the death of G and the physical injuries of F? Answer. A alone should be held liable for the death of G. The object of the conspiracy of A, B, C, and D was to kill F only. Since B, C, and D did not know of the stabbing of G by A, they cannot be held criminally. Therefore, E, the driver, cannot be also held liable for the death of G since the former was completely unaware of said killing. For the physical injuries of F, A, B and C should be held liable therefore. Even if it was only A who actually stabbed and caused physical injuries to G, B, and C are nonetheless liable for conspiring with A and for contributing positive acts which led to the realization of a common criminal intent. B positioned himself as a lookout, while C blocked F's escape. D, however, although part of the conspiracy, cannot be held liable because he left the scene before A could enter the house where the stabbing occurred. Although he was earlier part of the conspiracy, he did not personally participate in the execution of the crime by acts which directly tended toward the same end. People vs. Tomorrow, et al. 44 Philosophy 38. In the same breath, E, the driver, cannot be also held liable for the infliction of physical injuries upon F because there is no showing that he had knowledge of the plan to kill F. Art. 8, Conspiracy 1998 No 16. Juan and Arturo devised a plan to murder Joel. In a narrow alley near Joel's house, Juan will hide behind the big lamppost and shoot Joel when the latter passes through on his way to work. Arturo will come from the other end of the alley and simultaneously shoot Joel from behind. On the appointed day, Arturo was apprehended by the authorities before reaching the alley. When Juan shot Joel as planned, he was unaware that Arturo was arrested earlier. Discuss the criminal liability of Arturo, if any. 5%. Answer. Arturo, being one of the two who devised the plan to murder Joel, thereby becomes a co-principal by direct conspiracy. What is needed only is an overt act and both will incur criminal liability. Arturo's liability as a conspirator arose from his participation in jointly devising the criminal plan with Juan, to kill Jose. And it was pursuant to that conspiracy that Juan killed Joel. The conspiracy here is actual, not by inference only. The overt act was done pursuant to that conspiracy whereof Arturo is co-conspirator. There being a conspiracy, the act of one is the act of all. Arturo, therefore, should be liable as a co-conspirator, but the penalty on him may be that of an accomplice only. People vs. Naira, 96 SCRA 1, People Us. Medrano, 114 SCRA 335, because he was not able to actually participate in the shooting of Joel, having been apprehended before reaching the place where the crime was committed. Alternative answer. Arturo is not liable because he was not able to participate in the killing of Joel. Conspiracy itself is not punishable unless expressly provided by law, and this is not true in the case of murder. A co-conspirator must perform an overt act pursuant to the conspiracy. Art. 8, Conspiracy 2003 No 3. A and B, both store janitors, planned to kill their employer C at midnight and take the money kept in the cash register. A and B together drew the sketch of the store, where they knew C would be sleeping, and planned the sequence of their attack. Shortly before midnight, A and B were ready to carry out the plan. When A was about to lift C's mosquito net to thrust his dagger, a police car with sirens blaring passed by. Scared, B ran out of the store and fled, while A went on to stab C to death, put the money in the bag, and ran outside to look for B. The latter was nowhere in sight. Unknown to him, B had already left the place. What was the participation and corresponding criminal liability of each, if any? Reasons. 8%. Suggested answer. There was an expressed conspiracy between A and B to kill C and take the latter's money. The planned killing and taking of the money appears to be intimately related as component crimes, hence a special complex crime of robbery with homicide. The conspiracy being expressed, not just implied, A and B are bound as co-conspirators after they have planned and agreed on the sequence of their attack even before they committed the crime. Therefore, the principle in law that when there is a conspiracy, the act of one is the act of all, already governs them. In fact, A and B were already in the store to carry out their criminal plan. That B ran out of the store and fled upon hearing the sirens of the police car, is not spontaneous desistance but flight to evade apprehension. It would be different if B then tried to stop A from continuing with the commission of the crime. He did not. So the act of A in pursuing the commission of the crime which both he and B designed, planned, and commenced to commit, would also be the act of B because of their expressed conspiracy. Both are liable for the composite crime of robbery with homicide. Alternative answer. A shall incur full criminal liability for the crime of robbery with homicide, but B shall not incur criminal liability because he desisted. B's spontaneous desistance, made before all acts of execution are performed, is exculpatory. Conspiracy to rob and kill is not per se punishable. The desistance need not be actuated by remorse or good motive. It is enough that the discontinuance comes from the person who has begun the commission of the crime but before all acts of execution are performed. A person who has began the commission of a crime but desisted, is absolved from criminal liability as a reward to one, who having set foot on the verge of crime, heeds the call of his conscience and returns to the path of righteousness. Art 8, Conspiracy, Extent of Criminal Liability 1986 No. 3. Mahigpit is the general manager of Blue Chips Co. He fired Alabugha, Bulagsak, Baijiaso and Maybaijiao for gross incompetence the following day. The four dismissed employees happened to meet by chance at a restaurant, a block from the residence of Mahigpit. Then and there, the four hatched a plan to beat up Mahigpit so he would not be so harsh to his personnel in the future. Immediately, thereafter, the four proceeded to Mahigpit's house. After being allowed to enter, a heated discussion ensued. Mahigpit ordered the four to leave his house immediately. Thereupon, Alabugha and Bulagsak started raining blows on Mahigpit while Baijiaso held him by his arms. Maybaijiao proceeded to the second floor of the residence where he chanced upon Katu Long, the housemaid of Mahigpit. Katu Long saw what was going on and rushed to a window shouting for help. Maybaijiao hit Katu Long on the head with a metal flower vase. The four then fled from the house. When the police arrived at the scene, they found Mahigpit dead on the floor of the sala and Katu Long, also dead, near the window on the second floor. Alabugha, Bulagsak, Baijiaso and Maybaijiao were charged with murder on 2 counts. The fiscal stated that the 2 offences were characterized by conspiracy and, therefore, all the accused should be equally guilty for all the consequences of their criminal acts. Is the fiscal correct? Explain. Answer. Regarding the death of Mahigpit, only Alabugha, Bulagsak and Baijiaso are criminally liable. They acted pursuant to a conspiracy to beat the deceased whose death is the direct, natural, and logical consequence of the crime agreed upon to be committed. Maybaijiao is not liable for the death of Mahigpit because, although he participated in the plan to beat him, he did not personally perform any overt act as his contribution to realize the common criminal objective. Regarding the death of the housemaid, only Maybaijiao will be liable. The others are not criminally liable as the death of the housemaid is not covered in the conspiracy nor is it a necessary consequence thereof. Art 8, Conspiracy, Implied Conspiracy 2003 No. 4. A. State the concept of implied conspiracy and give its legal effects. 4%. Suggested answer. A. An implied conspiracy is one which is only inferred or deduced from the manner the participants in the commission of crime carried out its execution. Where the offenders acted in concert in the commission of the crime, meaning that their acts are coordinated or synchronized in a way indicative that they are pursuing a common criminal objective, they shall be deemed to be acting in conspiracy and their criminal liability shall be collective, not individual. The legal effects of an implied conspiracy are: 1. Not all those who are present at the scene of the crime will be considered conspirators. 2. Only those who participated by criminal acts in the commission of the crime will be considered as co-conspirators, and 3. Mere acquiescence to or approval of the commission of the crime, without any act of criminal participation, shall not render one criminally liable as co-conspirator. Art 8, Conspiracy, Implied Conspiracy 1998 No. 8. 1. What is the doctrine of implied conspiracy? 3% answer. 1. The doctrine of implied conspiracy holds 2 or more persons participating in the commission of a crime collectively responsible and liable as co-conspirators although absent any agreement to that effect, when they act in concert. Demonstrating unity of criminal intent and a common purpose or objective. The existence of a conspiracy shall be inferred or deduced from their criminal participation in pursuing the crime and thus the act of one shall be deemed the act of all. Art 8, Conspiracy, Robbery with Serious Physical Injuries 1992 No. 7. Efren, Greggy and Ilario, wearing fatigues and carrying unlicensed firearms, barged into the residence of Arnulfo Dilat at Scout Las Cano St. Before making their entrance, they gave instructions to their companion Sakai to stand watch outside. Once inside, they announced that they were members of the Philippine National Police, PNP, on an official mission. Inside the master bedroom, they demanded from Luningning, the wife of Arnulfo, cash and jewelries. After receiving the jewelries but before the money could be handed to them, they heard their companion Sakai shouting, "Police! Police!" Panic-stricken, Efren shot Arnulfo, who was seriously injured. Greggy and Ilario picked up the jewelry box whose contents spilled all over the floor as they rushed out. Before they could make good their escape, however, the police blocked their way, one of them clutching Sakai by the collar. They were forthwith brought to the police headquarters nearby. Discuss the individual and collective criminal liabilities of Efren, Greggy, Ilario and Sakai. Suggested answer. There appears to be conspiracy amongst the four offenders, in which case the act of one becomes the act of all. Ergo, they are all liable for the consequent crime, which is robbery under Art. 299, special complex crime of robbery with serious physical injuries, committed in an inhabited house, by pretending to be persons in authority. There is no band as only 3 are armed. Sakai, who seems to have participated only as lookout, still will be liable as principal because of the conspiracy. Even if there is none, he is criminally liable as a principal by indispensable cooperation. The crime is definitely consummated as offenders have complete disposal of the subject matter of the offense. Justifying and exempting circumstances. Art 11, Justifying Circumstances, Defense of Relative 1989 No. 5. Boy Bala was a notorious gang leader who had previously killed a policeman. The chief of police ordered his vice squad headed by Captain Anacito, to arrest Boy Bala and should he resist arrest, to shoot and kill him. Acting upon an informer's tip, Anacito and two of his trusted men went to the Corinthian nightclub where they saw Boy Bala dancing with a hostess. Without any warning, Anacito shot Boy Bala, who slumped on the dance floor. As Anacito aimed another shot at Boy Bala, the brother of the latter, Pedro, who was seated at a table nearby, got hold of a table knife and stabbed Anacito, killing him instantly. The chief of police filed a homicide case against Pedro for the death of Anacito. On the other hand, Pedro filed a complaint for murder against the chief of police for the death of Boy Bala, alleging that the issuance of the shoot-to-kill order was illegal and the chief of police was liable as a principal by inducement. How tenable are the respective claims of the chief of police and Pedro? Explain. Answer. The charge for murder against the chief of police for the death of Boy Bala is not tenable. Although, the chief of police is the superior on Captain Anacito who shot Boy Bala in cold blood, he cannot be held accountable for the act of Anacito. His order was specific, to arrest Boy Bala and should he resist arrest, to shoot and kill him. Anacito did not act in compliance with this order. He shot Boy Bala without warning, without even attempting to make an arrest. Consequently, it could not be said that the killing of Bala by Anacito was induced by the chief of police so as to make the latter criminally liable as a co-principal by inducement. The liability for the death of Bala is individual and not collective. On the other hand, the charge of homicide against Pedro for the stabbing of Anacito is likewise not tenable. Pedro acted in legitimate defense of relative, he being the brother of Boy Bala. All the requisites of this justifying circumstance are present. Thus, 1. There was unlawful aggression. At the time that Pedro stabbed Anacito, the latter had already shot at Boy Bala and was in the act of shooting him for the second time. The aggression is unlawful although Anacito is a police officer and Boy Bala is notorious gangster. By shooting Boy Bala without warning instead of attempting to arrest him first, Anacito became an unlawful aggressor. 2. There was reasonable necessity of the means employed by Pedro to prevent or repel unlawful aggression. The use of a knife against a gun for defense is reasonable. 3. Assuming that Boy Bala had provoked that attack on his person by Anacito because of his having earlier killed a policeman, it does not appear that Pedro, the one making the defense, had taken any part in said provocation. Art. 11. Justifying circumstances, defense of stranger 1984 No. 4. Despite denial of a rally permit from the city mayor, a group of students from different schools held a rally at Luisang Bonifacio. At the rally site, they were met by members of the WPD dispersal unit, armed with truncheons, water hose, etc. When student A saw a policeman striking a fellow student, B, with a truncheon, he hit the forearm of the policeman with an empty bottle of Coke in order to prevent the latter from further hurting B. At this point, other policemen came, subdued A and arrested him. For what crime or crimes, if any, under the revised penal code may A be charged? If A is liable for any crime, what circumstances would mitigate or aggravate his liability under the given facts? Explain. Answer. A. Furnished by Office of Justice Palma. None. When the policeman struck B with a truncheon, he goes beyond the limits of his powers. Consequently, A, who employed adequate means to prevent the policeman from hurting B, could not be held liable for assault or resistance nor for physical injuries, considering that he merely acted in defense of a stranger. B. Comments and suggested answer. A is not liable under the revised penal code. He is entitled to defense of stranger, which has the following requisites: 1. Unlawful aggression, 2. Reasonable necessity to prevent or repel it, 3. The person defending is not induced by revenge, resentment of any evil motive. Art. 11, PAR 3, Rev. Penal Code People vs Lara CA 43 OG 3152. The policeman who hit the student B with a truncheon, while the students were at the rally site, abused or exceeded his authority. In this case, the policeman would be an unlawful aggressor. A acted on impulse by striking the policeman on the forearm with an empty Coke bottle to prevent him from farther hurting B. From the facts of the case, B was already injured by the policeman when A hit him, and the means employed under the circumstances would be reasonable. A was not actuated by revenge, resentment, or any evil motive. Alternative answer. A can be held liable for simple resistance when the policeman hit B with a truncheon. The presumption is he acted in fulfillment of his duty as a peace officer to maintain and preserve order in the rally site. However, the act of the policeman can be considered sufficient provocation to A for him to bit the policeman on the arm with a Coke bottle to prevent him from further hurting B. A can invoke such mitigating circumstance. The crime committed is not direct assault, as a policeman is an agent of a person in authority, and the act of A under the facts cannot constitute manifest defiance to the authority of the law. US vs. Tabiana, 37 Philosophy 975, the aggravating circumstance of disregard of the rank of the policeman is also present. People vs. Regala, 113 SCRA 613 1982. Art. 11. Justifying circumstances, defense of stranger 2002 No. 15. B. A chanced upon 3 men who were attacking B with fist blows. C. One of the men was about to stab B with a knife. Not knowing that B was actually the aggressor because he had earlier challenged the 3 men to a fight, a shot C as the latter was about to stab B. May A invoke the defense of a stranger as a justifying circumstance in his favor? Why? 2%. Suggested answer. Yes. A may invoke the justifying circumstance of defense of strangers since he was not involved in the fight and he shot C when the latter was about to stab B. There being no indication that A was induced by revenge, resentment, or any other evil motive in shooting C, his act is justified under PAR 3, Article 11 of the Revised Penal Code, as amended. Art. 11, Justifying Circumstances, Euthanasia 1990 No. 3. A. In mercy killing, is the attending physician criminally liable for deliberately turning off the life support system, consequently costing the life of the patient? State reasons. B. How about in an instance when, in saving the life of the mother, the doctor sacrificed the life of the unborn child? Explain your answer. Answer. A. The attending physician is criminally liable. Euthanasia is not a justifying circumstance in Philippine jurisdiction. B. There is no criminal liability on the part of the doctor because his acts are justified under Article 11(4) of the Revised Penal Code, which provides that the following do not incur any criminal liability, XXX4, any person, who in order to avoid an evil or injury does an act which causes damage to another, provided that the following requisites are present: first, that the evil sought to be avoided actually exists; second, that the injury feared be greater than that done to avoid it; third, that there be no other practical and less harmful means of preventing it. Alternative answer. There is no criminal liability on the part of the doctor because his acts are justified under Article 11(5) of the Revised Penal Code, which provides that the following do not incur any criminal liability. XXX 5. Any person who acts in the fulfillment of a duty or in the lawful exercise of a right or office. Art. 11. Justifying circumstances, fulfillment of duty 2006. A. Lucretia, a store owner, was robbed of her bracelet in her home. The following day, at about 5 o'clock in the afternoon, a neighbor, 22-year-old June, who had an unsavory reputation, came to her store to buy bottles of beer. Lucretia noticed her bracelet wound around the right arm of June. As soon as the latter left, Lucretia went to a nearby police station and sought the help of a policeman on duty, Pat. Willie Reyes. He went with Lucretia to the house of June to confront the latter. Pat. Reyes introduced himself as a policeman and tried to get hold of June, who resisted and ran away. Pat. Reyes chased him and fired 2 warning shots in the air. June continued to run, and when he was about 7 meters away, Pat. Reyes shot him in the right leg. June was hit and he fell down, but he crawled towards a fence, intending to pass through an opening underneath. When Pat. Reyes was about 5 meters away, he fired another shot at June, hitting him at the right lower hip. Pat. Reyes brought June to the hospital, but because of profuse bleeding, he eventually died. Pat Reyes was subsequently charged with homicide. During the trial, Pat Reyes raised the defense, by way of exoneration, that he acted in the fulfillment of a duty. Is the defense tenable? Explain. 3%. Suggested answer. A. No, the defense of Pat Reyes is not tenable. The defense of having acted in the fulfillment of a duty requires as a condition, inter alia, that the injury or offence committed be the unavoidable or necessary consequence of the due performance of the duty. People vs. Oanese, et.al., 74 Philosophy 257. It is not enough that the accused acted in fulfillment of a duty. After June was shot in the right leg and was already crawling, there was no need for Pat Reyes to shoot him further. Clearly, Pat Reyes acted beyond the call of duty which brought about the cause of death of the victim. Art. 11. Justifying circumstances, self-defense 1992 No. 3. As Sergio, Yoyong, Zoolo, and Warlato engaged in a drinking spree at Heartthrob Disco, Special Police Officer 3, SPO 3, Manolo Yabang suddenly approached them, aimed his revolver at Sergio, whom he recognized as a wanted killer, and fatally shot the latter. Whereupon, Yoyong, Zoolo and Warlato ganged up on Yabang. Warlalo, using his own pistol, shot and wounded Yabang. A. What are the criminal liabilities of Yoyong, Zoolo, and Warlato for the injury to Yabang? Was there conspiracy and treachery? Explain. B. In turn, is Yabang criminally liable for the death of Sergio? Suggested answer. A. The acts of Yoyong, Zoolo, and Warlato are justified under Pars. 1 and 2 of Article 11, RPC, that is, self-defense or defense of a stranger, as they have reason to suspect that Yabang might not be satisfied in killing Sergio only, the 3 being friends and companions of the victim. Hence, they are entitled to protect their own lives and limbs from the unlawful aggression of Yabang. Alternatively, they have the justified right to defend a stranger, Sergio, whose life at that moment might still be saved by ganging up on Yabang to prevent the latter from any further attack by the latter. In either case, reasonable necessity of the means employed and lack of sufficient provocation are present. B. Yabang is liable for homicide for the killing of Sergio as the attack was frontal, alternative, murder, because of the qualifying circumstance of abuse of superior strength, in terms of weapon. Sergio, being a suspected killer, is no justification to be killed by Yabang, People vs. Oanese. Art. 11, Justifying Circumstances, Self-Defense 1977 No IA. When a saw be rushing towards him holding a bolo and poised to strike him, he immediately picked up a pointed iron bar and believing that his life was in danger as B was close enough, he made a trust on B hitting him on the stomach which caused the death of B thereafter. The truth, however, is that B was merely trying to play a joke on C, who was then behind A. Is A criminally liable for the death of B? State your reasons. Answer. A is not criminally liable because he acted in self-defense due to mistake of facts. As the facts of the problem state, A thrust the pointed iron bar on B, hitting him on the stomach as he believed that his life was in danger because B was close enough when he rushed towards A holding a bolo and poised to strike him. US vs. Ah Chong, 15 Philosophy 488. Under the circumstances, he had no time or opportunity to verify whether B was only playing a joke on C, who was behind A. Hence, his mistake of the facts was without fault or carelessness. He had no alternative but to take the facts as they appeared to him to justify his act. So A acted in good faith without criminal intent. Art. 11, Justifying Circumstances, Self-Defense 1978 No 4B. B repeatedly stabbed A with a kitchen knife. A managed to escape with minor injuries, and to run away from B, who continued to pursue him. A, upon reaching the safety of his house, took a scythe with which to defend himself against B. Thus armed, A went out of his house and dared B to come forward and fight. In the ensuing struggle, A killed B charged with homicide. A claimed self-defense. Is A entitled to the justifying circumstance? Decide and give your reasons. Answer. A is not entitled to the justifying circumstance of self-defense. There is no unlawful aggression on the part of the victim B. There are two stages in the fight. The first stage was when B stabbed A repeatedly with a kitchen knife, who managed however to escape and ran away, pursued by B. When A reached the safety of his house, he was already safe from the unlawful aggression of B, and so such was deemed to have ceased. When A took a scythe inside his house and while thus armed he went out of his house and dared B to come forward and fight, B became therefore the challenger. From the facts, a struggle ensued, which implies that the challenge of A was accepted by B, which is an agreement to fight, and hence there can be no unlawful aggression. People vs. Estilla, CAGR number 4391 6 Vileos Digest, page 124. Art. 11, Justifying Circumstances, Self-Defense 1979 No 6. X, a private citizen, saw two masked men break into a drug store across his home. He telephoned the police to come. Without waiting for the police, he went outside his house with a pistol and tried to intercept the thieves. He told them to stop, but they did not. He fired several shots at them, wounded them, and caused their hospitalization for 20 days. May the thieves file any criminal case against X? May X invoke the defense of the person or rights of a stranger? Answer. The thieves can file a criminal action against X. In defense of the person or property of a stranger, the elements of 1. Unlawful aggression, 2. Reasonable necessity of the means employed to prevent or repel it, and 3. That the person defending must not be induced by revenge, resentment or any other evil motive, must be present. In self-defense of property, the doctrine is that the attack on the property must be coupled with an attack upon the person of the possessor of the property. People vs. Apollinar, CA 38 OG 2870. The same rule should apply to defense of the property of a stranger, since the first two elements of defense of a stranger are also the first two elements of self-defense, that is, unlawful aggression and reasonable necessity of the means employed to prevent or to repel it. The means employed by X in firing several shots at the thieves was not reasonable, as there was no attack upon the person of the owner of the drugstore or of any person present therein. Nor can there be defense of the person of a stranger, since unlawful aggression is absent. Art. 11, Justifying Circumstances, Self-Defense 1980 No. 3. F and G quarreled. F attacked G with a club 2 or 3 times, but G was able to parry the attack. G did not move backwards but struck back, hitting F on his head with a lead pipe which he picked up from the ground, causing F's death. G was charged with homicide. If you were the judge, would you find G guilty as charged? Answer. If the term quarreled implies an agreement to a fight, G would be guilty of the crime charged. He cannot invoke self-defense because if there is an agreement to fight there would be no unlawful aggression. Any attack is considered as a mere consequence of the agreement to fight. On the other hand, if the word quarreled involves only a verbal altercation, G would not be guilty because F committed unlawful aggression when he attacked G 3 times with a club. When G struck back, hitting F on his head with a lead pipe which he picked up on the ground, he acted in self-defense because the aggression of F was still present and the pipe was the only means available to him in defending his person, as he was acting under the instinct of self-preservation. The assumption is that G did not give any sufficient provocation which immediately preceded the attack made by F. Art. 11, Justifying Circumstances, Self-Defense 1981 No. 3. A is the wife of B, but she and X, her former boyfriend, were having an illicit relation. One afternoon, B, unnoticed by A, followed his wife to a motel and saw her enter a room and close the door. After the lapse of some minutes, B managed to get in and found A and X lying together in bed. With his knife, B lunged at X, but the latter parried the thrust and was able to wrest the weapon from B and stabbed the latter to death. Prosecuted for homicide, X invoked the justifying circumstance of self-defense in killing B. Would you uphold the defense? Explain briefly. Answer. X cannot invoke the justifying circumstance of self-defense. An essential requisite of self-defense is unlawful aggression. The act of B in assaulting X when he found him and A, B's wife, lying together in bed in a room of the motel is natural and lawful, as it was made by B, the deceived and offended husband, in order to defend his honor and rights. X should have known that having illicit relations with A married woman, X being her former boyfriend, he was performing an unlawful and criminal act that would expose him to the vengeance of the offended husband. The act of B in assaulting X under the circumstances cannot constitute unlawful aggression. US vs. Merced 39 Philosophy 198. Furthermore, in view of his illicit relations with A, B's wife, and the situation in which B found them, lying together in bed, would constitute sufficient provocation to B for him to attack X. The third requisite of self-defense, which is lack of sufficient provocation on the part of the person defending himself, is, therefore, also absent. Art. 11, Justifying Circumstances, Self-Defense 1982 No. 2. A, intending to kill B, attacked the latter with a bolo. In trying to defend himself with a piece of wood by parrying the blows delivered by A, B hit C, an onlooker, on the head, as a result of which C died. Is B liable for C's death under the legal provisions that, although the wrong done be different from that intended? Explain your answer. Answer. B is not liable for C's death because he acted in self-defense. The legal provision that, although the wrong done be different from that intended, contemplates the commission of a felony, and the wrong done is the direct, natural, and logical consequence thereof, even though not intended. Had B acted in incomplete self-defense, then this provision would apply, because there is mistake in the blow or aberratio ictus. In the case of self-defense, however, which is a justifying circumstance, the act committed is lawful, hence B would not incur any criminal or civil liability. Art. 11, Justifying Circumstances, Self-Defense 1982 No. 3. A intending to kill B, shot the latter with a gun at close range. Although hit but not mortally wounded, B grappled with A for the possession of the gun until B succeeded in wresting it from his adversary. Immediately thereafter, B fired the gun at A whom he killed. Prosecuted for homicide, B interposed self-defense. The prosecution however contended self-defense was untenable because A had already been disarmed. Decide, explaining fully your decision. Answer. The contention of the prosecution that self-defense was untenable because A had already been disarmed must be sustained. The reason is there is no more aggression to be prevented or repelled. Upon almost identical facts, in the case of People vs. Diong et al., 98 SCRA 851, 1980, the Supreme Court held that as the victim was killed after the accused had wrested the gun from the former, since there was no more aggression to stop or repel as the victim was shot and killed when he was already unarmed and defenseless. Self-defense cannot be invoked. Art. 11, Justifying Circumstances, Self-Defense 1985 No. 9. Feeling homesick and terribly missing his wife after a long absence, Ronald, without notice, came home from Saudi. Arriving at their residence, he immediately proceeded to their bedroom where he saw his wife lying on their bed under a mosquito net locked in embrace with his compadre Dante Ayala. He immediately drew his gun but was beaten to a draw by Dante, whose bullet felled him. Prosecuted for homicide for killing Ronald, Dante set up self-defense but was nevertheless convicted. A. Comment on the validity of Dante's conviction. B. In the above given case, supposing Ronald shot Dante and his Ronald's wife, while Dante was on top of the latter, thus killing both of them, will you grant him the benefit of Article 247 of the Revised Penal Code? Explain. Answer. A. The conviction of Dante was valid. He cannot claim self-defense as there was no unlawful aggression on the part of the victim. When Ronald drew his gun upon surprising his wife locked in embrace with his compadre Dante, while lying on their bed at their residence, his act was natural and lawful as it was made by a deceived and offended husband. The act of Dante in maintaining illicit relations with the wife of his compadre was unlawful. U.S. v. Merced 89 Philosophy 189. Art. 11, Justifying Circumstances, Self-Defense 1987 No. 7. Pedro confronted Jose one morning near the latter's house and angrily inquired why he let loose his carabaos which destroyed his plants. Pedro saw that Jose was armed with a dagger tucked on his waist and thinking that Jose would react violently, Pedro immediately drew his revolver. Instinctively, Jose grabbed the gun from Pedro's hand and a struggle for possession of the gun ensued, as a result of which the gun was thrown 1 meter away. Pedro jumped for the gun, and Jose unsheathed his dagger and stabbed Pedro at the base of his neck, causing the latter to fall down. Jose ran away as he was afraid Pedro's relatives might kill him. He was apprehended 3 days later in another barrio. Fortunately, Pedro survived after 40 days of hospitalization. The gun turned out to be without live bullets. During the trial for frustrated homicide against Jose, Pedro testified that he drew his gun even while he knew it had no bullets, merely to scare Jose, and he jumped for it when it was thrown away for the same purpose. Jose pleaded self-defense. The fiscal argued that Jose's act of running away is evidence of guilt and negates self-defense. He also said that, in any event, there was no reasonable necessity of the means employed, namely, stabbing with a dagger, because Pedro's gun had no bullets. Decide the case. Answer. Jose is entitled to self-defense. Considering the circumstance of the case, unlawful aggression, the first element of self-defense is present. Pedro loose his carabaos which destroyed his plants, and he then loose his carabaos which destroyed his plants, and then immediately drew his revolver which Jose instinctively grabbed from Pedro's hand. In the struggle for the possession for the revolver, it was thrown 1 meter away, and when Pedro jumped for the gun, Jose unsheathed his dagger and stabbed Pedro, who fell down. Jose ran away. The intimidating attitude of Pedro when he drew his revolver constitutes imminent unlawful aggression. Jose did not give any provocation to Pedro. Pedro was in a violent mood, and in the mind of Jose was armed, with revolver in hand, and what Jose did in grabbing the gun was to prevent an aggression that is expected. People vs Domingo CA 13 Rep 1355. Stabbing Pedro with a dagger was the only available means to prevent the expected aggression, considering that Jose acted by following his instinct of self-preservation. The flight of Jose after stabbing Pedro cannot be considered as evidence of guilt because he did so as he was afraid the relatives of Pedro might kill him. Art 11, Justifying Circumstances, Self-Defense 1993 Number 11. 1. Pat Negra saw Philippine, an inmate, escaping from jail and ordered the latter to surrender. Instead of doing so, Philippine attacked Pat Negra with a bamboo spear. Philippine missed in his first attempt to hit Pat Negra, and before he could strike again, Pat Negra shot and killed him. Can Pat Negra claim self-defense? Explain. 2. Suppose Pat Negra missed in his shot, and Philippine ran away without parting with his weapon. Pat Negra pursued Philippine, but the latter was running so fast that Pat Negra fired warning shots into the air, shouting for Philippine to stop. Inasmuch as Philippine continued running, Pat Negra fired at him, hitting and killing him. Is the plea of self-defense sustainable? Why would you then hold Pat Negra criminally liable? Discuss. Answer. 1. Yes. Self-defense can be claimed as there is an imminent and great peril on the life of Negra. 2. No. Self-defense is no longer sustainable as there is no more peril on his life. Yes, excessive force is used. Art 11, Justifying Circumstances, Self-Defense, Defense of Honor 1998 No 15. One night, Una, a young married woman, was sound asleep in her bedroom when she felt a man on top of her. Thinking it was her husband Tito, who came home a day early from his business trip, Una let him have sex with her. After the act, the man said, "I hope you enjoyed it as much as I did." Not recognizing the voice, it dawned upon Lena that the man was not Tito, her husband. Furious, Una took out Tito's gun and shot the man. Charged with homicide, Una denies culpability on the ground of defense of honor. Is her claim tenable? 5%. Answer. No, Una's claim that she acted in defense of honor is not tenable because the unlawful aggression on her honor had already ceased. Defense of honor, as included in self-defense, must have been done to prevent or repel an unlawful aggression. There is no defense to speak of where the unlawful aggression no longer exists. Art 11, Justifying Circumstances, Self-Defense, Defense of Honor 2002 No 15. When A arrived home, he found B raping his daughter. Upon seeing A, B ran away. A took his gun and shot B, killing him. Charged with homicide, A claimed he acted in defense of his daughter's honor. Is A correct? If not, can A claim the benefit of any mitigating circumstance or circumstances? 3%. Suggested answer. No, A cannot validly invoke defense of his daughter's honor in having killed B since the rape was already consummated. Moreover, B already ran away, hence, there was no aggression to defend against and no defense to speak of. A may, however, invoke the benefit of the mitigating circumstance of having acted in immediate vindication of a grave offense to a descendant, his daughter, under PAR 5, Article 13 of the Revised Penal Code, as amended. Art 11, Justifying Circumstances, Self-Defense, Defense of Property 1983 No. 2. Considering that the Revised Penal Code provisions on justifying circumstances apply to anyone who acts in defense of his person or rights, can there be self-defense when there is simply an aggression against one's property, not coupled with an attack against his person? Explain. Answer. No. Self-defense will be incomplete. Under the Civil Code there is unlawful aggression on the property rights of another. But to constitute self-defense of property, two other elements must be considered, namely, reasonable necessity of the means employed to repel the aggression and lack of sufficient provocation on the part of the person defending his property. People v. Apolinar, 38 OG 2079, held that there is no self-defense of property if the attack on the property is not coupled with an attack on the person of the owner or possessor of the property. If, for example, the owner shot the aggressor although his person was not attacked, self-defense of property will not be present, although there is unlawful aggression on his property right, because the means adopted to repel the aggression is not reasonable. People vs. Navis, 1983, 121 SCRA 403. Art. 11, Justifying Circumstances, Self-Defense, Defense of Property 1996 No. 6. 1. A security guard, upon seeing a man scale the wall of a factory compound which he was guarding, shot and killed the latter. Upon investigation by the police who thereafter arrived at the scene of the shooting, it was discovered that the victim was unarmed. When prosecuted for homicide, the security guard claimed that he merely acted in self-defense of property and in the performance of his duty as a security guard. If you were the judge, would you convict him of homicide? Explain. Answer. 1. Yes. I would convict the security guard for homicide if I were the judge, because his claim of having acted in defense of property and in performance of a duty cannot fully be justified. Even assuming that the victim was scaling the wall of the factory compound to commit a crime inside the same, shooting him is never justifiable, even admitting that such act is considered unlawful aggression on property rights. In People vs. Narvaez, 121 SCRA 329, a person is justified to defend his property rights, but all the elements of self-defense under Art. 11 must be present. In the instant case, just like in Narvaez, the second element, reasonable necessity of the means employed, is absent. Hence, he should be convicted of homicide but entitled to incomplete self-defense. Art. 11, Justifying Circumstances, Self-Defense, Defense of Property 1977 No. 2b. While C was approaching his car, he saw D slowly driving it away. So he shouted at D to stop, but D instead accelerated his speed. To prevent his car from being carnapped, C drew at once hit revolver and fired at D, who was by then about 20 meters away, fatally hitting him on the head. When charged for the death of D, C interposed the defense of his rights to property. If you were the judge, will you acquit or convict C? State your reason. Answer. If I were the judge, I would convict C. There is no defense of his right to property because although D drove the car of C away and he did not stop in spite of his shouts for him to do so, D had not attacked him. To be entitled to complete self-defense of property, the attack on the property must be coupled with an attack upon the person of the owner or possessor of said property. People vs. Apolinar, CA 38 OG 2870. Art. 11, Justifying Circumstances, Self-Defense, Defense of Property. 1990 No. 4. In the middle of the night, Diong heard the footsteps of an intruder inside their house. Diong picked up his rifle and saw a man, Goryo, with a pistol ransacking Diong's personal effects in his study. He shot and killed Goryo. A. Is Diong criminally liable for killing the robber Goryo? State your reasons. B. Suppose Diong shot Goryo while he was running away from Diong's house with his television set, what is Diong liable for? Explain your answer. Answer. A. Diong is not criminally liable because he was acting in defense of property rights. Under the case of People v. Narvaez, G.RNOSL 33466-67, April 20, 1983, 121 SCRA 389, defense of property need not necessarily be coupled with aggression against persons. B. There is criminal liability, this time with the mitigating circumstance of incomplete self-defense. Under the case of People v. Narvaez, defense of property can be availed of even when there is no assault against a person. It is recognized as an unlawful aggression. Art. 11. Justifying circumstances, self-defense, unlawful aggression and mistake of fact. 2003 No. 2. The accused lived with his family in a neighborhood that often was the scene of frequent robberies. At one time, past midnight, the accused went downstairs with a loaded gun to investigate what he thought were footsteps of an uninvited guest. After seeing what appeared to him an armed stranger looking around and out to rob the house, he fired his gun, seriously injuring the man. When the lights were turned on, the unfortunate victim turned out to be a brother-in-law on his way to the kitchen to get some light snacks. The accused was indicted for serious physical injuries. Should the accused, given the circumstances, be convicted or acquitted? Why? 4%. Suggested answer. The accused should be convicted because, even assuming the facts to be true in his belief, his act of shooting a burglar when there is no unlawful aggression on his person is not justified. Defense of property or property right does not justify the act of firing a gun at a burglar unless the life and limb of the accused is already in imminent and immediate danger. Although the accused acted out of a misapprehension of the facts, he is not absolved from criminal liability. Alternative answer. Considering the given circumstances, namely, the frequent robberies in the neighborhood, the time was past midnight, and the victim appeared to be an armed burglar in the dark and inside his house, the accused could have entertained an honest belief that his life and limb or those of his family are already in immediate and imminent danger. Hence, it may be reasonable to accept that he acted out of an honest mistake of fact and therefore without criminal intent. An honest mistake of fact negatives criminal intent and thus absolves the accused from criminal liability. Art. 11. Justifying vs. Exempting circumstances 1978 No. 2b. Justifying and exempting circumstances have some similar effects but are different concepts. Discuss their similarities and distinctions. Answer. In justifying circumstance, the act committed is lawful, and the actor does not incur any criminal nor civil liability. In an exempting circumstance, a crime is committed but there is absent in the person of the offender any of the elements of voluntariness, and so he is not criminally liable but is civilly liable except in the exempting circumstances of accident and lawful or insuperable cause. To recapitulate, in a justifying circumstance, the act is lawful and hence, there is no crime committed. In an exempting circumstance, the actor does not incur any criminal nor civil liability. In an exempting circumstance, the offender is not criminally liable because the act is not committed voluntarily but he is civilly liable because the source of the obligation which is the crime is present. Art. 11, Justifying vs. Exempting circumstances 1998 No. 4. 1. Distinguish between justifying and exempting circumstances. 3% answer. 1. In justifying circumstances. A. The circumstance affects the act, not the actor. B. The act is done within legal bounds, hence considered as not a crime. C. Since the act is not a crime, there is no criminal. D. There being no crime nor criminal, there is no criminal nor civil liability. Whereas, in an exempting circumstances, A. The circumstance affects the actor, not the act. B. The act is felonious and hence a crime but the actor acted without voluntariness. C. Although there is a crime, there is no criminal because the actor is regarded only as an instrument of the crime. D. There being a wrong done but no criminal, there is civil liability but no criminal liability. Art. 11, Mistake of Fact 1977 No. IA. When a saw be rushing towards him holding a bolo and poised to strike him, he immediately picked up a pointed iron bar and believing that his life was in danger as B was close enough, he made a trust on B hitting him on the stomach which caused the death of B thereafter. The truth, however, is that B was merely trying to play a joke on C who was then behind A. Is A criminally liable for the death of B? State your reasons. Answer. A is not criminally liable because he acted in self-defense due to mistake of facts. As the facts of the problem state, A thrust the pointed iron bar on B, hitting him on the stomach as he believed that his life was in danger because B was close enough when he rushed towards A holding a bolo and poised to strike him. US vs. Ah Chong, 15 Philosophy 488. Under the circumstances, he had no time or opportunity to verify whether B was only playing a joke on C who was behind A. Hence, his mistake of the facts was without fault or carelessness. He had no alternative but to take the facts as they appeared to him to justify his act. So A acted in good faith without criminal intent. Art 11, Mistake of Fact 1988 Number 10. B. 5 laborers were hired by Manuel Diong to harvest coconuts from a plantation which he told them belonged to him. Unknown to them, the ownership of the land was in dispute, and the registered owner subsequently filed a case of qualified theft against them. How would you defend them? Explain briefly. Answer. B. I would defend them by citing US vs. Ah Chong, 15 Philosophy 488, on mistake of facts and charge the owner with violation of Article 282 on grave threats. In US vs. Ah Chong, the accused was exempted from criminal liability because he performed an act which would be lawful had it been true as he believed that grave threats. Any person who shall threaten another with the infliction upon the person, honor or property of the latter or of his family of any wrong amounting to a crime, shall suffer. Art 11, Mistake of Fact 1985 Number 6. Pat Josue, a member of the INP Western Police District, together with two other policemen, was chasing Cadendig, a notorious police killer. Cadendig entered a nearby dimly lighted warehouse. Josue and his companions continued pursuing him. When they reached the mezzanine, Josue saw a man crouching behind a pile of boxes, holding what appeared to be a long rifle. When the man suddenly stood up and faced Josue and his companions, Josue fired at the man, hitting him fatally. It turned out, however, that the deceased was the warehouseman who was holding a mere lead pipe. Discuss Pat Josue's criminal liability for the said killing, stating your reasons. Answer. Patrolman Josue will not incur any criminal liability. He can invoke in his favor mistake of facts due to good faith. Under the circumstances, Patrolman Josue shot the victim in the honest belief that he was the notorious police killer whom they were chasing until he entered a dimly lighted warehouse. In the mezzanine of the warehouse, Patrolman Josue saw a man crouching behind a pile of boxes holding what appeared to be a long rifle. The patrolman fired at the man when he suddenly stood up and faced him. He had no opportunity to verify first the identity of the victim before acting. He acted, therefore, without criminal intent and had the facts turned out to be true, as Patrolman Josue believed them to be, that is, that the victim was the notorious police killer, that act committed would be lawful. Art 11, Qualifying Circumstances as Elements of a Crime 2003 No. 4. B. When would qualifying circumstances be deemed, if at all, elements of a crime? 4%. Suggested answer. B. A qualifying circumstance would be deemed an element of a crime when 1. It changes the nature of the crime, bringing about a more serious crime and a heavier penalty. 2. It is essential to the crime involved, otherwise some other crime is committed, and 3. It is specifically alleged in the information and proven during the trial. Alternative answer. A qualifying circumstance is deemed an element of a crime when it is specifically stated by law as included in the definition of a crime, like treachery in the crime of murder. Art 12, Exempting Circumstances, Accident 1981 No. 1. A and B, both civilian guards, were seated inside the guardhouse. While A was cleaning his service pistol, B snatched it. In the ensuing struggle for the possession of the weapon, A succeeded in wresting it from the hand of B. But then the pistol exploded with the bullet hitting the breast of C, another civilian guard, who died as a consequence of the gunshot wound. Is A criminally liable for the death of C? Why? Answer. A is not criminally liable. Since his service pistol was snatched by B, in trying to regain its possession, A was in the lawful exercise of a right. When A succeeded in wresting the pistol from the hand of B and it exploded with the bullet hitting C, A cannot incur any criminal liability as he was performing a lawful act. Even under the Civil Code, he is justified to employ reasonable force to repel the unlawful deprivation of his property, Art. 429, Civil Code. Criminal intent is not present nor is there negligence under the circumstances. The death of C was, therefore, accidental. People vs. Bindoy 56 Philosophy 15. Art. 12, Exempting Circumstances, Accident 1989 No. 2. Nicandro borrowed Valeriano's gun, a high-powered M16 rifle, to hunt wild pigs. Nicandro was accompanied by his friend, Felix. On their way to the hunting ground, Nicandro and Felix met Pedro near a hut. Pedro told them where to hunt. Later, Nicandro saw a pig and then shot and killed it. The same bullet, however, that killed the pig struck a stone and ricocheted hitting Pedro on his breast. Pedro later died. May Nicandro be held liable for the death of Pedro? Explain. Answer. Nicandro may be held liable for the death of Pedro. While Pedro's death would seem to be accidental, the requisites of exempting circumstance of accident are not all present. Said requisites are: 1. A person is performing a lawful act, 2. With due care. 3. He causes an injury to another by mere accident, 4. Without fault or intention of causing it, Art. 12, PAR 4, RPC. When Nicandro borrowed Valeriano's high-powered M16 rifle and used it for hunting wild pigs, he committed the crime of illegal possession of firearms, as he does not appear to have either a license to possess a high-powered gun or to carry the same outside of his residence. At the time he shot at the wild pig, therefore, Nicandro was not performing a lawful act. Furthermore, considering that the M16 is a high-powered gun, Nicandro was negligent in not foreseeing that bullets fired from said gun may ricochet. Art. 12, Exempting Circumstances, Article 332, 2000 No. 11. A. Brother of B, with the intention of having a night out with his friends, took the coconut shell which is being used by B as a bank for coins from inside their locked cabinet using their common key. Forthwith, A broke the coconut shell outside of their home in the presence of his friends. What is the criminal liability of A, if any? Explain. 3%. Is A exempted from criminal liability under Article 332 of the Revised Penal Code for being a brother of B? Explain. 2%. Suggested answer. A is criminally liable for robbery with force upon things. B. No, A is not exempt from criminal liability under Art. 332 because said article applies only to theft, swindling or malicious mischief. Here, the crime committed is robbery. Art. 12, Exempting Circumstances, Insanity 1991 No. 7. A raped X. In the process, X resisted and slapped A. Angered, A grabbed a stone and hit X. She was dying when A consummated the sexual attack. A psychiatrist from the National Center for Mental Health testified that he conducted physical, mental, and psychological examinations on A and found him to be suffering from a mental disorder classified under organic mental disorder with psychosis. A's father testified that A was playful but cruel to his brothers and sisters, stole his mother's jewelry which he sold for low sums, wandered naked sometimes, and oftentimes did not come home for extended periods of time. The prosecution on the other hand, presented an array of witnesses to prove A that was lucid before and after the crime was committed and that he acted with discernment. After trial, the court convicted the accused and sentenced him to a life imprisonment considering that under the Constitution death penalty could no longer be imposed. Given the conflicting testimonies as to sanity of the accused, was the trial court correct in ruling out insanity as an exempting circumstances in this case? Is the sentence of life imprisonment a correct imposition of penalty? Answer. Yes, the court is correct in ruling out insanity as an exempting circumstance. While there was testimony that A was suffering from a mental disorder, the testimony of A's father disclosed that A had lucid intervals. Because what is presumed is sanity, not insanity, it is to be presumed that A was sane when he committed the crime. Consequently, evidence being wanting that A is completely deprived of reason at the moment of committing the crime, he should be liable. Besides, the crime committed and the acts done by the accused in the commission of the crime hardly reconciles with insanity of the offender, as rape presupposes evident premeditation. Art. 12, Exempting Circumstances, Minority 1998 No. 4. 2. John, an 8-year-old boy, is fond of watching the television program Zo Rangers. One evening while he was engrossed watching his favorite television show, Petra, a maid changed the channel to enable her to watch Home Along the Rails. This enraged John, who got his father's revolver, and without warning, shot Petra at the back of her head, causing her instantaneous death. Is John criminally liable? 2%. Answer. 2. No, John is not criminally liable for killing Petra because he is only 8 years old when he committed the killing. A minor below 9 years old is absolutely exempt from criminal liability, although not from civil liability. Art. 12, PAR 2, RPC. Art. 12, Exempting Circumstances, Minority 2000 No. 4. While they were standing in line awaiting their vaccination at the school clinic, Pompaing repeatedly pulled the ponytail of Katrina, his 11 years, 2 months, and 13 days old classmate in grade 5 at the Sampaloc Elementary School. Irritated, Katrina turned around and swung at Pompaing with a ball pen. The top of the ball pen hit the right eye of Pompaing, which bled profusely. Realizing what she had caused, Katrina immediately helped Pompaing. When investigated, she freely admitted to the school principal that she was responsible for the injury to Pompaing's eye. After the incident, she executed a statement admitting her culpability. Due to the injury, Pompaing lost his right eye. A. Is Katrina criminally liable? Why? 3%. B. Discuss the attendant circumstances and effects thereof. 2%. Suggested answer. A. No, Katrina is not criminally liable, although she is civilly liable. Being a minor less than 15 years old, although over 9 years of age, she is generally exempt from criminal liability. The exception is where the prosecution proved that the act was committed with discernment. The burden is upon the prosecution to prove that the accused acted with discernment. The presumption is that such minor acted without discernment, and this is strengthened by the fact that Katrina only reacted with a ballpen which she must be using in class at the time, and only to stop Pompaing's vexatious act of repeatedly pulling her ponytail. In other words, the injury was accidental. B. The attendant circumstances which may be considered are, 1. Minority of the accused as an exempting circumstance under Article 12. Paragraph 3, Rev. Penal Code, where she shall be exempt from criminal liability, unless it was proved that she acted with discernment. She is, however, civilly liable. 2. If found criminally liable, the minority of the accused as a privileged mitigating circumstance. A discretionary penalty lower by at least 2 degrees than that prescribed for the crime committed shall be imposed in accordance with Article 68. Paragraph 1, Rev. Penal Code. The sentence, however, should automatically be suspended in accordance with Section 5A of Rep. Act No. 8369, otherwise known as the Family Courts Act of 1997. 3. Also, if found criminally liable, the ordinary mitigating circumstance of not intending to commit so grave a wrong as that committed, under Article 13, Paragraph 3, Rev. Penal Code, and 4. The ordinary mitigating circumstance of sufficient provocation on the part of the offended party immediately preceded the act. Art. 12, Exempting Circumstances, Uncontrollable Fear 1979 No. v. X, engaged in illegal gambling, was accused of bribing Y, a policeman. X's defense was fear of reprisal from the police in case of non-payment of bribe money. He testified that when he attempted to stop giving bribe money to Y, the police raided his establishment without warrant for half a dozen times. Y also threatened to plant incriminating evidence on him. X was also manhandled by Y on the pretext of resisting arrest. X would park his police jeep in front of his house obviously to drive away his regular customers. X's defense is that he bribed Y under the impulse of an uncontrollable fear of an equal or greater injury. Please decide. Answer. X's defense that he bribed Y, a policeman, under the impulse of an uncontrollable fear of an equal or greater injury, is untenable. This exempting circumstance can be appreciated if a person is compelled to commit a crime by another through intimidation. It is also essential that the person intimidated must not have any opportunity for escape or to avoid the threat. The facts of the problem show that X could have easily reported to the authorities the alleged acts of harassment committed by the policeman. Lastly, the fear must not be speculative or fanciful but must be actual or real. All the acts testified to by X do not show any actual or direct intimidation on the part of Y in case of non-payment of the bribe. Art. 12, Minority, Effect on Accused's Liabilities 1984 No. 2. In what specific ways does the revised Penal Code exhibit due regard for the minority of an accused? A. In the determination of his criminal liability. B. In the determination of the degree of his culpability. C. In the imposition of penalties upon him. Answer. A. Furnished by Office of Justice Palma, A. Re. Criminal liability of a minor. Under Art. 12 of the RPC, a person under 9 years of age is exempt from criminal liability. A person over 9 years of age and under 15 is also exempt from criminal liability, except when he acts with discernment, in which case he shall be proceeded against in accordance with Art. 80 of the RPC, which suspends the sentence of minor delinquents. Under Art. 80 of RPC, whenever a minor under 16 years of age at the date of the commission of the offence, a grave or less grave felony, is accused thereof, the court, after hearing the evidence in the proper proceedings, instead of pronouncing judgment of conviction, shall suspend all further proceedings and shall commit such minor to the custody or care of a public or private benevolent or charitable institution, established under the law for the care, correction, or education of orphaned, homeless, defective and delinquent children, or to the custody or care of any responsible person until such minor shall have reached his majority age or for such less period as the court may deem proper. However, under PD 1179, which amended PD 603, the Child and Youth Welfare Code, which in turn, under Articles 189 and 192, thereof PD 603, amended Art. 80 of RFC, the suspension of sentence and commitment of youthful offenders covers minors over 9 years and under 18 years of age at the time of the commission of the offence who acts with discernment. If he acts without discernment, then he is exempt from criminal liability. B. Degree of culpability. Minority is treated as a mitigating circumstance under Art. 13 of the RPC. Under said article, a minor is a person under 18 years of age, in which case he shall be proceeded against in accordance with the provisions of Article 80, as amended by PD 603, as amended by P.D. 1179. But the rule is now settled that minority under 18 years is a privileged mitigating circumstance under Art. 68 of the RPC, which provides for the imposition of penalty 1 or 2 degrees lower than that prescribed for the offence. Imposition of penalties on minors. Article 68 of RPC provides, when the offender is a minor under 18 years and his case is one coming under the provisions of the Code, RPC, the following rules shall be observed. 1. Upon a person under 15 but over 9 years of age, who is not exempted from liability by reason of the court having declared that he acted with discernment, a discretionary penalty shall be imposed, but always lower by 2 degrees at least than that provided by law for the crime which he committed. 2. Upon a person over 15 and under 18 years of age, the penalty next lower than that prescribed by law shall be imposed, but always in the proper period. The provisions of PD 603, as amended by PD 1179, on suspension of penalties in the case of youthful offenders, under 18, are also applicable. A. Comments and suggested answer. The specific ways provided by the revised Penal Code regarding the minority of an accused follow. A. In the determination of his criminal liability. A minor 9 years of age and under at the time of the commission of the crime is exempt from criminal liability. A minor over 9 years and under 15 years of age at the time of the commission of the crime is also exempt from criminal liability unless he has acted with discernment. Art. 12. Rev. Penal Code as amended by Art. 189, PD 603 amended by PD 1179. A minor 15 years and under 21 years of age is dealt with like an adult offender. B. In the determination of his degree of culpability. A minor under 18 years of age at the time of the commission of the crime is entitled to a privileged mitigating circumstance, Art. 68 Rev. Penal Code, People vs. Jose eta. 1975, 71 SCRA 273. A minor 18 years and under 21 years of age is not entitled to a mitigating circumstance, whether ordinary or privileged. C. In the imposition of the penalty. A minor over 9 years and under 15 years of age at the time of the commission of the crime, who acted with discernment, is entitled to a discretionary penalty lower by 2 degrees at least than that prescribed by law for the crime committed. If he is 15 years and under 18 years of age, the penalty lower than that prescribed by law shall be imposed in the proper period. Under PO 603 as amended by PD 1179, the imposition of the sentence may be suspended upon the application of the minor if found guilty after trial. If granted by the court, the minor is ordered committed to an institution until he reaches the age of majority. If the minor during confinement has been found to be incorrigible, he is returned to the court for the pronouncement of the sentence. He shall be credited in the service of the sentence the full time spent in actual confinement and detention in said institution. The benefit of this provision shall not apply to a minor who has already enjoyed suspension of sentence nor to one convicted of an offense punishable by death or life imprisonment. The minor is under 18 years of age at the time of the commission of the crime, PD 1179, and at the time of the trial, People vs. Casiguran L 43387, November 7, 1979, Art. 80 of the Rev. Penal Code has been expressly repealed by Presidential Decree 1179 which amended Presidential Decree 603. Under Art. 189 thereof said minor who acted with discernment shall be proceeded against under Art. 192 of said Presidential Decree as amended. Art. 12, Minors, Liability 1995 Number 7. Victor, Ricky, Rod, and Ronnie went to the store of Mang Pandoi. Victor and Ricky entered the store while Rod and Ronnie posted themselves at the door. After ordering beer, Ricky complained that he was shortchanged, although Mang Pandoi vehemently denied it. Suddenly Ricky whipped out a knife as he announced "Hold up ITO," and stabbed Mang Pandoi to death. Rod boxed the store's salesgirl Lucy to prevent her from helping Mang Pandoi. When Lucy ran out of the store to seek help from people next door, she was chased by Ronnie. As soon as Ricky had stabbed Mang Pandoi, Victor scooped up the money from the cash box. Then Victor and Ricky dashed to the street and shouted, "Tumakbo Nako!" Rod was 14 and Ronnie was 17. The money and other articles looted from the store of Mang Pandoi were later found in the houses of Victor and Ricky. 1. Discuss fully the criminal liability of Victor, Ricky, Rod, and Ronnie. Answer. 1. All are liable for the special complex crime of robbery with homicide. The acts of Ricky in stabbing Mang Pandoi to death, of Rod in boxing the salesgirl to prevent her from helping Mang Pandoi, of Ronnie in chasing the salesgirl to prevent her in seeking help, of Victor in scooping up money from the cash box, and of Ricky and Victor in dashing to the street and announcing the escape, are all indicative of conspiracy. The rule is settled that when homicide takes place as a consequence or on the occasion of a robbery, all those who took part in the robbery are guilty as principals of the crime of robbery with homicide, unless the accused tried to prevent the killing. People vs. Balo, 224 SCRA 218. Further, the aggravating circumstance of craft could be assessed against the accused for pretending to be customers of Mang Pandoi. Although Rod is only 14 years old, his act of boxing Lucy to prevent her from helping Mang Pandoi is a clear sign of discernment, thus he cannot invoke exemption from criminal liability under Art. 12, PAR 3, RPC. Rod and Ronnie are, however, entitled to 2 and 1 degrees lower, respectively from the penalty of the principal under Art. 68 RPC. Mitigating circumstances. Art 13, Mitigating and Aggravating, when not considered 1975 No. 6. In what cases are mitigating and aggravating circumstances not considered in the imposition of the penalty? Answer. A. If the penalty is single and indivisible. B. If the offence is punished by a special law. C. If the penalty provided in an ordinance is a fine. D. In felonies committed by negligence or imprudence. E. If the offender is a Muslim or a non-Christian. Sector 106, Rev. ADM Code, People v. Moro Disamban, L. 1746, January 31, 1951. Art 13, Mitigating Circumstance, Voluntary Surrender 1996 No. 3. 1. Ilario, upon seeing his son engaged in a scuffle with Rene, stabbed and killed the latter. After the stabbing, he brought his son home. The chief of police of the town, accompanied by several policemen, went to Hilario's house. Ilario, upon seeing the approaching policemen, came down from his house to meet them and voluntarily went with them to the police station to be investigated in connection with the killing. When eventually charged with and convicted of homicide, Ilario, on appeal, faulted the trial court for not appreciating in his favor the mitigating circumstance of voluntary surrender. Is he entitled to such a mitigating circumstance? Explain. Answer. 1. Yes, Ilario is entitled to the mitigating circumstance of voluntary surrender. The crux of the issue is whether the fact that Ilario went home after the incident, but came down and met the police officers and went with them is considered voluntary surrender. The voluntariness of surrender is tested if the same is spontaneous, showing the intent of the accused to submit himself unconditionally to the authorities. This must be either, A. because he acknowledges his guilt, or, B. because he wishes to save them the trouble and expenses necessarily incurred in his search and capture. Reyes Commentaries, p. 303. Thus, the act of the accused in hiding after commission of the crime, but voluntarily went with the policeman who had gone to his hiding place to investigate, was held to be mitigating circumstance. People vs. Dayrit, cited in Reyes Commentaries, p. 299. Art 13, Mitigating Circumstance, Voluntary Surrender 1999 No. I. When is surrender by an accused considered voluntary, and constitutive of the mitigating circumstance of voluntary surrender? 3%. Suggested answer. A surrender by an offender is considered voluntary when it is spontaneous, indicative of an intent to submit unconditionally to the authorities. To be mitigating, the surrender must be A. Spontaneous, i.e., indicative of acknowledgement of guilt and not for convenience nor conditional. B. Made before the government incurs expenses, time, and effort in tracking down the offender's whereabouts, and C. Made to a person in authority or the latter's agents. Art 13, Mitigating Circumstances, Analogous Circumstances 1979 No. 4. X is charged with 1. Assaulting a policeman, and 2. Serious physical injury through reckless imprudence. The prosecution evidence shows that X, while driving his car, ran through a red light, hit a bystander along a street curve that caused his hospitalization for more than 30 days, and when arrested by a policeman, assaulted the arresting officer. The defense evidence shows that 3 days before the incident, X saw a doctor for treatment of a recurring back problem. He was prescribed Valium. X declared that on the day of the incident, the Valium had strange effects on him and that he completely lost control of himself. A medical expert testified that drowsiness, fatigue, ataxia, and confusion are the normal side effects of Valium. He added that hyperexcitability, though rare, was a possible side effect. If you were the judge, how would you decide the case? Answer. If I were the judge, I would hold X criminally liable. Loss of control of X as a result of the administration of the Valium is not an exempting circumstances, since there is no deprivation of freedom of action nor of intelligence. At most, X would be entitled to a mitigating circumstance analogous to passion or illness, since there is loss of self-control and reason. Art 13, PAR 10. Art 13, Mitigating Circumstances, Applicability in Special Laws 1981 No. 6. An accused was charged with illegal possession of a caliber .45 pistol. Upon arraignment, he pleaded guilty to the charge and invoked his plea as a mitigating circumstance. Can the court consider that plea as a mitigating circumstance in imposing the proper penalty on him? Why? Answer. The plea of guilty cannot be considered a mitigating circumstance. Alleged possession of a firearm is punished by a special law. The imposition of the penalty provided in a special law rests upon the discretion of the court. Furthermore, the plea of guilty as a mitigating circumstance under the revised Penal Code is appreciated only in a divisible penalty. It cannot be applied to a penalty which is indeterminate, that is, not divisible into periods of fixed duration, which is the penalty provided in special laws like the law punishing illegal possession of firearms. Art 13, Mitigating Circumstances, Applicability in Special Laws 1989 No. 8. Andres is charged with an offense defined by a special law. The penalty prescribed for the offense is imprisonment of not less than 5 years but not more than 10 years. Upon arraignment, he entered the plea of guilty. A. In the imposition of the proper penalty, should the indeterminate sentence law be applied? B. If you were the judge trying the case, what penalty would you impose on Andres? Answer. The plea of guilty cannot be considered as a mitigating circumstance in this case. The imposition of the indeterminate penalty in a special law rests upon the discretion of the court. Also, the pleas of guilty as a mitigating circumstance under the revised Penal Code is appreciated only in a divisible penalty. It cannot be applied to a penalty which is not divisible into periods of fixed duration, like the penalty provided in special laws. Art 13, Mitigating Circumstances, Immediate Vindication 1988 No. 13. A. The victim Dario went to the Civil Service Commission at about 11 a.m. to have some documents signed, and because his efforts were frustrated, he angrily remarked in the presence of the accused Benito that the Civil Service Commission is a hangout of thieves. The accused felt alluded to because he was then facing criminal and administrative charges on several counts involving his honesty and integrity, and pulling out a gun from his desk, he shot Dario, inflicting a fatal wound. Benito is now invoking the mitigating circumstances of immediate vindication of grave offense. Decide the case. Answer. A. The mitigating circumstances of immediate vindication of grave offense cannot be considered because to be applicable, Article 13 PAR 5 requires that, mitigating circumstances XXXX5. That the act was committed in the immediate vindication of a grave offense to the one committing the felony, delito, his spouse, ascendants, descendants, legitimate, natural or adopted brothers or sisters or relatives by affinity within the same degrees. Instead, the circumstances of passion or obfuscation should be considered. Benito should be charged with frustrated homicide with the mitigating circumstances of passion. Art 13, Mitigating Circumstances, Immediate Vindication 2000 No. 2. O Sang, a married woman in her early 20s, was sleeping on a banag on the floor of their nipa hut beside the seashore when she was awakened by the act of a man mounting her. Thinking that it was her husband, Gardo, who had returned from fishing in the sea, Osang continued her sleep but allowed the man, who was actually their neighbor, Julio, to have sexual intercourse with her. After Julio satisfied himself, he said "Salamat Osang" as he turned to leave. Only then did Osang realize that the man was not her husband. Enraged, Osang grabbed a balisong from the wall and stabbed Julio to death. When tried for homicide, Osang claimed defense of honor. Should the claim be sustained? Why? 5%. Suggested answer. No, Osang's claim of defense of honor should not be sustained because the aggression on her honor had ceased when she stabbed the aggressor. In Defense of Rights under Paragraph 1, Art. 11 of the RPC, it is required inter alia that there be, 1. Unlawful aggression, and, 2. Reasonable necessity of the means employed to prevent or repel it. The unlawful aggression must be continuing when the aggressor was injured or disabled by the person making a defense. But if the aggression that was begun by the injured or disabled party already ceased to exist when the accused attacked him, as in the case at bar, the attack made is a retaliation, and not a defense. Paragraph 1, Article 11 of the Code does not govern. Hence, Osang's act of stabbing Julio to death after the sexual intercourse was finished, is not defense of honor but an immediate vindication of a grave offense committed against her, which is only mitigating. Art. 13, Mitigating Circumstances, Incomplete Self-Defense 1990 No. 4. In the middle of the night, Inayong heard the footsteps of an intruder inside their house. Inayong picked up his rifle and saw a man, Goryo, with a pistol ransacking Inayong's personal effects in his study. He shot and killed Goryo. A. Is Inayong criminally liable for killing the robber Goryo? State your reasons. B. Suppose Inayong shot Goryo while he was running away from Inayong's house with his television set. What is Inayong liable for? Explain your answer. Answer. A. Inayong is not criminally liable because he was acting in defense of property rights. Under the case of People v. Narvaez, G.RNOSL 33466-67, April 20, 1983, 121 SCRA 389 defense of property need not necessarily be coupled with aggression against persons. B. There is criminal liability this time with the mitigating circumstance of incomplete self-defense. Under the case of People v. Narvaez, defense of property can be availed of even when there is no assault against a person. It is recognized as an unlawful aggression. Art. 13. Mitigating Circumstances, Minority 1985 No. 1. Minority is generally a privileged mitigating circumstance which entitles the minor offender to a suspended sentence. It may, however, under certain circumstances, be considered as a mere ordinary circumstance, in which case the offender may be immediately sentenced and made to serve the penalty imposed upon him instead of being placed under suspended sentence. Discuss. Answer. Minority as a privileged mitigating circumstance is considered in the imposition of the penalty, Art. 68, Revised Penal Code. However, the age of the minor at the time of the commission of the crime may be considered in suspending the sentence upon conviction. So under the Child and Youth Welfare Code, Presidential Decree 603, as amended, a minor under 18 years old at the time of the commission of the offense and at the time of the trial, if found guilty after trial, may apply for the suspension of the sentence. The only instance where There is no suspension of the sentence in spite of minority is that provided in Article 80 of the Revised Penal Code, where the minor under 16 years old at the time of the commission of a light felony, if found guilty, the sentence is immediately imposed. But Article 80 has been expressly repealed by Presidential Decree 1179, which took effect on August 15, 1977. As a matter of fact, the Supreme Court held in People v.S. Sanchez, 132 SCRA 103-1984, that there are only two instances where there can be no suspended sentence, to wit, 1. If the offense committed by a minor is punishable by death or life imprisonment. 2. If the minor is 18 years and above at the time of the commission of the offense and at the time of the trial. Art. 13, Mitigating Circumstances, Minority, Vindication 1993 No. 18. B. Who is blind in one eye, conspired with M., a 16-year-old boy, with C., who had been previously convicted of serious physical injuries, and with R., whose sister was raped by X a day before, to kill the latter. B, C, and R were armed with 38 caliber revolvers, while M carried no weapon and acted only as a lookout. They proceeded to the house of X riding in a motorized tricycle. Thereupon, C, on instruction of B to give X no chance, shot X, who was then sleeping. Indicted for homicide, as the information alleges no qualifying circumstance, specify the mitigating and aggravating circumstances present, and explain in whose favor, and against whom, must they be considered. Answer. 1. Mitigating circumstances. A. B is entitled to the mitigating circumstance under paragraph 8 of Article 13 of the Revised Penal Code. B. M is entitled to the privileged mitigating circumstances of minority under Article 68 of the Revised Penal Code. C. Vindication of a grave offense in favor of R because his sister was raped by X a day before the shooting, and even if there was an interval of 1 day between the rape and the killing. Art. 13, Mitigating circumstances, no intent to commit so grave a wrong, intoxication. 2000 No. 14. Despite the massive advertising campaign in media against firecrackers and gun firing during the New Year's celebrations, Jonas and Haja bought 10 boxes of Super Lolo and PLA in Baco, Bulacan. Before midnight of December 31, 1999, Jonas and Haja started their celebration by having a drinking spree at Jonas' place by exploding their high-powered firecrackers in their neighborhood. In the course of their conversation, Jonas confided to Haja that he has been keeping a long-time grudge against his neighbor Japoy in view of the latter's refusal to lend him some money. While under the influence of liquor, Jonas started throwing lighted Super Lolos inside Japoy's fence to irritate him, and the same exploded inside the latter's yard. Upon knowing that the throwing of the Super Lolo was deliberate, Japoy became furious and sternly warned Jonas to stop his malicious act or he would get what he wanted. A heated argument between Jonas and Japoy ensued, but Haja tried to calm down his friend. At midnight, Jonas convinced Haja to lend him his .45 caliber pistol so that he could use it to knock down Japoy and to end his arrogance. Jonas thought that after all, explosions were everywhere and nobody would know who shot Japoy. After Haja lent his firearm to Jonas, the latter again started throwing lighted Super Lolos and PLA Plus at Japoy's yard in order to provoke him so that he would come out of his house. When Japoy came out, Jonas immediately shot him with Haja's .45 caliber gun but missed his target. Instead, the bullet hit Japoy's 5-year-old son who was following behind him, killing the boy instantaneously. A. What crime or crimes can Jonas and Haja be charged with? Explain. 2%. B. If you were Jonas and Haja's lawyer, what possible defenses would you set up in favor of your clients? Explain. 2%. C. If you were the judge, how would you decide the case? Explain. 1%. Suggested answer. A. Jonas and Haja can be charged with the complex crime of attempted murder with homicide because a single act caused a less grave and a grave felony, art. 48 RPC. B. If I were Jonas and Hage's lawyer, I will use the following defenses. 1. That the accused had no intention to commit so grave a wrong as that committed, as they merely intended to frighten Japoy. 2. That Jonas committed the crime in a state of intoxication, thereby impairing his willpower or capacity to understand the wrongfulness of his act. Non-intentional intoxication is a mitigating circumstance, people us. Fordic, 281 SCRA 600, 1997, Art. 15, RPC. Art 13, Mitigating Circumstances, Plea of Guilty 1999 No X. A. In order that the plea of guilty may be mitigating, what requisites must be complied with? 2%. B. An accused charged with the crime of homicide pleaded not guilty during the preliminary investigation before the municipal court. Upon the elevation of the case to the regional trial court, the court of competent jurisdiction, he pleaded guilty freely and voluntarily upon arraignment. Can his plea of guilty before the RDC be considered spontaneous and thus entitle him to the mitigating circumstance of spontaneous plea of guilty under Art. 13, 7, RPC? 3%. Suggested answer. A. For plea of guilty to be mitigating, the requisites are: 1. That the accused spontaneously pleaded guilty to the crime charged, 2. That such plea was made before the court competent to try the case and render judgment, and 3. That such plea was made prior to the presentation of evidence for the prosecution. B. Yes, his plea of guilty before the regional trial court can be considered spontaneous, for which he is entitled to the mitigating circumstance of plea of guilty. His plea of not guilty before the municipal court is immaterial, as it was made during preliminary investigation only and before a court not competent to render judgment. Art. 13, Mitigating Circumstances, Plea of Guilty and Voluntary Surrender 1997 No. 5. After killing the victim, the accused absconded. He succeeded in eluding the police until he surfaced and surrendered to the authorities about 2 years later. Charged with murder, he pleaded not guilty, but, after the prosecution had presented 2 witnesses implicating him to the crime, he changed his plea to that of guilty. Should the mitigating circumstances of voluntary surrender and plea of guilty be considered in favor of the accused? Answer. 1. Voluntary surrender should be considered as a mitigating circumstance. After 2 years, the police were still unaware of the whereabouts of the accused and the latter could have continued to elude arrest. Accordingly, the surrender of the accused should be considered mitigating because it was done spontaneously, indicative of the remorse or repentance on the part of said accused, and therefore, by his surrender, the accused saved the government expenses, efforts, and time. Alternative answer. Voluntary surrender may not be appreciated in favor of the accused. 2 years is too long a time to consider the surrender as spontaneous, people us. Ablau, 183 SCRA 658. For sure the government had already incurred considerable efforts and expenses in looking for the accused. 2. Plea of guilty can no longer be appreciated as a mitigating circumstance because the prosecution had already started with the presentation of its evidence. Art. 13, PAR 7. Revised Penal Code. Art. 13, Mitigating, Voluntary Surrender, Plea of Guilty 1992 No. 5. Upon learning that the police wanted him for the killing of Polis Tico, Jeprox decided to visit the police station to make inquiries. On his way, he met a policeman who immediately served upon him the warrant for his arrest. During the trial, in the course of the presentation of the prosecution's evidence, Jeprox withdrew his plea of not guilty and entered a plea of guilty. Can he invoke the mitigating circumstances of voluntary surrender and plea of guilty? Explain. Suggested answer. Jeprox is not entitled to the mitigating circumstance of voluntary surrender, as his going to the police station was only for the purpose of verification of the news that he is wanted by the authorities. In order to be mitigating, surrender must be spontaneous and that he acknowledges his guilt. Neither is plea of guilty a mitigating circumstances because it was qualified plea. Besides, Art. 13. PAR 7 provides that confession of guilt must be done before the prosecution had started to present evidence. Aggravating circumstances. Art. 14, Aggravating Circumstances 1996 Number 2. 2. Jose, Domingo, Manolo, and Fernando, armed with bolos, at about 1 o'clock in the morning, robbed a house at a desolate place where Danilo, his wife, and 3 daughters were living. While the 4 were in the process of ransacking Danilo's house, Fernando, noticing that one of Danilo's daughters was trying to get away, ran after her and finally caught up with her in a thicket somewhat distant from the house. Fernando, before bringing back the daughter to the house, raped her first. Thereafter, the 4 carted away the belongings of Danilo and his family. A. What crime did Jose, Domingo, Manolo, and Fernando commit? Explain. B. Suppose, after the robbery, the 4 took turns in raping the 3 daughters of Danilo inside the latter's house, but before they left, they killed the whole family to prevent identification. What crime did the 4 commit? Explain. C. Under the facts of the case, what aggravating circumstances may be appreciated against the 4? Explain. Answer. 2. A. Jose, Domingo, and Manolo committed robbery, while Fernando committed complex crime of robbery with rape. B. The crime would be robbery with homicide because the killings were by reason, to prevent identification, and on the occasion of the robbery. The multiple rapes committed and the fact that several persons were killed. Homicide would be considered as aggravating circumstances. The rapes are synonymous with ignominy and the additional killing synonymous with cruelty. People vs Solis, 182 SCRA, People vs Plaga, 202 SCRA 531. C. The aggravating circumstances which may be considered in the premises are: I. Banned because all the 4 offenders are armed. 2. Noctumida because evidently the offenders took advantage of nighttime. 3. Dwelling, and 4. Uninhabited place because the house where the crimes were committed was at a desolate place and obviously the offenders took advantage of this circumstance in committing the crime. Art. 14, Aggravating Circumstances, Abuse of Confidence 1981 Number 5. H and W are husband and wife living in an apartment within the university belt. They took in S, a male student townmate, as a boarder. Before long, W and S fell in love with each other until one day H caught them in bed. If you were the investigating fiscal to whom H complained, what aggravating circumstance or circumstances would you allege in your information for adultery against W and S? Why? Answer. If I were the fiscal, I would allege as an aggravating circumstance that the crime was committed with abuse of confidence. Evidently, S was taken in as a boarder by the spouses M and W because he was their townmate. Such engendered trust and confidence in the relationship of the spouses with S. By committing adultery with W, abuse of confidence was availed of by S in the commission of the crime. Since he took advantage of the favorable position in which he was placed by the injured party as boarder in their house. US vs Barbicho 12 Philosophy 616. Dwelling cannot be alleged as an aggravating circumstance because the wife and the paramour were living in the same house where they had a right to be. US vs Distrito et al. 23 Philosophy 23. Art. 14, Aggravating Circumstances, Abuse of Superior Strength 1978 No 3b. A wealthy 65-year-old landed proprietor, haciendero, with failing eyesight and defective hearing who has been a tubercular patient for the last 10 years, was robbed and killed in cold blood while asleep. A was found guilty as principal, B and C as his accomplices. In passing sentence, the judge considered abuse of superior strength as aggravating circumstance correctly appreciated against the 3. Explain. Answer. There is no abuse of superior strength since A participated in the commission of the crime as principal and B and C as accomplices. This is inconsistent, since the offenders did not take advantage of their combined strength in the commission of the crime. People vs. Cortez, 56 Philosophy 143. Art 14, Aggravating Circumstances, Abuse of Superior Strength, Dwelling 1976 No IA. At about midnight, the accused, attacked fatally an unarmed, 4 feet, 11 inches girl with a hunting knife while she was alone in her room. What aggravating circumstance or circumstances were present in the commission of the crime? Reason. Answer. Abuse of superior strength and dwelling. There is abuse of superior strength because the girl was defenseless since she was unarmed and A was armed with a hunting knife, which is a deadly weapon. The abuse of superiority of A lies in his sex and the weapon he used, from which the woman would be unable to defend herself. USU Consuelo, 13 Philosophy 612. Dwelling is also an aggravating circumstance because the girl was attacked in her room. The facts of the problem do not show that she has given any provocation. People v. Paca, 81 Philosophy 426. Art 14, Aggravating Circumstances, Cruelty 1985 No. 4. A case of murder was filed against MN for killing XY, solely on the basis of a finding that XY sustained more than 200 stab wounds, only 3 of which were fatal. Discuss the propriety of the charge filed against MN. Answer. The charge for murder against MN is not tenable. Any qualifying circumstance of murder cannot be inferred but must be proved satisfactorily and conclusively as the act itself. The fact that the victim sustained more than 200 stab wounds, of which only 3 were fatal, does not indicate cruelty as a qualifying circumstance of murder. Cruelty requires deliberate prolongation of suffering of the victim. The number of wounds in itself does not show cruelty as it is essential to prove that the wounds were inflicted unnecessarily while the victim was alive to prolong his physical suffering. In cruelty, the wrong done in the commission of the crime is deliberately augmented by causing other wrongs not necessary in the commission of the crime. Cruelty cannot be presumed. People vs. Ardienda 90 SCRA 944. Scoffing or outraging at the corpse of the victim cannot also be invoked as the facts do not show that wounds were inflicted when the victim was already dead or in what part of the body were the wounds inflicted. Besides, being a qualifying circumstance, it cannot also be presumed. Art 14, Aggravating Circumstances, Cruelty 1988 No. 13. B. The robbers killed a mother and her baby, then threw the body of the baby outside the window. Can the aggravating circumstances of cruelty be considered in this case? Reasons. Answer. B. Cruelty cannot be considered in this case because the aggravating circumstance of cruelty requires deliberate prolongation of the suffering of the victim. In this case, the baby was dead already so that there is no more prolongation to speak of. Art 14, Aggravating Circumstances, Cruelty, Relationship 1994 No. 8. Ben, a widower, driven by bestial desire, poked a gun on his daughter Zenny, forcibly undressed her and tied her legs to the bed. He also burned her face with a lighted cigarette. Like a madman, he laughed while raping her. What aggravating circumstances are present in this case? Answer. A. Cruelty, for burning the victim's face with a lighted cigarette, thereby deliberately augmenting the victim's suffering by acts clearly unnecessary to the rape, while the offender delighted and enjoyed seeing the victim suffer in pain. People vs. Lucas, 181 SCRA 316. B. Relationship, because the offended party is a descendant, daughter, of the offender and considering that the crime is one against chastity. Art 14, Aggravating Circumstances, Evident Premeditation, Treachery, Nighttime, Unlawful Entry 1997 Number 3. The accused and the victim occupied adjacent apartments, each being a separate dwelling unit of one big house. The accused suspected his wife of having an illicit relation with the victim. One afternoon, he saw the victim and his wife together on board a vehicle. In the evening of that day, the accused went to bed early and tried to sleep, but being so annoyed over the suspected relation between his wife and the victim, he could not sleep. Later in the night, he resolved to kill victim. He rose from bed and took hold of a knife. He entered the apartment of the victim through an unlocked window. Inside, he saw the victim soundly asleep. He thereupon stabbed the victim, inflicting several wounds, which caused his death within a few hours. Would you say that the killing was attended by the qualifying or aggravating circumstances of evident premeditation, treachery, nighttime and unlawful entry? Answer. 1. Evident premeditation cannot be considered against the accused because he resolved to kill the victim later in the night and there was no sufficient lapse of time between the determination and execution, to allow his conscience to overcome the resolution of his will. 2. Treachery may be present because the accused stabbed the victim while the latter was sound asleep. Accordingly, he employed means and methods which directly and specially ensured the execution of the act without risk himself arising from the defense which the victim might have made. People vs. D'Aquina 60 Philosophy 279 People vs. Miranda, et at 90 Philosophy 91. 3. Nighttime cannot be appreciated because there is no showing that the accused deliberately sought or availed of nighttime to ensure the success of his act. The intention to commit the crime was conceived shortly before its commission. People vs. Pardo 79 Phil. 568. Moreover, nighttime is absorbed in treachery. 4. Unlawful entry may be appreciated as an aggravating circumstance, inasmuch as the accused entered the room of the victim through the window, which is not the proper place for entrance into the house. Art. 14 Par 18. Revised Penal Code, People vs. Barga 61 Philosophy 318. Art. 14, Aggravating Circumstances, Generic vs. Qualifying 1984 Number 13. From the standpoint of legal, effect and weight, how would you distinguish generic aggravating from qualifying circumstances? Answer. A. Furnished by Office of Justice Palma. 1. A generic aggravating circumstance can be offset by an ordinary mitigating circumstance which is not so in qualifying circumstance. 2. A qualifying aggravating circumstance cannot be proved as such unless alleged in the information, whereas a generic aggravating circumstance may be proved even though not alleged. 3. A generic aggravating circumstance increases the penalty to the maximum but not beyond that provided by law, whereas a qualifying aggravating circumstance changes the nature and even the name of the offense to one more serious. B. Comments and suggested answer. Generic aggravating and qualifying circumstances are distinguished as to legal effect and weight, as follows. 1. A generic aggravating circumstance can be offset by an ordinary mitigating circumstance which is not so in a qualifying circumstance. 2. A qualifying circumstance cannot be proved unless alleged in the information, whereas a generic aggravating circumstance may be proved even though not alleged. 3. A generic aggravating not offset has the effect of increasing the penalty to the maximum but not beyond that provided by law. A qualifying circumstance changes not only the nature but also the name of the crime and the offender becomes liable for the new offense which is more serious in nature. Art. 14, Aggravating Circumstances, Kinds 1999 No. 9. A. Name the four kinds of aggravating circumstances and state their effect on the penalty of crimes and nature thereof. 3%. B. Distinguish generic aggravating circumstance from qualifying aggravating circumstance. C. The charge against the accused was raised to murder on the basis of the allegation in the information of the qualifying circumstances of treachery and evident premeditation, both of which circumstances were supported by evidence. Murder was proved during the trial, but the accused proved the mitigating circumstance of voluntary surrender. Should the accused be entitled to the minimum of the penalty for murder? 3%. Suggested answer. A. The four kinds of aggravating circumstances are: 1. Generic aggravating, or those that can generally apply to all crimes, and can be offset by mitigating circumstances, but if not offset, would affect only the maximum of the penalty prescribed by law. 2. Specific aggravating, or those that apply only to particular crimes and cannot be offset by mitigating circumstances. 3. Qualifying circumstances, or those that change the nature of the crime to a graver one, or brings about a penalty next higher in degree, and cannot be offset by mitigating circumstances. 4. Inherent aggravating, or those that essentially accompany the commission of the crime and does not affect the penalty whatsoever. B. Generic aggravating circumstances. 1. Affects only the imposition of the penalty prescribed, but not the nature of the crime committed. 2. Can be offset by ordinary mitigating circumstances. 3. Need not be alleged in the information as long as proven during the trial, the same shall be considered in imposing the sentence. Qualifying circumstances. 1. Must be alleged in the information and proven during trial. 2. Cannot be offset by mitigating circumstances. 3. Affects the nature of the crime or brings about a penalty higher in degree than that ordinarily prescribed. Art. 14. Aggravating circumstances, must be alleged in the information 2006. B. Rico, a member of the Alpha Rho fraternity, was killed by Pocolo, a member of the rival group, Sigma Phi Omega. Pocolo was prosecuted for homicide before the regional trial court in Binan, Laguna. During the trial, the prosecution was able to prove that the killing was committed by means of poison in consideration of a promise or reward and with cruelty. If you were the judge, with what crime will you convict Pocolo? Explain. 2%. Suggested answer. B. Pocolo should be convicted of the crime of homicide only because the aggravating circumstances which should qualify the crime to murder were not alleged in the information. The circumstances of using poison, in consideration of a promise or reward, and cruelty which attended the killing of Rico could only be appreciated as generic aggravating circumstances since none of them have been alleged in the information to qualify the killing to murder. A qualifying circumstance must be alleged in the information and proven beyond reasonable doubt during the trial to be appreciated as such. Art. 14. Aggravating circumstances, need to be alleged 1982 number 18. A. Is prosecuted for homicide under proper information. At the time of the trial, it was established that the crime was committed with treachery, premeditation, at nighttime and with abuse of superior strength. A. If you were the judge, what crime should you convict A of? Why? B. How would you dispose of the circumstances stated above? Answer. B. Treachery, premeditation, nighttime, abuse of superior strength do not appear to be alleged in the information. Treachery, which absorbs nighttime and abuse of superior strength, and evident premeditation will be considered as generic aggravating circumstances. Art. 14. Aggravating circumstances, nighttime, Band 1994 number 9. At about 9:30 in the evening, while Dino and Rafi were walking along Padre Farias Street, Manila, Johnny hit them with a rock, injuring Dino at the back. Rafi approached Dino, but suddenly, Bobby, Steve, Danny and Nonoe surrounded the duo. Then Bobby stabbed Dino. Steve, Danny, Nonoe and Johnny kept on hitting Dino and Rafi with rocks. As a result, Dino died. Bobby, Steve, Danny, Nonoe and Johnny were charged with homicide. 1. Is there conspiracy in this case? 2. Can the court appreciate the aggravating circumstances of nighttime and band? Answer. 2. No, nighttime cannot be appreciated as an aggravating circumstance because there is no indication that the offenders deliberately sought the cover of darkness to facilitate the commission of the crime or that they took advantage of nighttime. People vs. De Los Reyes, 203 SCRA 707. Besides, judicial notice can be taken of the fact that Padre Farias Street is well lighted. However, banned should be considered as the crime was committed by more than 3 armed malefactors. In a recent Supreme Court decision, stones or rocks are considered deadly weapons. Art. 14, Aggravating Circumstances, Recidivism 2001 No. 3. Juan de Castro already had three previous convictions by final judgment for theft when he was found guilty of robbery with homicide. In the last case, the trial judge considered against the accused both recidivism and habitual delinquency. The accused appealed and contended that in his last conviction, the trial court cannot consider against him a finding of recidivism and, again, of habitual delinquency. Is the appeal meritorious? Explain. 5%. Suggested answer. No, the appeal is not meritorious. Recidivism and habitual delinquency are correctly considered in this case because the basis of recidivism is different from that of habitual delinquency. Juan is a recidivist because he had been previously convicted by final judgment for theft and again found guilty for robbery with homicide, which are both crimes against property, embraced under the same title, Title 10, Book 2 of the Revised Penal Code. The implication is that he is specializing in the commission of crimes against property, hence aggravating in the conviction for robbery with homicide. Habitual delinquency, which brings about an additional penalty when an offender is convicted a third time or more for specified crimes, is correctly considered. Art. 14, Aggravating Circumstances, Recidivism 1983 No. 8. 3 persons A, B and C were found guilty of homicide. Each of them had been previously convicted of an offense, A for robbery, B for estafa, and C for frustrated murder. In the homicide case, against whom may the aggravating circumstance of recidivism be appreciated? Why? Answer. Only against C. The reason is homicide, for which A, B and C were found guilty, is embraced in the same title of the code as frustrated homicide, for which C had been previously convicted. Recidivism is a personal cause which should affect only C to whom it is attendant. Art. 62, Par 3. Art. 14, Aggravating Circumstances, Recidivism vs Habitual Delinquency 1986 No. 5. Give at least 4 distinctions between habitual delinquency and recidivism. Can a person be a habitual delinquent without being a recidivist? Explain. Answer. The 4 distinctions between habitual delinquency and recidivism are: 1. In habitual delinquency, the crimes are specified, which are robbery, theft, estafa, falsification, serious and less serious physical injuries. In recidivism, the crimes are embraced in the same title of the Revised Penal Code. 2. In recidivism, no period of time is fixed between the former conviction and the last conviction. In habitual delinquency, conviction of any of the specified crimes must take place within 10 years from the last conviction or release. 3. In recidivism, it is enough that there be a second conviction of any crime embraced in the same title of the last or the first crime. In habitual delinquency, there must be at least a third conviction of any of the specified crimes. 4. Recidivism is an aggravating circumstance and if not offset serves to increase the penalty. Habitual delinquency provides for the imposition of an additional penalty. There may be habitual delinquency without recidivism if the 3 convictions refer to crimes not embraced in the same title code, like robbery in the first conviction, a crime against property, falsification, the second conviction, a crime against public interest and serious physical injuries, the third conviction, a crime against persons. Art. 14, Aggravating Circumstances, Recidivism vs Habitual Delinquency 1983 No. 3. X already had 3 previous convictions by final judgment for theft when he was found guilty of robbery with homicide. In the last case, the trial judge considered against X both recidivism and habitual delinquency. X appealed, contending that conviction for one crime cannot twice be considered against the accused, once for the purpose of using it as basis for a finding of recidivism, and again, to establish habitual delinquency. Resolve with reasons. Answer. The appeal is not meritorious. Recidivism and habitual delinquency have different legal effects. In the conviction for robbery with homicide, recidivism is appreciated as an aggravating circumstance because the previous convictions for theft are embraced in the same title of the code as robbery with homicide, which are crimes against property. Habitual delinquency is also considered because of the 3 previous convictions by final judgment for theft, for the imposition of the additional penalty. Art. 14, Aggravating Circumstances, Recidivism vs. Quasi-Recidivism 1998 No. 8. To distinguish between recidivism and quasi-recidivism. 2% answer, 2 in recidivism. A. The convictions of the offender are for crimes embraced in the same title of the revised penal code, and B. This circumstance is generic aggravating and therefore can be effected by an ordinary mitigating circumstance. Whereas in quasi-recidivism, A. The convictions are not for crimes embraced in the same title of the revised penal code, provided that it is a felony that was committed by the offender before serving sentence by final judgment for another crime or while serving sentence for another crime, and B. This circumstance is a special aggravating circumstance which cannot be offset by any mitigating circumstance. Art. 14, Aggravating Circumstances, Recidivism, Habituality 1989 No. 4. Andres was earlier convicted of adultery and served an indeterminate penalty, the maximum term of which did not exceed 2 years, 4 months and 1 day of prison correctional. A month after his release from prison, he was charged with the crime of serious physical injuries. Later, Andres was again charged with homicide punishable by re-illusion temporal. He entered a plea of guilty in the homicide case. May the aggravating circumstances of recidivism and/or habituality, reiteration, be appreciated against Andres. Explain. Answer. The aggravating circumstance of recidivism cannot be taken against Andres. For this circumstance to exist, it is necessary that 1. The offender is on trial for an offense. 2. He was previously convicted by final judgment of another crime. 3. Both the first and second offenses are embraced in the same title of the code, and 4. The offender is convicted of the new offense, Art. 14, PAR 9 RPC. At the time of his trial for homicide, Andres was not previously convicted by final judgment of another crime embraced in the same title of the revised penal code. Adultery, which is his only previous conviction by final judgment, is a crime against chastity, and therefore is not embraced in the same title of the code as homicide, which is a crime against person. As for the charge of serious physical injuries, although serious physical is also a crime against person, it appears that he had not as yet been convicted, much less by final judgment, of the charge at the time that he was facing trial for homicide. The aggravating circumstance of habituality or reiteration can likewise not be taken against Andres because in order that this circumstance can exist, it is necessary that he was facing trial for homicide. The aggravating circumstance of habituality or reiteration can likewise not be taken against Andres because in order for this circumstance to exist, it is necessary that 1. The accused is on trial for an offense. 2. He previously served sentence for another offense to which the law attaches an equal or greater penalty, or for 2 or more crimes to which it attaches a lighter penalty than that for the new offense. 3. He is convicted of the new offense. In the case at bar, Andres had previously served sentence only for one offense, that of adultery, but the penalty for adultery, prison correctional, is lighter than the penalty for homicide, reclusion temporal. Consequently, there is no aggravating circumstance of habituality or reiteration. Art. 14, Aggravating Circumstances, Recidivism, Motor Vehicle, Treachery 1993 No. 18. B, who is blind in one eye, conspired with M, a 16-year-old boy, with C, who had been previously convicted of serious physical injuries, and with R, whose sister was raped by X a day before, to kill the latter. B, C, and R were armed with .38 caliber revolvers, while M carried no weapon and acted only as a lookout. They proceeded to the house of X riding in a motorized tricycle. Thereupon, C, on instruction of B to give X no chance, shot X, who was then sleeping. Indicted for homicide, as the information alleges no qualifying circumstance, specify the mitigating and aggravating circumstances present, and explain in whose favor, and against whom, must they be considered. Answer. 2 aggravating circumstances. A. The aggravating circumstance of recidivism under paragraph 9, Article 14 should be considered against C if alleged in the information, People vs. Peter Vita, et al., G.R. Noel 94528. March 1, 1993. B. The aggravating circumstance of motor vehicle under paragraph 20 of Article 14 of the Code, all the accused having used a motorized tricycle. C. Treachery should be aggravating against all of the accused, including M, who acted as a lookout because all of them were present when X was shot. Article 62, paragraph 4 of the Revised Penal Code. X was sleeping when shot to death. Art 14, aggravating circumstances, treachery 1979 No 11. X was slapped by Z in front of many people. X went to his house, got a knife and waited for Z, who was gambling in the upper floor of a house. When Z came down the house, X approached him from behind to stab him. Somebody shouted to warn Z, and Z was able to turn around on time to parry the stab of X. The two fought each other until Z, while in process of retreating, fell in a canal, face upward. X then mounted him and succeeded in stabbing Z fatally. Is there treachery? Answer. Treachery is not present. While it is true that X approached Z from behind to stab him, Z, however, was not deprived of any opportunity to defend himself because of the warning from somebody, and as a matter of fact because of it he was able to turn around in time to parry the stab of X. He was not deprived of an opportunity to defend himself. The stabbing of the victim by X, who mounted him when he fell in a canal face upward as a result of the fight which followed when the victim was able to parry the stab of X, does not constitute treachery, since it was a mere continuation of the fight. It was spontaneous and a mere incident of the fight. Art 14, aggravating circumstances, treachery 1980 No 15. In the course of a fight, the accused assaulted the victim with a knife, inflicting upon the latter a serious cut on his left arm, prompting the said victim to run and flee. He was pursued by the accused. After having fled for a short distance, the victim fell on the ground, face downward, and before he could stand, the accused delivered a fatal stab with his knife on the back of the victim. What crime did the accused commit? Answer. Since the accused assaulted the victim with a knife in the course of a fight, it cannot be said that the attack was treacherous because the victim would have been placed on his guard. People, vs. Gonzalez, 76 Philosophy 473, People vs. Artiza, 55 SCKA 345. Besides, from the location of the wound of the victim, which was on his left arm, it can reasonably be inferred that the attack was frontal. Treachery cannot be presumed but must be proved conclusively as the crime itself. So, the inception of the attack was not attended by treachery. When the victim, after having been seriously wounded, ran and was pursued by the accused, fell on the ground, face downward, was fatally stabbed on the back, the accused acted spontaneously. The stabbing at the back was a continuation of the fight, and if the fight is continuous, even if treachery is present at the latter stage of the fight, treachery cannot be appreciated as attendant. People vs. Kaint, 44 Philosophy 478. Art 14, aggravating circumstances, treachery 1984 No. 14. Aside from the procedural requirements, what are the other requisites for treachery to be considered as a qualifying circumstance? Answer. A. Furnished by Office of Justice Palma. 1. By employment of means, method, or manner of execution which would ensure the offender's safety front any defensive retaliatory act on the part of the offended party. 2. By the fact that such means, method, or manner of execution was deliberately or consciously chosen. B. Comments and suggested answer. The other requisites of treachery as a qualifying circumstance aside from the procedural requirements are: 1. Employment of means, method, or manner of execution which would ensure the offender's safety from any defensive or retaliatory act on the part of the offended party, which means no opportunity is given to the latter to defend himself or retaliate, and 2. Such means, method, or manner of execution was deliberately or consciously chosen. People vs. Barnio, L. 64164, June 22, 1934, 129 SCRA 725. Art. 14, Aggravating Circumstances, Treachery 1993 No. 6. As a result of a misunderstanding during a meeting, Joe was mauled by Nestor, Jolin, Reedon, and Arthur. He ran towards his house but the four chased and caught him. Thereafter, they tied Joe's hands at his back and attacked him. Nestor used a knife, Jolin, a shovel, Arthur, his fists, and Reedon, a piece of wood. After killing Joe, Reedon ordered the digging of a grave to bury Joe's lifeless body. Thereafter, the four left together. Convicted for the killing of Joe. Arthur now claims that his conviction is erroneous as it was not he who inflicted the fatal blow. 1. Would you sustain his claim? Why? 2. What was the crime committed by the four assailants? Discuss with reasons. Answer. 1. No. Arthur's claim is without merit. The offenders acted in conspiracy in killing the victim and hence, liable collectively. 2. The crime committed is murder, qualified by treachery because the offenders, taking advantage of their superiority in number, rendered the victim defenseless and without any chance to retaliate, by tying his hands at his back before attacking him. Treachery exists at least in the second and final stage of the attack, after the offenders caught up with the victim. Art. 14, Aggravating Circumstances, Treachery and Abuse of Superior Strength 1992 No. 3. As Sergio, Yoyong, Zoolo, and Warlato engaged in a drinking spree at Heartthrob Disco, Special Police Officer 3, SPO 3, Manolo Yabang suddenly approached them, aimed his revolver at Sergio whom he recognized as a wanted killer and fatally shot the latter. Whereupon, Yoyong, Zoolo and Warlato ganged up on Yabang. Warlalo, using his own pistol, shot and wounded Yabang. A. What are the criminal liabilities of Yoyong, Zoolo, and Warlato for the injury to Yabang? Was there conspiracy and treachery? Explain. B. In turn, is Yabang criminally liable for the death of Sergio? Suggested answer. A. Treachery cannot likewise be appreciated as there was no conscious adoption of means, methods, or form to facilitate the commission of the felony. B. Yabang is liable for homicide for the killing of Sergio as the attack was frontal, alternative, murder, because of the qualifying circumstance of abuse of superior strength, in terms of weapon. Sergio, being a suspected killer, is no justification to be killed by Yabang, People vs. Oanese. Art. 14, Aggravating Circumstances, Treachery, Nighttime, Superior Strength and Uninhabited Place. 1982 No. 6. A. A suitor of girl B, saw the latter at about midnight walking along a dark and deserted alley near her house. A sneaked up to her, grabbed her breasts from behind, kissed her, and at the same time raised her dress. At that moment, a noise was heard frightening A, who immediately ran away. If you were the fiscal, for what crime would you prosecute A? Would you allege treachery, nighttime, superior strength and uninhabited place as aggravating circumstances? Reasons. Answer. The crime committed is acts of lasciviousness. Stealthily kissing, embracing, and fondling the breast of complainant and raising her dress constitute lewd or lascivious acts. People vs. Yabut, CAG.R, No 2550R August 5, 1960. More so, as the acts were committed at midnight and in a dark and deserted alley although near the house of the girl. Treachery is not present because this aggravating circumstance applies only to crimes against persons. Acts of lasciviousness is a crime against chastity. Nighttime is not present because the facts do not show that the accused took advantage of the darkness of the night to facilitate the commission of the crime to ensure immunity from capture. Superior strength is not aggravating because mere physical superiority is not taking advantage of superior strength. It is necessary to prove the relative strength of the parties. People vs. Bustos, 51 Phil 385. Uninhabited place is also not present because the place of the commission of the crime was near the house of the offended party, and the fact that A heard some noise which frightened him show that the place was not uninhabited. Besides, the facts do not show that the place was purposely chosen for the easy and uninterrupted accomplishment of the crime. People vs. Luneta et ed. 45 OG 2832. Art 14, Aggravating circumstances, treachery, evident premeditation, nocturnity. 1991 Number 10. In an information for murder against A, B, and C, the prosecution alleges treachery as the qualifying circumstance and the following generic aggravating circumstances: L. Nocturnity. 2. Abuse of superior strength, and 3. Employing means to weaken the defense. At the trial, the prosecution, without objection from the de officio counsel for the accused, proved evident premeditation. It likewise successfully proved the qualifying and the generic aggravating circumstances alleged in the information. A. For the purpose of determining the appropriate penalty to be imposed upon the accused, may the court take into account evident premeditation and the other generic aggravating circumstances? Answer. A. Yes, as far as evident premeditation is concerned, but only as a generic aggravating circumstance. Since treachery absorbs nocturnity, abuse of superior strength and employing means to weaken the defense, they can no longer be considered as additional circumstances. B. Supposing that treachery was not proved, may evident premeditation, which was duly proved, be considered as the qualifying circumstances? Answer. B. No, since it was not alleged in the information, qualifying circumstances not alleged if proved during trial will only be considered as generic. C. If the prosecution failed to prove treachery and did not offer any evidence to prove evident premeditation, does acquittal of the accused follow? Answer. C. No, but liability will only be for homicide, as there is no circumstances to qualify it to murder. Alternative circumstances. Art 15, Alternative circumstances, Intoxication 1978 No 7b. A. Not being used to liquor, became drunk at a party. When he reached home, with the help of his friends, B and C, his wife W berated him so harshly, and a violent quarrel ensued. He squeezed her neck, banged her head against the wall and kicked her repeatedly in the stomach. The next day, W vomited profusely and died thereafter. Cause of death was established to be hemorrhage caused by A's assault upon his wife. During the trial, A's counsel argued that A did not have the intention to kill his wife and alleged intoxication as an exempting circumstance. Decide with reasons. Answer. The intoxication was not habitual as A was not used to liquor. He only became drunk during a party, and so the intoxication was not subsequent to the plan to commit the crime. It is not exempting but an alternative mitigating circumstance. Since intoxication involves loss of reason and self-control, A could not have any intention to kill his wife. A is liable for parricide. The mitigating circumstances of intoxication and lack of intent to commit so grave a wrong as that which resulted cannot, however, be appreciated in his favor to lower the penalty by 1 degree, because the penalty for parricide consists of 2 single and indivisible penalties which are reclusion perpetuate to death. Art 246, Art 63, Revised Penal Code, People vs. Monleon, 74 SCRA 263. Art 15, Alternative circumstances, Intoxication 2002 No I. A was invited to a drinking spree by friends. After having had a drink too many, A and B had a heated argument, during which A stabbed B. As a result, B suffered serious physical injuries. May the intoxication of A be considered aggravating or mitigating? 5%. Suggested answer. The intoxication of A may be prima facie considered mitigating since it was merely incidental to the commission of the crime. It may not be considered aggravating as there is no clear indication from the facts of the case that it was habitual or intentional on the part of A. Aggravating circumstances are not to be presumed, they should be proved beyond reasonable doubt. Persons criminally liable for felonies. Art. 16, Degree of Participation 1976 No. 2a. X, after promising Y to give him P10,000.00, induced the latter, Y, to kill Z, who at the time was vacationing in an isolated island in the sea which can easily be reached by a boat. W, who owns the only motor boat in the locality, offered to transport and actually transported Y to said island. Upon reaching the island, Y killed Z, indicate whether X, Y, and W is a principal or accomplice in the commission of the crime. Reason. Answer. X is a principal by inducement. By promising to give Y P10.00 to kill Z, which is an agreement for a consideration, the inducement was made directly with the intention of procuring the commission of the crime. Further, the facts show that Y has no personal reason to kill Z except the inducement, which is therefore the determining cause for the commission of the crime by Y. People v. Kiichi, 61 Philosophy 609. Y is a principal by direct participation because he killed Z pursuant to the inducement or agreement for a consideration and he, therefore, personally took part in the execution of the act constituting the crime. Art.17, PAR 1. W is neither a principal nor an accomplice. Although W offered and actually transported Y to the island where Z was vacationing as he owns the only motor boat in the locality, the facts of the problem do not show that W has any knowledge of the criminal design nor purpose of Y to be a principal by indispensable cooperation. It is essential that there be either anterior conspiracy or unity of criminal purpose and intention immediately before the commission of the crime. This means participation in the same criminal resolution of Y, the principal by direct participation. W is not a principal by direct participation because he did not participate directly in the execution of the act constituting the crime. Clearly, he also is not a principal by inducement because he did not induce Y to kill Z. W is not an accomplice because he has also no knowledge of the criminal design of Y, the principal by direct participation. If W has knowledge of the criminal purpose of Y, then he will be a principal by indispensable cooperation because he cooperated in the commission of the crime by Y, which is the transporting of Y to the island in his boat, which is the only one in the locality, without which the crime would not have been accomplished. Art. 17, PAR 3. Art. 16, Degree of Participation 1984 No. 1. A kidnapped a boy and demanded a ransom of P100,000 from the boy's parents. In time, the ransom was paid and the victim was released. When X, A's adopted sister, learned that A was being hunted by the police for kidnapping, she took him into her house and concealed him. A was thus able to elude the police. Did X incur any criminal responsibility? Explain. Answer. A furnished by Office of Justice Palma. X has no criminal liability. She is not a principal because she did not take part in the commission of the act, or induce another to commit, or cooperated in the commission of the offense by another act without which it will not have been accomplished. Art. 17, 12 RPC. Neither is she an accomplice because she did not cooperate in the execution of the offense by previous or simultaneous acts. Art. 18. She is not also an accessory because, although she harbored, or concealed, or assisted in the escape of the principal, the crime is not treason, parricide, murder or an attempt to take the life of the chief executive or the author thereof is known to be habitually guilty of same other crime. Art. 19, 3 RPC. A comments and suggested answer. X did not incur any criminal liability. X learned that A was being hunted by the police for kidnapping and so being an adopted sister, she took A in her house and concealed him, thus enabling him to elude the police. X cannot be a principal nor accomplice because her participation is subsequent to the commission of the crime. Being a private person, she is also not an accessory, as the crime of kidnapping is not included among the cases where such private person harbors, conceals, or assists in the escape of the author of the crime who is guilty of treason, parricide, murder, attempt against the life of the chief executive or is known to be habitually guilty of some other crime. Art 19, PAR 3, Revised Penal Code. Art 16, Degree of Participation 1987 No I. Juan had a land dispute with Pedro for a number of years. As Juan was coming down his house, he saw his brother, Rodolfo, attack Pedro with a bolo from behind. Rodolfo was about to hit Pedro a second time while the latter was prostrate on the ground, when Carling, Pedro's son, shouted, "I'll kill you." This distracted Rodolfo, who then turned to Carling. Rodolfo and Carling fought with their bolos. While the two were fighting, Juan shouted to his brother Rodolfo, "Kill them both, they are our enemies." Carling suffered a number of wounds and died on the spot. Pedro, who was in serious condition, was rushed to the hospital. He died 5 days later for loss of blood because the blood purchased from Manila, which could have saved him, according to the doctor, did not arrive on time. Jose, father of Juan and Rodolfo, told his sons to hide in Manila and he gave them money for the purpose. When the police investigators saw Jose, he told the police investigators that Juan and Rodolfo went to Mindanao. What crimes, if any, did A. Rodolfo, B. Juan and C. Jose commit? Explain your answer and state whether the acts committed are accompanied by circumstances affecting criminal liability. Answer. A. Rodolfo committed murder regarding the killing of Pedro since Pedro was attacked from behind. The killing was attended by the qualifying circumstance of treachery. The mode of attack deprived Pedro of any chance to defend himself or to retaliate. Rodolfo is also liable for homicide regarding the killing of Carling, Pedro's son, as that is the result of a fight, both of them being armed with bolos. Although Pedro died 5 days later, since the blood purchased which would have saved him did not arrive on time, Rodolfo is still liable for the death of Pedro, as that is the direct, natural, and logical result of the wound inflicted by him. B. Juan, the brother of Rodolfo, has no criminal liability. What he shouted to Rodolfo, "Kill them both, they are our enemies," when Rodolfo and Carling were fighting, was not the only reason why Carling was killed, and hence, he cannot be a principal by inducement. The doctrine is to be a principal by inducement, the inducement must be the only reason why the crime is committed. People vs. Kiichi et al. 61 Philosophy 609. C. Jose, father of Juan and Rodolfo, is an accessory to the crime of murder committed by Rodolfo because he assisted him to escape to Manila. But he is not criminally liable because of his relationship to Rodolfo, Article 20. He is not an accessory to the crime of homicide, because this crime is not included in treason, parricide, murder, attempt against the life of the chief executive or the principal is known to be habitually guilty of some other crime if the accessory is a private person. However, this is moot and academic because of the relationship of Jose to Rodolfo. Art 16, Degree of Participation 1989 Number 15. Emilio and Andres were walking home from the farm at 8 o'clock in the evening when they met Diong, whom Emilio suspected as the one who stole his fighting cock 2 days before. Emilio confronted Diong and after a heated discussion, a bolo fight between the two ensued. Diong sustained fatal wounds and died. Emilio asked Andres to help him carry the body of Diong and bury it behind the bushes. After burying Diong, Emilio picked up TB jute bag Diong was then holding and found inside P600, which Emilio and Andres divided, each getting P300. A week after the investigation by the police, a complaint was filed in the Office of Provincial Fiscal against Emilio and Andres for robbery with homicide with the aggravating circumstances of nighttime and uninhabited place. If you were the fiscal, what information or informations will you file against Emilio and Andres? What are their respective criminal liabilities? Answer. If I were the fiscal, I would file two separate informations against Emilio and Andres, one for homicide with Emilio as principal and Andres as accessory, and another for theft against both Emilio and Andres as principals. This is so because of the following reasons. 1. The killing of Diong by Emilio is homicide. It is not attended by any qualifying circumstance of murder. It was a killing at the spur of the moment, in the course of a bolo fight, as an aftermath of a heated discussion. 2. Neither was the killing by reason of or on the occasion of a robbery. There was no intention of either Emilio or Andres to rob Diong either prior to or in the course of the killing. The taking of Diong's P600 was only an afterthought, after the killing was already perpetrated. There is no causal or other connection between the act of killing and the act of taking the money. 3. Andres is liable as an accessory in the homicide case because he had no participation either as co-principal or accomplice in the killing of Diong, who died solely because of the wounds inflicted on him in his bolo fight with Emilio, the principal. However, when Andres agreed to help Emilio carry the body of Diong and bury it behind the bushes, thus concealing or destroying the body of the crime, corpus delicti, to prevent its discovery, he became an accessory to the crime of homicide, Art 19, RPC. 4. With respect to the taking of the P600.00 which Emilio and Andres divided between themselves, they committed the crime of theft as co-principals. Theft because with intent to gain but without violence against or intimidation of persons, no force upon things, they took personal property of another without the latter's consent. They acted with unity of purposes and intention, thus making them co-principals by direct participation. Art 16, Degree of Participation 1994 Number 6. Tata owns a 3-story building located at number 3 Heron Street, Paco, Manila. She wanted to construct a new building but had no money to finance the construction. So, she insured the building for P3,000,000.00. She then urged Yoboy and Yangzi, for monetary consideration, to bum her building so she could collect the insurance proceeds. Yoboy and Yangzi burned the said building, resulting to its total loss. 1. What crime did Tata, Yoboy and Yangzi commit? 2. What is their respective criminal liability? Answer. 1. Tata, Yoboy and Yangzi committed the crime of destructive arson because they collectively caused the destruction of property by means of fire under the circumstances which exposed to danger the life or property of others. Art. 320, PAR 5, RPC as amended by RA number 7659. 2. Tata is a principal by inducement because she directly induced Yoboy and Yangzi, for a price or monetary consideration, to commit arson which the latter would not have committed were it not for such reason. Yoboy and Yangzi are principals by direct participation, Art 17, Pars 21 and 3, RPC. Art 16, Degree of Participation 2014. Despite the massive advertising campaign in media against firecrackers and gunfiring during the New Year's celebrations, Jonas and Haja bought 10 boxes of Super Lolo and PLA in Baco, Bulacan. Before midnight of December 31, 1999, Jonas and Haja started their celebration by having a drinking spree at Jonas' place by exploding their high-powered firecrackers in their neighborhood. In the course of their conversation, Jonas confided to Haja that he has been keeping a long-time grudge against his neighbor Japoy in view of the latter's refusal to lend him some money. While under the influence of liquor, Jonas started throwing lighted Super Lolos inside Japoy's fence to irritate him, and the same exploded inside the latter's yard. Upon knowing that the throwing of the Super Lolo was deliberate, Japoy became furious and sternly warned Jonas to stop his malicious act or he would get what he wanted. A heated argument between Jonas and Japoy ensued, but Haja tried to calm down his friend. At midnight, Jonas convinced Haja to lend him his .45 caliber pistol so that he could use it to knock down Japoy and to end his arrogance. Jonas thought that after all, explosions were everywhere and nobody would know who shot Japoy. After Haja lent his firearm to Jonas, the latter again started throwing lighted super lolos and PLA plus at Japoy's yard in order to provoke him so that he would come out of his house. When Japoy came out, Jonas immediately shot him with Haja's .45 caliber gun but missed his target. Instead, the bullet hit Japoy's 5-year-old son who was following behind him, killing the boy instantaneously. A. What crime or crimes can Jonas and Haja be charged with? Explain. 2%. B. If you were Jonas and Haja's lawyer, what possible defenses would you set up in favor of your clients? Explain. 2%. C. If you were the judge, how would you decide the case? Explain. 1%. Suggested answer. A. Jonas and Haja can be charged with the complex crime of attempted murder with homicide. C. I would convict Jonas as principal by direct participation and Haja as co-principal by indispensable cooperation for the complex crime of murder with homicide. Haja should be held liable as co-principal and not only as an accomplice because he knew of Jonas' criminal design even before he lent his firearm to Jonas and still he concurred in that criminal design by providing the firearm. Art 16, Degree of Participation Affects Nature of Crime Committed 1987 No 14. A, B, C, D, and E were members of a gang operating in Mindanao with Goryo as overall leader. Goryo assigned A, B, and C to get money from Pedro, a businessman from Agasan. As instructed, A, B, and C, armed with guns, went to see Pedro and demanded P100,000.00. When Pedro refused, A pointed his gun at him while B hit him with the butt of his gun. Pedro gave the amount demanded. After the three left, Pedro went to the PC command to tell them what happened. On the way, he met Orlando, also a businessman. Orlando told him that D and E, week earlier, wrote him a letter asking P50,000 and threatening to kill his son and wife should he fail to give the amount. Afraid that the two would make good their threat, he gave the money when D called him that day. Orlando was also on his way to the PC to report what happened. A. What crime did A, B, and C commit? B. What crime did D and E commit? If the crimes committed by A, B and C on one hand and D and E on the other hand are different, explain why they are different when the purpose is the same, i.e. to extort money. C. Did Goryo commit any crime? Answer. A, B, and C committed robbery. They were able to make Pedro give them the P100,000 that they demanded when A pointed his gun at Pedro because he refused at first to accede to their demand and B hit him with the butt of his gun. They employed violence and intimidation in the taking of the money with intent to gain. B, D and E committed grave threats. The reason is the intimidation employed refers to the killings of the wife and son of Orlando should he fail to give the amount of P50,000 demanded in the latter which D and E sent him. The distinction between robbery and grave threats when the purpose is the same, that is, to extort money, is that in robbery, the intimidation is actual and immediate whereas on grave threats, the intimidation is future and conditional. C. Goryo, being the overall leader of the group, is a principal by inducement in the robbery committed against Pedro. He has no liability regarding the grave threats committed by D and E against Orlando because the facts of the problem do not specifically mention his intervention in the activities of D and E. Art 16, Degree of Participation, 1989 Number 6. Mario, a law student, wanted to avenge the death of his brother, Jose, in the hands of Pedro and his gang. So, Mario talked to Dalmatio, known tough guy, to kill Pedro by promising him P50,000 to be paid after he had accomplished the killing. Dalmatio agreed. Since Pedro was to appear in court the following day at 9 a.m. at the City Hall to attend the hearing involving the death of Jose, Mario told Dalmatio to carry out the plan at that exact time in the courtroom, to which Dalmatio assented. At 8:50 a.m., Mario went to see Captain Malenso of the police department and told him that Dalmatio would kill Pedro at 9:00 am at the city hall. He asked Captain Malenso to prevent it, and so the latter rushed to the city hall but arrived at 9:05 am when Dalmatio had already killed Pedro. Is Mario liable as co-principal with Dalmatio for the killing of Pedro? Give your reasons. Answer. Mario is a principal by inducement. By promising to give P50,000,000 to Dalmatio, which is an agreement for a consideration for the purpose of avenging his brother's death, the inducement was made directly with the intention of procuring the commission of the crime. Furthermore, the facts show that Dalmatio has no personal reason to kill Pedro except the inducement, which is therefore the determining cause for the commission of the crime by Dalmatio. Mario's change of mind and heart at the last minute, which did not, after all, prevent the consummation of the crime, because it was too late, does not alter the course of his criminal liability as a co-principal by inducement. Desistance from carrying out a criminal design is no defense if such desistance has not actually and successfully prevented the commission of the crime. Art. 16, Degree of Participation, Accessories who are exempt. 1982 Number 5. A committed the crime of murder. His father, B, the chief of police of X town, who had knowledge of A's commission of the crime, concealed his son to evade arrest and prosecution. Is B guilty as accessory to the crime or murder? Is B guilty of some other crime? If he is, what crime did he commit? If not, why not? Reasons. Answer. B is not guilty as an accessory to the crime of murder committed by his son whom he concealed to evade arrest and prosecution. The reason is B is a relative of A and under Art. 20 of the revised Penal Code is exempt from criminal liability as an accessory except if he profited or assisted the offender to profit from the effects of the commission of the crime. B, however, should be guilty of prevarication or dereliction of duty for having failed maliciously to institute the prosecution for the punishment of A, his son, whom he knew to have committed a crime, as B is an officer of the law charged with the prosecution of offences. Art. 16, Degree of Participation, Accomplice. 1980 No v. L pointed a .45 caliber revolver at M without good reason. There ensued a struggle between the two for the weapon. N, a female companion of L, approached the combatants and quickly wounded M in the chest with a knife, as a consequence of which M died almost instantly. Can L be convicted as an accomplice? Answer. L is not liable as an accomplice. An accomplice must be aware of the criminal design of the principal and must perform acts, whether previous or simultaneous, showing his approval or concurrence to said criminal design. The facts of the problem clearly show that while L and M were struggling for the possession of the revolver, N, the female companion of L, approached the combatants and wounded M in the chest with a knife which caused his death. L had no knowledge of what N would do, and he did not perform any acts subsequent to the stabbing to show that he approved of what N did. People vs Cajun Dab, 52 SCRA 161. Art. 16, Degree of Participation, Principle by Inducement. 1981 Number 4. In the course of an argument over a parcel of land, which each one claimed as his own, B hit A on the face. A week later, C, father of A, and B were disputing the ownership of the same property. Coming from behind, A clubbed B on the head, causing him to topple unconscious to the ground. Then C told A, "That serves him right." Post-mortem examination disclosed that B died instantly from the blow he received on the head. A and C were charged by the prosecuting fiscal for the death of B. Is C criminally liable as a principal by inducement for the death of B? Why? Answer. C is not a principal by inducement. The requisites of a principal by inducement are, 1. That the inducement be made directly with the intention of procuring the commission of the crime, and 2. That such inducement be the determining cause of the said commission of the crime induced. People vs. Amin Kiaichi 61 Philosophy 609, People vs. De La Cruz, L30912, April 30, 1980, 97 SCRA 385. The facts of the problem show that when C told A after A clubbed B's head causing him to topple unconscious to the ground that serves him right, A had already committed the crime of killing B. So, the utterances of C cannot be the determining cause of the commission of the crime. Furthermore, A had a reason of his own in committing the crime. People vs. Cambrai et al. 110 Phil 370, People vs. Castillo et al. 17 SCRA 721. There was no inducement. Art 16, Degree of Participation, Principle by Inducement 2002 No. 2. A asked B to kill C because of a grave injustice done to A by C. A promised B a reward. B was willing to kill C, not so much because of the reward promised to him but because he also had his own long-standing grudge against C, who had wronged him in the past. If C is killed by B, would A be liable as a principal by inducement? 5%. Suggested answer. No, A would not be liable as a principal by inducement because the reward he promised B is not the sole impelling reason which made B to kill C. To bring about criminal liability of a co-principal, the inducement made by the inducer must be the sole consideration which caused the person induced to commit the crime and without which the crime would not have been committed. The facts of the case indicate that 0, the killer supposedly induced by A, had his own reason to kill C out of a long-standing grudge. Art 19, Conviction of Principal before Conviction of Accessory 1978 No. 3a. An accessory's liability is subordinate to that of the principal. Is it necessary that the principal should first be found and declared guilty before the accessory can be held liable? Discuss. Answer. It is not necessary that the principal be first found guilty before the accessory can be held liable provided the evidence is clear as to the commission of the crime. What is controlling is the Spanish text of the revised Penal Code which provides that the principal may be found guilty and not the English translation which speaks of the author being guilty of treason, parricide, murder, etc. People W. Billen, CA 48 OG 1391. This was reiterated in the more recent case of People vs. Inovaro, CA No. 04426-27 CR February 5, 1968. 65 O.G. 748, where it was held that the death of the principal does not preclude the conviction of an accessory in a murder case. What death extinguishes is the criminal liability of the principal but not the crime committed, and the accessory, having something to do with the commission of the crime, must suffer its consequence. Also, People vs. Nueva, 74 OG 1424. Art 19, Conviction of Principal before Conviction of Accessory 1981 No. 8. Is it necessary that the principal of a crime be convicted first before one may be found guilty and punished as an accessory? Explain your answer. Answer. It is not necessary that the principal be convicted before the accessory be found guilty and punished. Neither the letter nor the spirit of the law, Art 19, Revised Penal Code, requires that the principal be convicted before one may be punished as an accessory. As long as the corpus delicti is conclusively proved and the accessory's participation is established, he can be held criminally responsible and meted the corresponding penalty. People vs. Inovaro. CA 63 O.G. 3160. The Spanish text of the revised Penal Code was held to prevail, which does not require that the principal be guilty, unlike in the English text. People vs. Villain, CA 48 OG 1931. Art 19, Degree of Participation, Accessory 1986 No. 16. Brothers Aber and Bobbitt, 16 and 17 years old, respectively, have had no food for the past 2 days. Suffering from severe hunger, they hatched a plan to break into a store to steal some food. 5 days later, at 12 midnight, they were able to enter the store by breaking the hinges of the door. Aber took 10 cans of sardines worth P50.00. Bobbitt wandered into a nearby room where the store owner, Cosma, was sleeping. Cosma, awakened by Bobbitt's footsteps, attacked Bobbitt with a club. Bobbitt avoided the blow and hit Cosma in the chest with his fist. Aber, upon hearing the commotion, entered the room and tried to pull Bobbitt away from Cosma. Cosma, however, continued to attack Bobbitt, forcing the latter to box Cosma in the face. Cosma collapsed on the floor. Bobbitt and Aber fled. The following day, Aber sold 6 of the sardine cans taken from the store to Demas, who lives a block from the store. Earlier that day, Demas heard rumors that the nearby store had been robbed and that his friend Cosma was found dead. Demas thought of asking Aber and Bobbitt where they got the sardines to clear away this doubt, but on second thought did not. He bought the cans for P20.00 and sold them for P30.00. The fiscal charged Aber and Bobbitt with the complex crime of robbery with homicide aggravated by nighttime, evident premeditation and dwelling. The fiscal charged Demas as an accessory of Aber and Bobbitt and for violation of the anti-fencing law, PD No. J 612. D. If you were the counsel of Aber, what defenses would you raise? Explain. 2. If you were the counsel of Bobbitt, what defenses would you raise? Explain. 3. If you were the counsel of Demas, what defenses would you raise? Explain. 4. If you were the judge, how would you decide the case? Explain, answer. 3. If I were the counsel of Demas, I would maintain that he could not be liable as an accessory to the crime of homicide attributed to Bobbitt because he had no knowledge of its commission. Regarding the violation of the anti-fencing law, he can maintain that he bought the tins of sardines in good faith without any knowledge that these were the proceeds of the crime of theft. 4. Demas will be liable for fencing as he bought the tins of sardines without inquiring from Aber where he got the sardines, and under the circumstances he could have known that those were the proceeds of the crime of theft. He bought them with intent to gain, as in fact he sold them for a profit. Impliedly, he is not liable as an accessory. Art 19, Degree of Participation, Accessory 1983 No. 4. A proposed to B that they rob a certain store, to which B agreed. Later, however, B undertook the robbery alone and made off with P2,000 cash. The following day, after making some shallow explanation, B apologized to A and gave the latter P500, which A somewhat grudgingly accepted. What is A's liability, if any, and the legal basis thereof? Answer. A is liable as an accessory. Although A proposed that robbery be committed in a certain store, such proposal is not punished by law. So if B, to whom the proposal was made, committed the robbery alone, only he will be liable for the robbery. But since A received from B P500 which he knew to be part of the amount of P2,000, which was robbed, A is liable as an accessory because he profited from the proceeds of the commission of the crime. Alternative answer. A is liable for the offense of fencing. The reason is A with intent to gain for himself, received, possessed and kept an article or object of value which he knew to have been derived from the proceeds of the crime of robbery. Presidential Decree No. 1612, Money is an article of value. Art 19, Degrees of Participation, Accessories and Fence 1998 No. 7. King went to the house of Laura, who was alone. Laura offered him a drink, and after consuming 3 bottles of beer, King made advances to her and with force and violence, ravished her. Then King killed Laura and took her jewelry. Doming, King's adopted brother, learned about the incident. He went to Laura's house, hid her body, cleaned everything and washed the bloodstains inside the room. Later, King gave Jose, his legitimate brother, 1 piece of jewelry belonging to Laura. Jose knew that the jewelry was taken from Laura, but nonetheless he sold it for P2,000. What crime or crimes did King, Doming, and Jose commit? Discuss their criminal liabilities. 10%. Answer. King committed the composite crime of rape with homicide as a single indivisible offense, not a complex crime, and theft. Doming's acts, having been done with knowledge of the commission of the crime and obviously to conceal the body of the crime to prevent its discovery, makes him an accessory to the crime of rape with homicide under Art. 19. Par 2 of the Rev Penal Code, but he is exempt from criminal liability therefore under Article 20 of the Code, being an adopted brother of the principal. Jose incurs criminal liability either as an accessory to the crime of theft committed by King, or as fence. Although he is a legitimate brother of King, the exemption under Article 20 does not include the participation he did, because he profited from the effects of such theft by selling the jewelry knowing that the same was taken from Laura. Or Jose may be prosecuted for fencing under the Anti-Fencing Law of 1979, PD number 1612, since the jewelry was the proceeds of theft and with intent to gain, he received it from King and sold it. Art 19, Anti-Fencing Law 1987 No X. Pedro, a municipal treasurer, received from the provincial treasurer of the province 5 brand new typewriters for use in the municipal treasurer's office. Each typewriter is valued at P10,000.00. Since Pedro needed money for the hospitalization of his sick son, he sold four of the typewriters to his friend, Rodolfo, a general merchant in San Isidro for P2,000.00 each or a total of P8,000.00. Rodolfo as a general merchant knew that one typewriter could easily be between P6,000.00 to P10,000.00, and for this reason he readily agreed to buy the 4 typewriters. Rodolfo then resold the typewriters at P6,000.00, thus, making a profit of P16,000. 2 months after the transaction, Pedro was audited and the investigation as to his accountabilities led to the discovery that Rodolfo bought the 4 typewriters from Pedro. A. What crime did Pedro commit? Is Rodolfo liable as an accessory or for violation of the anti-fencing law? Answer. B. Rodolfo is not liable for violation of the anti-fencing law as this law refers only to the buy and sell of articles of value which are the proceeds of robbery and theft. Rodolfo is liable as an accessory to the crime of malversation as he purchased the typewriter for P2,000. Each only although he knew it could easily be sold for P6,000 to P10,000. Therefore he profited or assisted the principal to profit from the effects or proceeds of the commission of the crime. Art 19, Anti-Fencing Law 1992 No. 4. At the height of the eruption of Mt. Pinatubo at around midnight, Anacito joined some neighbors in evacuating his family, a few possessions and 2 horses to higher ground. Miguel, taking advantage of the darkness and the confusion, got one of the horses and asked his friend Doro to accompany him to Angeles City where he sold the same to an acquaintance Pepeng. Searching for his horse, Anacito found it, with identifying brand intact, in the possession of Pepeng who refused to surrender the same saying that he had paid good money for it. Whereupon, Anacito reported the matter to the police who promised to accompany him to the prosecutor's office. C. May Pepeng be indicted under the anti-fencing law? Explain. Suggested answer. C. Pepeng should be held liable for violation of the anti-fencing law, P.D. number 1612. He brought the horse which he should have known to have been derived from robbery or theft. The horse was duly branded, this should have forewarned Pepeng. Besides, he should have demanded a certificate of ownership from Miguel. Art 19. Anti-Fencing Law 1981 No. 17. Without asking for any document of ownership, A bought from B, a person who claimed to be a balikbayan from Saudi Arabia, a 1980 model national TV set for P500.00. 2 days later, a policeman visited A and informed him that the TV set he had bought from B, who already confessed to the robbery, was stolen from the house of C. Claiming that he bought the TV set in good faith, A refused to surrender it to C, so A was charged under the Anti-Fencing Act of 1979, Presidential Decree No. 1612. Is A criminally liable under this act? Why? Answer. A is criminally liable under the Anti-Fencing Act of 1979. Under this law, mere possession of any goods, article, item, object or anything of value which has been the object of robbery of theft shall be prime facie evidence of fencing. Fencing is committed if a person who with intent to gain for himself or another shall buy, receive, possess, keep, acquire, conceal, sell, or dispose of, or shall buy and sell or in any manner deal in any article, item, object or anything of value, which he knows or should be known to him to have been derived from the proceeds of robbery or theft. The law involves second-hand articles. A purchased the 1980 model national TV set as a second-hand item. His failure to ask any document of ownership and if B was indeed a Balikbayan whether he brought the TV set with him when he returned to the Philippines as evidenced by a carrier manifest since the TV set certainly cannot be hand-carried, and since the price was considerably cheap. Are circumstances which show that he should have known that the TV set was a proceed of robbery or theft. Art. 19, Anti-Fencing Law 1985 No. 12. While waiting for his car, Ub was approached by CD, who offered him a new set of auto mechanic tools coding P3,000.00 for only P500. Ub paid CD P500 and thereafter gave the brand new set of tools as a birthday gift to his godson, an auto mechanic. It turned out later that CD is the object of a police manhunt upon complaint of his employer for the theft of more than 100 sets of similar tools. Threatened with criminal prosecution for violation of the anti-fencing law, he consulted you as to his probable criminal liability for the said transaction. Put down in writing your advice and explanation on his query. Answer. Fencing is the act of any person, who with intent to gain for himself, or for another shall buy, receive, possess, keep, acquire, conceal, sell, or dispose of or shall buy and sell or in any other manner deal in any article, item or object or anything of value, which he knows or should be known to him to have been derived from the proceeds of the crime of robbery or theft, PD number 1612, considering that CD was a total stranger to Ub, that the former was the one who approached the latter to sell auto mechanic tools costing P3,000 for only P500, that CD was not in the business of selling auto mechanic tools nor was he representing any store engaged in such business. Ub should have been placed on guard that the object purchased by him was the proceed of the crime of robbery or theft. Ub should be liable for fencing. I would advise him to show his good faith in purchasing the auto mechanic tools that he requested from CD, the seller, a receipt, with a warranty to defend his ownership from a claim of any person whatsoever. Art. 19, Anti-Fencing Law 1986 No. 16. Brothers Aber and Bobbitt, 16 and 17 years old, respectively, have had no food for the past 2 days. Suffering from severe hunger, they hatched a plan to break into a store to steal some food. 5 days later, at 12 midnight, they were able to enter the store by breaking the hinges of the door. Aber took 10 cans of sardines worth P50.00. Bobbitt wandered into a nearby room where the store owner, Cosma, was sleeping. Cosma, awakened by Bobbitt's footsteps, attacked Bobbitt with a club. Bobbitt avoided the blow and hit Cosma in the chest with his fist. Aber, upon hearing the commotion, entered the room and tried to pull Bobbitt away from Cosma. Cosma, however, continued to attack Bobbitt, forcing the latter to box Cosma in the face. Cosma collapsed on the floor. Bobbitt and Aber fled. The following day, Aber sold 6 of the sardine cans taken from the store to Demas, who lives a block from the store. Earlier that day Demas heard rumors that the nearby store had been robbed and that his friend Cosma was found dead. Demas thought of asking Aber and Bobbitt where they got the sardines to clear away this doubt, but on second thought did not. He bought the cans for P20.00 and sold them for P30.00. The fiscal charged Aber and Bobbitt with the complex crime of robbery with homicide aggravated by nighttime, evident premeditation and dwelling. The fiscal charged Demas as an accessory of Aber and Bobbitt and for violation of the anti-fencing law, PD No. J612. 1. If you were the counsel of Aber, what defenses would you raise? Explain. 2. If you were the counsel of Bobbitt, what defenses would you raise? Explain. 3. If you were the counsel of Demas, what defenses would you raise? Explain. 4. If you were the judge, how would you decide the case? Explain, answer. 4. Demas will be liable for fencing as he bought the tins of sardines without inquiring from Aber where he got the sardines, and under the circumstances he could have known that those were the proceeds of the crime of theft. He bought them with intent to gain, as in fact he sold them for a profit. Art. 19, Anti-Fencing Law 1990 No. 7. Oscar owns and operates a gift and jewelry shop. Pilar sold to him for P1,000.00 a 55-carat diamond ring which she stole. A. May Oscar be held criminally liable under the Anti-Fencing Law, PD No. 1612? Explain your answer. B. How can Oscar acquire immunity from criminal prosecution for purchasing the diamond ring from Pilar and thus enable him to sell the same to the general public for a profit? Explain your answer. Answer. A. Yes, he is liable for fencing. The price is unconscionable. This shows that he would have known of the fact that the ring was stolen. Section 2 of PD 1612. The Anti-Fencing Law of 1979, provides that, a fencing is the act of any person who, with intent to gain for himself or for another, shall buy, receive XXX, sell or dispose of, or shall buy and sell, or in any other manner deal in any article XXX of value which he knows, or should be known to him, to have been derived from proceeds of the crime of robbery or theft. B. Oscar should secure a clearance/permit to sell the second-hand ring from the proper INP station commander pursuant to Section 6, PD 1612. The said section states that any person who fails to secure the clearance or permit, upon conviction, shall be punished as offense. Art. 19, Anti-Fencing Law 1995 No. 5. 1. What are the elements of fencing? 2a. What is the difference between a fence and an accessory to theft or robbery? Explain. B. Is there any similarity between them? Answer. 1. The elements of fencing are: a. A crime of robbery or theft has been committed. B. Accused, who is not a principal or accomplice in the crime, buys, receives, possesses, keeps, acquires, conceals, or disposes, or buys and sells, or in any manner deals in any article, item, object or anything of value, which has been derived from the proceeds of said crime. C. The accused knows or should have known that said article, item, object or anything of value has been derived from the proceeds of the crime of robbery or theft, and D. There is, on the part of the accused, intent to gain for himself or for another. 2a. One difference between a fence and an accessory to theft or robbery is the penalty involved. A fence is punished as a principal under PD No. 1612 and the penalty is higher, whereas an accessory to robbery or theft under the revised Penal Code is punished 2 degrees lower than the principal, unless he bought or profited from the proceeds of theft or robbery arising from robbery in Philippine highways under PD No. 532, where he is punished as an accomplice, hence the penalty is 1 degree lower. Also, fencing is a malum prohibition and therefore there is no need to prove criminal intent of the accused. This is not so in violations of revised Penal Code. B. Yes, there is a similarity in the sense that all the acts of one who is an accessory to the crimes of robbery or theft are included in the acts defined as fencing. In fact, the accessory in the crimes of robbery or theft could be prosecuted as such under the revised Penal Code or as offense under PD No. 1612. Dizon Paminchuan vs. People, 234 SCRA 63. Art. 19, Anti-Fencing Law 1996 No. 7. 2. Flora, who was engaged in the purchase and sale of jewelry, was prosecuted for the violation of PD 1612, otherwise known as the Anti-Fencing Law, for having been found to be in possession of recently stolen jewelry valued at P100,000 at her jewelry shop at Zapote Road, Las Piñas, Metro Manila. She testified during the trial that she merely bought the same from one named Cecilino and even produced a receipt covering the sale. Cecilino, in the past, used to deliver to her jewelries for sale but is presently nowhere to be found. Convicted by the trial court for violation of the anti-fencing law, she argued, or her acquittal on appeal, contending that the prosecution failed to prove that she knew or should have known that the jewelries recovered from her were the proceeds of the crime of robbery or theft. Answer: 2. No, Flora's defense is not well taken because mere possession of any article of value which has been the subject of theft or robbery shall be prima facie evidence of fencing, P.D. No 1612. The burden is upon the accused to prove that she acquired the jewelry legitimately. Her defense of having bought the jewelry from someone whose whereabouts is unknown, does not overcome the presumption of fencing against her, Pamanchuanas People, G.R. 111426, July 11, 1994. Buying personal property puts the buyer on caveat because of the phrases that he should have known or ought to know that it is the proceed from robbery or theft. Besides, she should have followed the administrative procedure under the decree that of getting a clearance from the authorities in case the dealer is unlicensed, in order to escape liability. Penalties. Art 25, Penalties 1988 Number 3. A. State the two classes of penalties under the revised Penal Code. Define each. B. May censure be included in a sentence of acquittal? Why or why not? Answer: A. The two classes of penalties under Article 25 of the revised Penal Code are as follows. 1. Principal. 2. Accessory. A principal penalty is defined as that provided for a felony and which is imposed by court expressly upon conviction. An accessory penalty is defined as that deemed included in the imposition of the principal penalty. B. Censure may not be included in a sentence of acquittal, because a censure is a penalty. Censure is repugnant and is essentially inconsistent and contrary to an acquittal. People vs. Abel Lira, 69 Philosophy 623. Art 25, Penalties 1997 Number 7. A. Was convicted of the complex crime of estafa through falsification of public document. Since the amount involved did not exceed P200.00, the penalty prescribed by law for estafa is arresto mayor in its medium and maximum periods. The penalty prescribed by law for falsification of public document is prison mayor plus fine not to exceed P5,000.00. Impose the proper prison penalty. Answer: the proper penalty is any range within prison correctional, 6 months and 1 day to 6 years, as minimum, to any range within prison mayor maximum, 10 years and 1 day to 12 years, as maximum. This is in accordance with People Us, Gonzalez, 73 Phil. 549, where it was ruled that for the purpose of determining the penalty next lower in degree, the penalty that should be considered as a starting point is the whole of prison mayor, it being the penalty prescribed by law, and not prison mayor in its maximum period, which is only the penalty actually applied because of Article 48 of the revised Penal Code. The penalty next lower in degree therefore is prison correctional, and it is within the range of this penalty that the minimum should be taken. Art 25, Penalties 1997 Number 8. Assume in the preceding problem that there were two mitigating circumstances and no aggravating circumstance. Impose the proper prison penalty. Answer: there being two mitigating circumstances without any aggravating circumstance, the proper prison penalty is arresto mayor, in any of its periods, i.e. ranging from 1 month and 1 day to 6 months, as minimum, to prison correctional in its maximum period 4 years, 2 months, and 1 day to 6 years as maximum. Under Art. 64, PAR 5 of the Revised Penal Code, when a penalty contains 3 periods, each one of which forms a period in accordance with Article 76 and 77 of the same code, and there are 2 or more mitigating circumstances and no aggravating circumstances, the penalty next lower in degree should be imposed. For purposes of the indeterminate sentence law, the penalty next lower in degree should be determined without regard as to whether the basic penalty provided by the Revised Penal Code should be applied in its maximum or minimum period as circumstances modifying liability may require. The penalty next lower in degree to prison correctional. Therefore, as previously stated, the minimum should be within the range of arresto mayor and the maximum is within the range of prison correctional in its maximum period. Art. 25, Penalties, Appreciation of Modifying Circumstances 1997 No. 6. A and B pleaded guilty to the crime of parricide. The court found 3 mitigating circumstances, namely, plea of guilty, lack of instruction and lack of intent to commit so grave a wrong as that committed. The prescribed penalty for parricide is reclusion perpetua to death. Impose the proper principal penalty. Answer. The proper penalty is reclusion perpetua. Even if there are 2 or more mitigating circumstances, a court cannot lower the penalty by 1 degree. Art. 63 PAR 3, Revised Penal Code, People vs. Formigones, 87 Philosophy 685. In U.S. vs. Relator 60 Philosophy 593, where the crime committed was parricide with the 2 mitigating circumstances of illiteracy and lack of intention to commit so grave a wrong, and with no aggravating circumstance, the Supreme Court held that the proper penalty to be imposed is reclusion perpetua. Art. 25, Penalties, Appreciation of Modifying Circumstances 1977 No. 4a. During the trial for homicide, the defense was able to prove 4 generic mitigating circumstances while the state was able to prove only 1 aggravating circumstance. Offsetting the mitigating and aggravating circumstances, there still remained 3 mitigating circumstances. So the judge imposed a penalty lower by 1 degree than the penalty provided by law. Did the judge err in imposing a penalty lower by 1 degree than the penalty provided by law? State your reasons. Answer. The judge erred in imposing the penalty lower by 1 degree. Article 64 PAR 5, which prescribes the penalty next lower in degree if the imposable penalty is divisible as is the penalty for homicide, which is reclusion temporal, applies if there are 2 or more mitigating circumstances present without any attending aggravating circumstance. People v. Soriano, 70 Philosophy 334, People v. Dayrit, 108 Philosophy 100. However, in a case decided by the Court of Appeals, PAR 5 of Article 64 was applied where there were 3 mitigating circumstances and 1 aggravating after 1 mitigating was made to offset the aggravating circumstance. The decision was by a division of 5, People v. Gamboa, O.G., 1947. The Supreme Court decisions are obviously controlling. Art. 25, Penalties, Appreciation of Modifying Circumstances 1982 No. 7. Homicide is punishable by reclusion temporal. The accused, 17 years of age, committed the crime of frustrated homicide while under the state of passion and obfuscation and acting in immediate vindication of a grave offense committed by the deceased against Ms. Wife. Accused thereafter surrendered voluntarily immediately after the commission of the offense, and pleaded guilty at the trial. What is the proper penalty to be imposed upon him? In your answer, disregard the civil liability but consider the indeterminate sentence. Explain fully the procedure adopted in the computation of the penalty. Answer. The proper penalty to be imposed upon A is arresto mayor in its minimum period. Frustrated homicide is punished by 1 degree next lower than consummated homicide. Since the penalty for homicide is reclusion temporal, 1 degree next lower will be prison mayor, which is the penalty for frustrated homicide. The accused was 17 years old when he committed the crime. Such minority is a privileged mitigating circumstance. Prison mayor should be lowered by 1 degree under Art. 68 of the revised Penal Code, which will be prison correctional. Voluntary surrender and voluntary plea of guilty will reduce again the imposable penalty by 1 degree, as there was no aggravating circumstance present and the imposable penalty is divisible in nature, Art. 64, PAR 5 RPC. So prison correctional will be lowered by 1 degree, which is arresto mayor. The maximum imprisonment in arresto mayor is 6 months. The indeterminate sentence law will not apply under Section 2 thereof because the term of imprisonment in the penalty does not exceed 1 year. Since passion and obfuscation and immediate vindication of a grave offence were also present, whether based on the same fact or on different facts, arresto mayor is to be imposed in the minimum period, as there is no attending aggravating circumstance. Art. 25, Penalties, Appreciation of Modifying Circumstances 1985 No. 2. Arthur, a 17-year-old student and aggrieved by the death of his only brother in a previous rally at the hands of the police, fired at a motorcycle cop passing by their place. He, however, missed his target and instead hit Jason, a passerby, who died instantaneously. A. As an investigating fiscal, what charge or charges will you file against Arthur? Reasons. B. Upon arraignment, Arthur pleaded guilty and invoked the additional mitigating circumstance of voluntary surrender. As a judge in applying the indeterminate sentence law, what penalty will you impose upon Arthur? Discuss. C. May Arthur apply for and be entitled to probation under PD 968, as amended by PD 1251 and Batas Pambanza 76? Answer. B. As a judge, I will first consider the imposable penalty under the revised Penal Code for the complex crime of direct assault with homicide. The penalty is for the more serious crime to be imposed in its maximum period, Art. 48, Revised Penal Code. The age of Arthur at the time of the commission of the crime, which is 17 years, is a privileged mitigating circumstance. Under Art. 68, PAR 2, Revised Penal Code, the imposable penalty is to be lowered by 1 degree. There being 2 mitigating circumstances, which are voluntary plea of guilty and voluntary surrender, without any aggravating circumstance, the penalty, being divisible, is attained to be lowered by 1 degree. Art. 64, PAR 5, Revised Penal Code. The imposable penalty, lowered by 2 degrees, will be the maximum of the indeterminate sentence. The minimum will be 1 degree next lower than the maximum. Act 4103 as amended, Indeterminate Sentence Law. Art. 25, Penalties, Appreciation of Modifying Circumstances 1989 No. 9. Jose is charged with bigamy. The revised Penal Code prescribes the penalty of prison mayor for this offense. The information filed against Jose alleged 1 aggravating circumstance. Upon being arraigned, he entered the plea of guilty and invoked the additional mitigating circumstance of voluntary surrender, which the trial fiscal admitted. If you were the judge trying the case, from what range of the prescribed penalty would you determine the proper penalty, to constitute the maximum term of an indeterminate sentence, to be imposed on Jose? Answer. I would take the maximum term of the indeterminate sentence from the range of prison mayor in its minimum period. This is so because while there are 2 ordinary mitigating circumstances present, one of them is offset by an aggravating circumstance. Consequently, it is as if the crime is attended by only 1 ordinary circumstance, and this will result in the imposition of the minimum period of the penalty prescribed by law. The presence of 2 or more ordinary mitigating circumstances will give rise to a privileged mitigating circumstance only if there is no aggravating circumstance present and the penalty prescribed by law is divisible. In this case, while the penalty of prison mayor is divisible, and while there are 2 ordinary mitigating circumstances present, there is an aggravating circumstance. This precludes the reduction of the penalty by 1 degree lower, inasmuch as the 2 ordinary mitigating circumstances cannot be considered as a privileged mitigating circumstance. Art. 25, Penalties, Appreciation of Modifying Circumstances 1991 No. 12. Rolando was charged with murder. The penalty for murder is reclusion temporal in its maximum period to death. The trial court convicted Rolando, but lowered the penalty by 1 degree because of the attendance of 3 ordinary mitigating circumstances and the absence of any aggravating circumstance. The court then imposed an indeterminate sentence of 6 years 1 day of prison mayor as minimum to 17 years and 1 day of reclusion temporal as maximum. Is the penalty correct? Answer. Technically and legally, the sentence of 6 years and 1 day to 17 years and 1 day is correct. Since there are 3 mitigating without any aggravating circumstance, the penalty provided for by law should be reduced by 1 degree, that is, prison mayor, maximum, to reclusion temporal, medium, which will be the maximum of the indeterminate sentence. Otherwise stated, the maximum will have a range of 10 years and 1 day, the starting point of prison mayor maximum, up to 17 years and 4 months, the end of reclusion temporal medium. Since the maximum sentence imposed by the judge is 17 years and 1 day, it is well within the maximum range. The minimum of 6 years and 1 day is also within the range of the next lower in degree of prison correctional maximum, 4 years, 2 months, 1 day to 6 years, up to prison mayor medium, 8 years, 1 day to 10 years. Alternative answer. Since there are 3 mitigating circumstances which justify the lowering of the penalty by 1 degree, and only the presence of 2 mitigating circumstances will be enough to lower the penalty by 1 degree. The excess of 1 mitigating circumstance should justify the judge to impose the minimum of the minimum, 4 years, 2 months, 1 day, and the minimum of the maximum, 10 years, 1 day. R25, Penalties, Appreciation of Modifying Circumstances 1995 Number 10. Homer was convicted of homicide. The trial court appreciated the following modifying circumstances: the aggravating circumstance of nocturnity, and the mitigating circumstances of passion and obfuscation, no intent to commit so grave a wrong, illiteracy and voluntary surrender. The imposable penalty for homicide is reclusion temporal, the range of which is 12 years and 1 day to 20 years. Taking into account the attendant aggravating and mitigating circumstances, and applying the indeterminate sentence law, determine the proper penalty to be imposed on the accused. Answer. It appears that there is 1 aggravating circumstance, nocturnity, and 4 mitigating circumstances, passion and obfuscation, no intent to commit so grave a wrong as that committed, and voluntary surrender. PAR 4, Art. 64 should be applied. Hence there will be offsetting of modifying circumstances, which will now result in the excess of 3 mitigating circumstances. This will therefore justify in reducing the penalty to the minimum period. The existence of an aggravating circumstance, albeit there are 4 aggravating, will not justify the lowering of the penalty to the next lower degree under paragraph 5 of said article, as this is applicable only if there is no aggravating circumstance present. Since the crime committed is homicide and the penalty therefore is reclusion temporal, the maximum sentence under the indeterminate sentence law should be the minimum of the penalty, which is 12 years and 1 day to 14 years and 8 months. The minimum penalty will thus be the penalty next lower in degree, which is prison mayor in its full extent, 6 years and 1 day to 12 years. Ergo, the proper penalty would be 6 years and 1 day, as minimum, to 12 years and 1 day, as maximum. I believe that because of the remaining mitigating circumstances after the offsetting, it would be very logical to impose the minimum of the minimum sentence under the ISL and the minimum of the maximum sentence. R25, Penalties, Concurrent Service of Sentence 1982 Number 8. What penalties, among those mentioned in the revised Penal Code, may be served concurrently and what penalties cannot be served concurrently? Explain. Answer. Penalties which may be served concurrently: perpetual or temporary absolute disqualification or perpetual or temporary special disqualification, public censure or suspension from public office. These penalties may be served with imprisonment. Penalties which cannot be served concurrently: imprisonment like reclusion temporal and prison mayor which must be served successively, one after the other, in the order of severity. Art. 25, Penalties, Death, Effect of Modifying Circumstances 1980 No. 7. Convicted of the special complex crime of rape with homicide, an accused was sentenced to death. On automatic review to the Supreme Court, his counsel pleaded the mitigating circumstances of plea of guilty and voluntary surrender which were not offset by any aggravating circumstance and prayed that the penalty be reduced to reclusion perpetua. The existence of said modifying circumstances was, in fact, established. Is the contention legally tenable? Answer. The intention is not legally tenable. Death is a single and indivisible penalty. Under Article 63 of the Revised Penal Code, it could be applied regardless of any mitigating or aggravating circumstances which attended the commission of the crime. People vs. Umit, 32 SCRA 95. The mitigating circumstances of plea of guilty and voluntary surrender cannot have the effect of reducing the death penalty to reclusion perpetua. Art. 25, Penalties, Factors to Consider 1991 No. 11. Imagine that you are a judge trying a case, and based on the evidence presented and the applicable law, you have decided on the guilt of two accused. Indicate the five steps you would follow to determine the exact penalty to be imposed. Stated differently, what are the factors you must consider to arrive at the correct penalty? Answer. 1. Determine the crime committed. 2. Stage of execution and degree of participation. 3. Determine the penalty. 4. Consider the modifying circumstances. 5. Determine whether indeterminate sentence law is applicable or not. Art. 25, Penalties, Reclusion perpetua vs. Life imprisonment 1991 No. 7. A raped X. In the process, X resisted and slapped A. Angered, A. grabbed a stone and hit X. She was dying when A. consummated the sexual attack. A psychiatrist from the National Center for Mental Health testified that he conducted physical, mental, and psychological examinations on A and found him to be suffering from a mental disorder classified under organic mental disorder with psychosis. A's father testified that A was playful but cruel to his brothers and sisters, stole his mother's jewelry which he sold for low sums, wandered naked sometimes, and oftentimes did not come home for extended periods of time. The prosecution, on the other hand, presented an array of witnesses to prove A that was lucid before and after the crime was committed and that he acted with discernment. After trial, the court convicted the accused and sentenced him to a life imprisonment, considering that under the Constitution death penalty could no longer be imposed. Given the conflicting testimonies as to sanity of the accused, was the trial court correct in ruling out insanity as an exempting circumstances in this case? Is the sentence of life imprisonment a correct imposition of penalty? Answer. The sentence of life imprisonment is not a correct imposition of penalty for the rape. It should be reclusion perpetua, the technical designation of the penalty for the crime under the Revised Penal Code. It is not correct to use the term life imprisonment because the accessory penalties to reclusion perpetua does not follow the penalty of life imprisonment. Furthermore, in reclusion perpetua the duration is stated to be for 30 years. Art. 25, Penalties, Reclusion perpetua vs. Life imprisonment 1994 No. 4. 1. Differentiate reclusion perpetua from life imprisonment. Answer. 1. Reclusion perpetua is that penalty provided for in the Revised Penal Code for crimes defined in and penalized therein except for some crimes defined by special laws which impose reclusion perpetua, such as violations of Republic Act 6425. As amended by Republic Act 7659 or of PD 1860, while life imprisonment is a penalty usually provided for in special laws. Reclusion perpetua has a duration of 20 years and 1 day to 40 years under Republic Act 7659, while life imprisonment has no duration. Reclusion perpetua may be reduced by 1 or 2 degrees. Reclusion perpetuates accessory penalties while life imprisonment does not have any accessory penalties. People vs. Baguio, 196 SCRA 459, People vs. Panelos, 205 SCRA 546. R25, Penalties, Reclusion perpetua vs. Life imprisonment 2001 No. 7. A. After trial, Judge Juan Laya of the Manila RDC found Benjamin Garcia guilty of murder, the victim having sustained several bullet wounds in his body so that he died despite medical assistance given in the Hospital NG Manila. Because the weapon used by Benjamin was unlicensed and the qualifying circumstance of treachery was found to be present, Judge Laya rendered his decision convicting Benjamin and sentencing him to reclusion perpetua or life imprisonment. Are reclusion perpetua and life imprisonment the same and can be imposed interchangeably as in the foregoing sentence? Or are they totally different? State your reasons. 3%. Suggested answer. A. The penalty of reclusion perpetua and the penalty of life imprisonment are totally different from each other and therefore, should not be used interchangeably. Reclusion perpetua is a penalty prescribed by the revised Penal Code, with a fixed duration of imprisonment from 20 years and 1 day to 40 years, and carries it with accessory penalties. Life imprisonment, on the other hand, is a penalty prescribed by special laws, with no fixed duration of imprisonment and without any accessory penalty. R25, Penalties, Subsidiary Penalty 1989 No. 7. Pedro was convicted of the crime of damage to property through reckless imprudence for bumping the car of Jose and the court have sentenced him to pay a fine of P3,000. Pedro failed to pay the amount of the fine for he was insolvent. Later, the court ordered the incarceration of Pedro so that the latter could serve subsidiary imprisonment to satisfy the fine. Pedro filed a petition for habeas corpus alleging that his confinement is illegal. Will the petition prosper? Give your reasons. Answer. The petition for habeas corpus will prosper. Subsidiary penalty is not an accessory penalty which adheres to a principal penalty and may therefore be imposed even if it is not expressly provided in the sentence. It is a penalty in lieu of the penalty imposed in the sentence. Hence, unless the judgment or sentence expressly provides for subsidiary imprisonment, the culprit cannot be made to undergo the same. People vs. Fallardo, 65 Philosophy 639. In this case, the court merely sentenced Pedro to pay a P3,000 fine. It was only later that the court ordered the incarceration of Pedro to serve subsidiary imprisonment after Pedro failed to pay the amount of the fine. Subsidiary imprisonment cannot be imposed unless it is expressly provided in the sentence. R25, Penalties, Successive Service of Sentence 1980 No. 6. B. An accused was found guilty of double murder and was meted out 2 sentences of reclusion perpetua. How would the accused serve the sentences? Answer. B. The rule is if 2 or more penalties in view of their nature cannot be served simultaneously, such must be served successively in the order of severity in accordance with the scale of the severity of penalties provided in Art. 70 RPC, but in no case is he to serve more than 3 times the most severe penalty, and which is not to exceed 40 years. If the penalties are the same, such is to be considered as the most severe penalty. As per V.S. Director of Prisons, 85 Philosophy 737, in the problem, 2 penalties of reclusion perpetua were imposed upon the accused. In view of their nature, these penalties cannot be served simultaneously. Reclusion perpetua has a duration of 30 years, multiplied by 3. 3 times the most severe penalty, the result is 90 years. The accused should serve however imprisonment not exceeding 40 years, Art 70 RPC. Art 25, Penalties, Threefold Rule 1985 No. 7. Finding Carlos Torres guilty of robbery as charged, Judge Cruz nevertheless dismissed the case against him, it appearing from the evidence that Carlos Torres had already been previously convicted in 15, other criminal cases and sentenced to a total penalty of 305 years. His Honor ruling that anyway the total penalty which he may be compelled to serve cannot in any case exceed 40 years under the threefold rule. Comment on the legality of His Honor's aforesaid pronouncement. Answer. The dismissal of the robbery case by Judge Cruz is improper and irregular. Dismissal is inconsistent with the finding of guilt of the accused. The duty of the court is to apply the law and to impose the penalty provided upon the accused found guilty of the crime charged. The reason that the accused, Carlos Torres, had been previously convicted in 15 other crimes and sentenced to a total penalty of 305 years and the total penalty that the accused may be compelled to serve cannot exceed 40 years under the threefold rule, does not find application in law. The threefold rule applies to the service of the penalties and not in the imposition of the penalties. People vs. Esquires 102 Philosophy 677. Art 25, Indeterminate Sentence Law 1975 No. 7. The purpose of the Indeterminate Sentence Law is to uplift and redeem valuable human material and prevent unnecessary and excessive deprivation of personal liberty and economic unusefulness. Explain how the law achieves that purpose. Answer. The Indeterminate Sentence Law provides for an indeterminate sentence which has a minimum and a maximum. After the prisoner has served the minimum, depending upon his conduct and behavior during confinement, he may be released on parole. The law, therefore, encourages the prisoner to reform. Once released on parole, provided the conditions are not violated, he will no longer serve the remainder of the sentence. The law hence treats the accused first as an individual and second as a member of society. It shortens his term of imprisonment, depending upon his behavior. Art 25, Indeterminate Sentence Law 1983 No. 11. A convict serving sentence for robbery escaped from the penitentiary and killed a rival gang member. Found guilty of homicide, he was given a straight prison term. He moved for reconsideration, contending that not being a habitual delinquent, he was entitled to an indeterminate sentence. Decide with reasons. Answer. The convict is not entitled to an indeterminate sentence because when he committed the crime of homicide he escaped from the penitentiary while serving the sentence for robbery. Section 2 of the Indeterminate Sentence Law enumerates the cases in which the law cannot apply, and one of those is if the offender escaped from confinement or evaded his sentence. Art 25, Indeterminate Sentence Law 1988 No. 4. A. State the application of the Indeterminate Sentence Law. Answer. A. The Indeterminate Sentence Law applies in cases where the penalty imposed is more than 1 year, and the ISL shall apply where there is a minimum penalty which is not lower than the penalty next lower in degree provided by law, and the maximum not higher than the maximum penalty provided by law in cases of felonies, but when it comes to statutory offences it must be lower than the minimum penalty provided by law and not higher than the maximum penalty provided by law except in the following cases as provided by Section 2 of Art. 4103. 1. Life imprisonment. 2. Those convicted of treason, conspiracy, or proposal to commit treason. 3. To those convicted of misprision of treason, rebellion, sedition, or espionage. 4. To those convicted of piracy. 5. Those who are habitual delinquents. 6. To those who shall have escaped from confinement or evaded sentence. 7. To those who, having been granted conditional pardon by the Chief Executive, shall have violated the terms thereof. 8. To those whose maximum term of imprisonment does not exceed 1 year, not to those already sentenced by final judgment at the time of approval of this Act, except as provided in Section 5 hereof. Art 25, Indeterminate Sentence Law 1989 No. 8. Andres is charged with an offence defined by a special law. The penalty prescribed for the offence is imprisonment of not less than 5 years but not more than 10 years. Upon arraignment, he entered the plea of guilty. A. In the imposition of the proper penalty, should the Indeterminate Sentence Law be applied? B. If you were the judge trying the case, what penalty would you impose on Andres? Answer. A. The indeterminate sentence law should be applied in this case. By express provision of said law, Section 1, it is applicable to offences punished by special laws. The indeterminate sentence in such cases shall consist of a maximum term which shall not exceed the maximum fixed by the special law and a minimum term which shall not be less than the minimum term prescribed by the same. If I were the judge trying the case, I would impose a penalty consisting of any duration not less than 5 years as minimum term and any duration not more than 10 years as maximum term. It could be 5 years and 1 day to 7 years, 7 years, 6 months, and 1 day to 9 years, or any other sentence where the minimum term is not less than 5 years and the maximum term not more than 10 years. Art. 25, Indeterminate Sentence Law 1990 No. 12. A. Carlos was charged and convicted of murder. He was sentenced to life imprisonment and to indemnify the offended party in the amount of P30,000. He sought a reconsideration of the penalty on the ground that he should be entitled to the benefits of the indeterminate sentence law. Decide with reasons. B. Suppose that instead of filing a motion for reconsideration he applies for probation. If you were the judge, will you grant the same? Explain your answer. Answer. A. Carlos is not entitled to avail of the indeterminate sentence law because Section 2 of said law specifically disqualifies and disallows application thereof to persons sentenced to life imprisonment. Art. 25, Indeterminate Sentence Law 1991 No. 6. A was charged with homicide. During the trial, uncontradicted evidence consisting of medical certificates were presented showing that the accused had sustained injuries in 10 previous occasions while engaged in fisticuffs with different persons. He was also confined at the National Mental Hospital for mental ailment diagnosed as homicidal and suicidal instincts. During his second confinement thereat, he escaped. Upon conviction, the prosecutor objected to the application of the indeterminate sentence law, contending that the accused is a habitual delinquent and an escapee from the National Mental Hospital. If you are the judge, rule on the objection. Answer. Objection should be overruled. A could not be legally considered a habitual delinquent. Habitual delinquency cannot be validly invoked without being alleged in the information and proven during the trial. Besides, there is no indication that A was convicted within 10 years from last conviction or release, 3 times or oftener of the crimes of robbery, theft, estafa, physical injuries, or falsification. Being an escapee from the mental hospital will not disqualify him from the application of the ISL, as Section 2 thereof contemplates having escaped from confinement or evaded sentence. Confinement presupposes imprisonment by virtue of a final judgment. Art. 25, Indeterminate Sentence Law 1994 No. 11. Idos was convicted of an offence penalized by a special law. The penalty prescribed is not less than 6 years but not more than 12 years. No modifying circumstance attended the commission of the crime. If you were the judge, will you apply the indeterminate sentence law? If so, how will you apply it? Answer. If I were the judge, I will apply the provisions of the indeterminate sentence law, as the last sentence of Section 1 Act 4103 specifically provides the application thereof for violations of special laws. Under the same provision, the minimum must not be less than the minimum provided therein, 6 years and 1 day, and the maximum shall not be more than the maximum provided therein, i.e. 12 years. People vs. Rosalina Reyes, 186 SCRA 184. Art. 25, Indeterminate Sentence Law 1999 No. 8. Andres is charged with an offence defined by a special law. The penalty prescribed for the offence is imprisonment of not less than 5 years but not more than 10 years. Upon arraignment, he entered a plea of guilty. In the imposition of the proper penalty, should the indeterminate sentence law be applied? If you were the judge trying the case, what penalty would you impose on Andres? 4%. Suggested answer. Yes, the indeterminate sentence law should be applied because the minimum imprisonment is more than 1 year. If I were the judge, I will impose an indeterminate sentence, the maximum of which shall not exceed the maximum fixed by law and the minimum shall not be less than the minimum penalty prescribed by the same. I have the discretion to impose the penalty within the said minimum and maximum. Art. 25, Indeterminate Sentence Law 1999 No. 12. Under what circumstances is the indeterminate sentence law not applicable? 2%. A was convicted of illegal possession of grease guns and 2 Thompson submachine guns punishable under the old law RA No. 4 with imprisonment of from 5 to 10 years. The trial court sentenced the accused to suffer imprisonment of 5 years and 1 day. Is the penalty thus imposed correct? Explain. 3%. Suggested answer. Indeterminate sentence law does not apply to 1. Persons convicted of offences punished with death penalty or life imprisonment. 2. Those convicted of treason, conspiracy, or proposal to commit treason. 3. Those convicted of misprision of treason, rebellion, sedition, or espionage. 4. Those convicted of piracy. 5. Those who are habitual delinquents. 6. Those who shall have escaped from confinement or evaded sentence. 7. Those who violated the terms of conditional pardon granted to them by the Chief Executive. 8. Those whose maximum term of imprisonment does not exceed 1 year. 9. Those who, upon the approval of the law, December 5, 1933, had been sentenced by final judgment. 10. Those sentenced to the penalty of destierro or suspension. The penalty imposed, being only a straight penalty, is not correct because it does not comply with the indeterminate sentence law which applies to this case. Said law requires that if the offence is punished by any law other than the revised penal code, the court shall sentence the accused to an indeterminate sentence, the maximum term of which shall not exceed the maximum penalty fixed by the law and the minimum shall not be less than the minimum penalty prescribed by the same. Art. 25, Indeterminate Sentence Law 2002 No. 3. A. How are the maximum and the minimum terms of the indeterminate sentence for offences punishable under the revised penal code determined? 3%. Suggested answer. For crimes punished under the revised penal code, the maximum term of the indeterminate sentence shall be the penalty properly imposable under the same code after considering the attending mitigating and/or aggravating circumstances according to Art. 64 of said code. The minimum term of the same sentence shall be fixed within the range of the penalty next lower in degree to that prescribed for the crime under the said code. B. Under the law, what is the purpose for fixing the maximum and the minimum terms of the indeterminate sentence? 2%. Suggested answer. The purpose of the law in fixing the minimum term of the sentence is to set the grace period at which the convict may be released on parole from imprisonment. Unless by his conduct he is not deserving of parole and thus he shall continue serving his prison term in jail but in no case to go beyond the maximum term fixed in the sentence. Art. 25, Indeterminate Sentence Law, Exceptions 2003 No. 13. When would the indeterminate sentence law be inapplicable? 4% suggested answer. The indeterminate sentence law is not applicable to 1. Those persons convicted of offences punished with death penalty or life imprisonment or reclusion perpetua. 2. Those convicted of treason, conspiracy, or proposal to commit treason. 3. Those convicted of misprision of treason, rebellion, sedition, or espionage. 4. Those convicted of piracy. 5. Those who are habitual delinquents. 6. Those who shall have escaped from confinement or evaded sentence. 7. Those who having been granted conditional pardon by the Chief Executive shall have violated the terms thereof. A. Those whose maximum term of imprisonment does not exceed 1 year. 9. Those already sentenced by final judgment at the time of approval of this Act, and 10. those whose sentence imposes penalties which do not involve imprisonment, like destierro. Art. 25, Probation Law 1984 Number 11. Under the probation law, the filing of an application for probation shall be deemed a waiver of the right to appeal. Is this waiver mandatory or irrevocable? Explain. A. Furnished by Office of Justice Palma. Despite the provision in the probation law that the filling of an application for probation shall be deemed a waiver of the right to appeal, it has been held that such a waiver is not irrevocable. Hence an accused may withdraw his application for probation and instead opt to pursue appeal from conviction. UCV Morales, 121 SCRA 853. For the purposes of probation, what the law gives more importance to is the offender, not the crime, to v. Cruz Pano, 120 SCRA 8. In line with the public policy behind probation, the right of appeal should not be irrevocably lost from the moment a convicted accused files an application for probation. Appeal and probation spring from the same policy, considering justice, humanity, and compassion. UCV Morales, Supra. B. Comments and suggested answer. The waiver provided in the probation law is not irrevocable. The offender may still withdraw his application for probation and file an appeal if the period to do so has not yet prescribed. Probation law is interpreted liberally in favor of the accused. It is not served by a harsh and stringent interpretation of its provisions. Appeal and probation spring from the same policy considerations of justice, humanity, and compassion. If it appears that the application for probation was improvidently filed by the offender who was assisted by counsel de officio and not by his counsel of record who was in a better position to consider fully the strength of a possible appeal, being fully familiar with the case, the waiver rule cannot be considered irrevocable. UC et al. vs. Judge Morales L. 61958, April 28, 1983, 121, SCRA 653. Art. 25, Probation Law 1989 No. 20. A was charged with theft and upon arraignment, pleaded guilty to the charge. He was detained for failure to post bail. After 2 months, a decision was rendered, sentencing A to an indeterminate sentence of 6 months and 1 day as a minimum, to 1 year and 1 month as maximum, and to pay the offended party the amount of P700, on January 16, 1985, the very day the sentence was read to A. The judge issued a commitment order addressed to the provincial jail warden. On January 28, 1985, A applied for probation, but his application was denied on the ground that the sentence of conviction became final and executory on January 16, 1985, when A commenced to serve his sentence. A. Is A eligible for probation? B. What is the purpose of the probation law? Answer. A is still eligible for probation since he filed his application for probation within 15 days from the promulgation of the judgment. Under the probation law, the accused may apply for probation within the period for perfecting an appeal, which is 15 days from promulgation or notice thereof. The judge committed an error in issuing a commitment order on the same day of promulgation. A commitment order for the convict to begin serving his sentence can be validly issued only if the period for perfecting an appeal has expired with no appeal being taken. The fact that in compliance with such order, which is void, the accused commenced to serve his sentence does not bar him from availing himself of the benefits of the probation law. It is true that under the new rules on criminal procedure it is provided that a judgment in a criminal case becomes final after the lapse of the period for perfecting an appeal, or when the sentence has been partially or totally satisfied or served, or the accused has applied for probation, Sector 7, Rule 120. But Section 9 of the same rule provides that nothing in this rule shall be construed as affecting any existing provision in the law governing suspension of sentence, probation or parole. The probation law does not speak of filing an application for probation before judgment has become final. It only speaks of filing the application within the period for perfecting an appeal. There is nothing in the probation law that bars an accused who has commenced to serve his sentence from filing an application for probation provided he does so within the period for perfecting an appeal. What the probation law provides is that no application for probation shall be entertained or granted if the defendant has perfected an appeal from the judgment or conviction. It does not say that no application shall be entertained if the judgment has become final because the convict has commenced to serve his sentence. B. The purposes of the probation law are: 1. To promote the correction and rehabilitation of an offender by providing him with individualized treatment. 2. To provide an opportunity for the reformation of a penitent offender which might be less probable if he were to serve a prison sentence, and 3. To prevent the commission of offenses. Art. 25, Probation Law 1990 No. 12. A. Carlos was charged and convicted of murder. He was sentenced to life imprisonment and to indemnify the offended party in the amount of P30,000. He sought a reconsideration of the penalty on the ground that he should be entitled to the benefits of the indeterminate sentence law. Decide with reasons. B. Suppose that instead of filing a motion for reconsideration he applies for probation. If you were the judge, will you grant the same? Explain your answer. Answer. B. I will not grant the application for probation as it is clear in the probation law that the benefits thereof shall not apply to those sentenced to serve a maximum term of imprisonment of more than 6 years, PD 1990. Art. 25, Probation Law 1991 No. 13. A. Boyatmar was charged with consented abduction by a 17-year-old complainant. The accused made wedding arrangements with the girl, but her parents insisted on the prosecution of the case. To avoid further embarrassment of a court trial for him and the girl, the accused entered a plea of guilty. He then filed a petition for probation before serving sentence, but the court denied the petition on the ground that it would be better for the accused to serve sentence so that he would reform himself and avoid the scandal in the community that would be caused by the grant of the petition. The accused served sentence, but he brought the matter to the Supreme Court in a petition for certiorari. Did the trial court act correctly in denying the petition for probation? Answer. The trial court acted incorrectly. In Balita us. Levist, 92 SCRA 719, the judge precisely denied the petition for probation on the same excuse stated in the problem. The Supreme Court held that an accused must fall within any one of the disqualifications stated in Section 9 of PD 960 in order to be denied probation. Art. 25, Probation Law 1993 No. 2. Juanito was found guilty of robbery by the RDC of Manila and sentenced to 4 years, 2 months and 1 day of prison correctional as minimum to 8 years and 20 days of prison mayor as maximum. Juanito appealed to the Court of Appeals, which found him guilty only of theft and sentenced him to a straight penalty of 1 year. The decision of the appellate court was promulgated in May 1993. 1. Is Juanito entitled to the benefits of the probation law which became effective on January 3, 1978? Why? 2. Suppose the prison term imposed by the RDC in the above example is only 2 years as minimum to 6 years as maximum, and Juanito did not appeal. When he applied for probation, it was discovered that in March 1960, a municipal court has sentenced him to a 6-month imprisonment for less serious physical injuries which he fully served. May his application for probation be granted? Reason out. Answer. 1. Juanito is not entitled to probation because the law, as amended, requires the filing of the application within the period for perfecting an appeal. 2. He is not entitled to the probation law because Section 9(c) provides that probation shall not be extended to those who have previously been convicted by final judgment of an offense punishable by imprisonment of not less than 1 month and 1 day or a fine of not more than P 200.00. Art. 25, Probation Law 1981 No. 9. Isidro, 21, was convicted of consented abduction and sentenced to an indeterminate penalty of 3 months and 1 day of arresto mayor, as minimum, to 2 years, 4 months and 1 day of prison correctional, as maximum. Isidro did not appeal, but he filed a petition for probation. The probation officer recommended favorable action on the application, stating that the accused did not intend to cause a grave wrong and had the potential of a good probationer. The trial court denied probation on the ground that it would be better for the accused to serve his sentence so that he could reform himself and correct his selfish tendencies. Admittedly, Isidro does not fall within any of the classes of disqualified offenders under the probation law. Would you sustain the action of the trial judge in a certiorari case assailing it? Reasons. Answer: I will not sustain the action of the trial judge. His denial of the application for probation because it would be better for the accused to serve his sentence so that he could reform himself and correct his selfish tendencies was arbitrary, capricious, and whimsical. He should have considered the recommendation of the probation officer, which was made after a post-investigation of the offender in accordance with the probation law, that the offender was entitled to probation because he had not intended to commit a grave wrong when he committed the crime of consented abduction and that he had the potential of a good probationer. Balita Jr. vs. Judge Leviste, 92 SCRA 715, 1979. Art 25. Probation Law 1984 No. 15. On a plea of guilty, X was convicted of homicide through reckless imprudence and was sentenced to a prison term. The judgment made no pronouncement regarding his civil liability. X forthwith applied for probation. The following day, the private prosecutor, who was not given the chance to present evidence on X's civil liability, filed a motion to set the case for the reception of said evidence. Although supported by the fiscal, the motion was denied by the judge on the ground that it was filed out of time. According to the judge, the prosecution should have asked for leave to prove the civil liability of the defendant before judgment was rendered, not thereafter. For a hearing for that purpose after judgment would in effect nullify the order of suspension of the sentence and would defeat the very purpose of the probation law. Was the denial of the motion in accordance with law? Explain. Answer: A. Furnished by Office of Justice Palma. No, the denial of the motion was not proper. In Budlong vs. Apalasoc, 122 SCRA 935, it was held that probation affects only the criminal aspect of the case. The suspension of the sentence imposed on the accused who is granted probation has no bearing on his civil liability. The court must hear the civil aspect of the case where accused pleads guilty and at the same time. In the example given, the judgment was not final. Hence, the court should have reopened the case for reception of evidence in support of the civil aspect. It would be contrary to the rule against multiplicity of suits should the private prosecutor be compelled to institute a separate civil action for the recovery of the civil liability, either on the concept principle of ex delicto or ex quasi delicto. Since the same acts may be both considered as delict or quasi-delict giving rise to civil liability. B. Comments and suggested answer. The denial of the motion was not in accordance with law. The granting of probation affects only the criminal liability of the offender. This is shown by the statutory definition of probation, which is a disposition under which the defendant after conviction and sentence is released subject to the conditions imposed by the court and to the supervision of the probation officer. The conviction and sentence phrase shows that probation affects only the criminal aspects of the case. The suspension of the sentence imposed on the accused who is granted probation has no bearing on his civil liability. There is no legal basis in the conclusion of the trial court that a hearing to prove the civil liability of the accused would nullify the order of suspension of the sentence and would defeat the very purpose of the probation law. The denial of the motion would violate the right of the complainant to due process. The motion was filed on the day after the judgment of conviction was rendered and hence before it became final. Besides, the civil liability of the accused is not part of the penalty for the crime committed. It is personal to the offended party. Berlong vs Apalasoc L 60151 June 24, 1983, 122 SCRA 935. R25, Probation Law 1985 No. 2. Arthur, a 17-year-old student and aggrieved by the death of his only brother in a previous rally at the hands of the police, fired at a motorcycle cop passing by their place. He, however, missed his target and instead hit Jason, a passerby, who died instantaneously. A. As an investigating fiscal, what charge or charges will you file against Arthur? Reasons. B. Upon arraignment, Arthur pleaded guilty and invoked the additional mitigating circumstance of voluntary surrender. As a judge in applying the indeterminate sentence law, what penalty will you impose upon Arthur? Discuss. C. May Arthur apply for and be entitled to probation under PD 968, as amended by PD 1251 and Batas Pambanza 76? Answer. C. Arthur may apply for and be entitled to probation if the maximum of the indeterminate sentence does not exceed 6 years and 1 day. President Decree 968 as amended by President Decree 1257 and Batas 76. R25, Probation Law 1986 No. 6. Aristides was found guilty by the trial court of challenging Bodinus to a duel and scoffing at Bodinus because of the latter's refusal to accept the challenge. The court sentenced Aristides to a penalty of imprisonment from 4 months and 1 day to 2 years and 4 months. In the dispositive portion of the decision, the court found Aristides entitled to probation and suspended the execution of the sentence for a period of 2 years. Aristides did not appeal the decision. State the purposes of the probation law and explain whether or not the action of the judge promotes or serves these purposes. Answer. The purposes of the probation law are: 1. To promote the correction and rehabilitation of the offender by providing him with individualized treatment. 2. To provide an opportunity for the reformation of a penitent offender which might be less probable if he were to serve a prison sentence. 3. To prevent the commission of offenses. The action of the judge certainly promotes or serves these purposes because it gives a first-time offender a second chance to maintain his place in society, through a process of reformation, which is better achieved when he is not mixed with hardened criminals. The accused is afforded to reform and rehabilitate himself without the stigma of a prison record. However, probation cannot be granted without an application filed by the offender after conviction and sentence. Besides, if probation is granted, mandatory and optional conditions must be provided in the order of the court. R25, Probation Law 1988 No. 4. B. Who are the offenders disqualified from availing themselves of the benefits of the probation law, PD 968, as amended? Answer. B. The following offenders are disqualified from availing of the benefits of the probation law. 1. Those sentenced to serve maximum term of imprisonment of more than 6 years. 2. Those convicted of subversion or any crime against the national security of the public order. 3. Those who have previously been convicted by final judgment of an offense punished by imprisonment of not less than 1 month and 1 day and or a fine of not less than 200 pesos. 4. Those who have been once on probation under the provisions of this decree, and 5. Those who are already serving sentence at the time the substantive provisions of this decree applicable pursuant to Section 33 of PD 968. R25, Probation Law 1995 No. 3. In a case for violation of Sector 8, RA 6425, otherwise known as the Dangerous Drugs Act, accused Vincent was given the benefit of the mitigating circumstances of voluntary plea of guilt and drunkenness not otherwise habitual. He was sentenced to suffer a penalty of 6 years and 1 day and to pay a fine of P6,000.00 with the accessory penalties provided by law, plus costs. Vincent applied for probation. The probation officer favorably recommended his application. 1. If you were the judge, What action will you take on the application? Discuss fully. 2. Suppose that Vincent was convicted of a crime for which he was sentenced to a maximum penalty of 10 years. Under the law, he is not eligible for probation. He seasonably appealed his conviction. While affirming the judgment of conviction, the appellate court reduced the penalty to a maximum of 4 years and 4 months, taking into consideration certain modifying circumstances. Vincent now applies for probation. How will you rule on his application? Discuss fully. Answer. 1. If I were the judge, I will deny the application for probation. The accused is not entitled to probation as Sector 9 of the Probation Law, PD No. 968, as amended, specifically mentions that those who are sentenced to serve a maximum term of imprisonment of more than 6 years are not entitled to the benefits of the law. 2. The law and jurisprudence are to the effect that appeal by the accused from a sentence of conviction forfeits his right to probation, Sector 4, PD number 968 as amended by PD 1990, Bernardo Us. Balagot, Francisco VSCA, Lamatu VSCA, De La Cruz vs Judge Callejo, CA case. NB to number 2. This is the second consecutive year that this question was asked. It is the sincere belief of the committee that there is a need to re-examine the doctrine. Firstly, much as the accused wanted to apply for probation, he is proscribed from doing so as the maximum penalty is not probationable. Secondly, when the maximum penalty was reduced to one which allows probation, it is but fair and just to grant him that right, because it is apparent that the trial judge committed an error and for which the accused should not be made to suffer. Judicial tribunals in this jurisdiction are not only courts of law but also of equity. Thirdly, the judgment of the appellate court should be considered a new decision as the trial court's decision was vacated, hence, he could take advantage of the law when the decision is remanded to the trial court for execution. Please see dissenting opinion in Francisco VSCA. It is suggested, therefore, that an examinee answering in this tenor should be credited with some points. Art 25, Probation Law 1997 Number 9. The accused was found guilty of grave oral defamation in 16 informations which were tried jointly and was sentenced in one decision to suffer in each case a prison term of 1 year and 1 day to 1 year and 8 months of prison correctional. Within the period to appeal, he filed an application for probation under the Probation Law of 1976, as amended. Could he possibly qualify for probation? Answer. Yes. In Francisco vs Court of Appeals, 243 SCRA 384, the Supreme Court held that in case of one decision imposing multiple prison terms, the totality of the prison terms should not be taken into account for the purposes of determining the eligibility of the accused for the probation. The law uses the word maximum term, and not total term. It is enough that each of the prison terms does not exceed 6 years. The number of offenses is immaterial for as long as the penalties imposed, when taken individually and separately, are within the probationable period. Art 25, Probation Law, Applicability 2003 No. 14. Juan was convicted of the Regional Trial Court of a crime and sentenced to suffer the penalty of imprisonment for a minimum of 8 years. He appealed both his conviction and the penalty imposed upon him to the Court of Appeals. The appellate court ultimately sustained Juan's conviction but reduced his sentence to a maximum of 4 years and 8 months imprisonment. Could Juan forthwith file an application for probation? Explain. 8%. Suggested answer. No, Juan can no longer avail of the probation because he appealed from the judgment of conviction of the trial court, and therefore, cannot apply for probation anymore. Section 4 of the Probation Law, as amended, mandates that no application for probation shall be entertained or granted if the accused has perfected an appeal from the judgment of conviction. Art 25, Probation Law, barred by appeal. 2001 No. 17. A subdivision developer, was convicted by the RDC of Makati for failure to issue the subdivision title to a lot buyer despite full payment of the lot, and sentenced to suffer 1 year imprisonment. A appealed the decision of the RDC to the Court of Appeals, but his appeal was dismissed. May A still apply for probation? Explain. 5%. Suggested answer. No, A is no longer qualified to apply for probation after he appealed from the judgment of conviction by the RDC. The Probation Law, PD 968, as amended by PD 1990, now provides that no application for probation shall be entertained or granted if the accused has perfected an appeal from the judgment of conviction. Sector 4, PD 968. Art. 25, Probation Law, Effective Application 1992 No. 9. Johnny Guitarra was convicted of the crime of estafa by the Regional Trial Court of Manila. He was imposed the indeterminate penalty of imprisonment of 3 years, 2 months, and 1 day as minimum and 6 years as maximum, both of prison correctional, and was ordered to indemnify the offended party in the amount of P3,000,000. He filed an application for probation upon the promulgation of the judgment. What is the legal effect of his application for probation on the judgment of conviction? Does said application interrupt the running of the period of appeal? Suggested answer. The filing of the application for probation is considered as a waiver of the right of the accused to appeal. The decision has become final. In view of the finality of the decision, there is no period of appeal to speak of. Art. 25, Probation Law, Effective Discharge 1983 No. 17. When a person convicted by final judgment is placed on probation and finally discharged after the probation period, is he still required to satisfy his pecuniary liabilities under the revised Penal Code? Why? Answer. Under the Probation Law, Presidential Decree No. 968 as amended by Presidential Decree No. 1257, if the person who is placed on probation is finally discharged, such will operate to fully discharge the offender of his liability for the fine imposed. Under Art. 38 of the revised Penal Code, fine is one of the pecuniary liabilities of the offender. The other pecuniary liabilities, which are reparation for damages caused and indemnification for consequential damage. Art. 38, supra, which constitute the civil liability of the offender, are not extinguished because probation affects only the criminal aspect of the case. This is clearly evident in the Conviction and Sentence Clause of the definition of probation under Presidential Decree No. 968. Budlong vs. Judge Apalasak L. 60151, June 24, 1983, note, the question should have referred to the civil liability of the offender, as that seems to be the intention of the examiner. Art. 25, Probation Law, Entitlement to Probation, Appeals 2002 No. 4. A was charged with homicide. After trial, he was found guilty and sentenced to 6 years and 1 day in prison mayor, as minimum, to 12 years and 1 day of reclusion temporal, as maximum. Prior to his conviction, he had been found guilty of vagrancy and imprisoned for 10 days of arresto manner and fined 50 pesos, P 50.00. Is he eligible for probation? Why? 3%. Suggested answer. No, he is not entitled to the benefits of the Probation Law. PD 968, as amended, does not extend to those sentenced to serve a maximum term of imprisonment of more than 6 years, Sector 9A. It is of no moment that in his previous conviction A was given a penalty of only 10 days of arresto mayor and a fine of P 50.00. B. May a probationer appeal from the decision revoking the grant of probation or modifying the terms and conditions thereof. 2%. Suggested answer. No. Under Section 4 of the Probation Law, as amended, an order granting or denying probation is not appealable. Art. 25, Probation Law, Qualifications for Probation 1994 No. 17. On February 3, 1986, Roberto was convicted of arson through reckless imprudence and sentenced to pay a fine of P15,000.00, with subsidiary imprisonment in case of insolvency by the Regional Trial Court of Quezon City. On February 10, 1986, he appealed to the Court of Appeals. Several months later, he filed a motion to withdraw the appeal on the ground that he is applying for probation. On May 7, 1987, the Court of Appeals granted the motion and considered the appeal withdrawn. On June 10, 1987, the records of the case were remanded to the trial court. Roberto filed a motion for probation praying that execution of his sentence be suspended, and that a probation officer be ordered to conduct an investigation and to submit a report on his probation. The judge denied the motion on the ground that pursuant to Presidential Decree No. 1990, which took effect on July 16, 1986, no application for probation shall be entertained or granted if the defendant has perfected an appeal from the judgment of conviction. Is the denial of Roberto's motion correct? Answer: yes. Even if at the time of his conviction Roberto was qualified for probation but that at the time of his application for probation, he is no longer qualified, he is not entitled to probation. The qualification for probation must be determined as of the time the application is filed in court. Bernardo vs. Judge, Adel. Gr. No. L865619 Nov. 10. 1992, Edwin de la Cruz vs. Judge Callejo. Et al., SP 19655, April 18, 1990, citing Lamadou vs. CA, et al., GR number 84859, June 28, 1989, Bernardo Us. Judge Balagot, Adel, GR 86561, November 10, 1992. Art 29, Destiero 1982 number 15. May an accused person sentenced to Destiero be credited with a portion of the time during which he had undergone preventive imprisonment? If not, why not? If in the affirmative, what portion of the time of preventive imprisonment should be credited to him? Answer: an accused sentenced to Destiero can be credited with a portion of his period of preventive imprisonment in the service of the sentence consisting of deprivation of liberty because Destiero as a penalty involves also deprivation of liberty although partial. People vs. Bastisa et al., 88 SCRA 184. Art 29, Preventive Imprisonment 1980 No. 6. A. Under Article 29 of the Revised Penal Code, offenders who have undergone preventive imprisonment shall be credited in the service of their sentence consisting of deprivation of liberty, with the full time during which they have undergone preventive imprisonment. An accused was sentenced to Destiero for having killed his wife under exceptional circumstances. He had been preventively detained for a period of almost 12 years. Would he be entitled to the benefits of Art. 29 insofar as his preventive imprisonment is concerned? Answer: A. Article 29 as amended by RA No. 6127 provides that an offender who has undergone preventive imprisonment shall be credited in the service of his sentence consisting of deprivation of liberty, with the full time of the period of his preventive imprisonment if he has agreed in writing to observe the rules of discipline applied to convicted prisoners, and 4/5 if there is no written commitment. The penalty of Destiero involves also deprivation of liberty. People vs. Belong, 82 Philosophy 172. The problem does not show whether there is a written commitment. So, the deduction of the full period of preventive imprisonment cannot technically be applied. However, the period of preventive imprisonment is almost 12 years. Hence, even if 4/5 thereof of 12 years is applied, the result will be more than 8 years. The duration of Destiero is from 6 months 1 day to 6 years. The accused therefore is entitled to be released because the period of his preventive imprisonment exceeds the penalty of Destiero imposed upon him. Art 29, Preventive Imprisonment 1983 No. 10. Having caught A in flagrante delicto doing the sex act with his B's wife, B shot and killed a while the latter was still in the compromising act. B was sentenced to reclusion perpetua for murder after a protracted trial. It was only on appeal that he was given the proper penalty of destierro under Article 247 of the revised Penal Code. During the pendency of the case, the accused was under preventive detention which lasted for about 8 years. A. In serving his sentence, is B entitled to credit for his preventive imprisonment? Explain. B. What is the philosophy of the legal provision imposing the penalty of destierro for the above crime? Answer. A can be credited for his preventive imprisonment. Destierro as a penalty involves also deprivation of liberty. People vs. Bastisa, 1979, of 6 OG 6844. Art 29, Preventive Imprisonment 1994 No. 3. 1. When is there preventive imprisonment? 2. When is the accused credited with the full time of his preventive imprisonment, and when is he credited with 4/5 thereof? Answer. 1. There is preventive imprisonment when an offender is detained while the criminal case against him is being heard, either because the crime committed is a capital offense and not bailable, or even if the crime committed was bailable, the offender could not post the required bail for his provisional liberty. 2. An accused is credited with the full time of his preventive imprisonment if he voluntarily agreed in writing to abide by the rules of the institution imposed upon its prisoners, provided that a. The penalty imposed on him for the crime committed consists of a deprivation of liberty. b. He is not disqualified from such credit for being a recidivist, or for having been previously convicted for 2 or more times of any crime, or for having failed to surrender voluntarily for the execution of the sentence upon being so summoned, Art 29, RPC. Where the accused however did not agree, he would only be credited with 4/5 of the time he had undergone preventive imprisonment. Art 39, Subsidiary Imprisonment 1978 No. 4a. A bus driver was found guilty of damage to property through reckless imprudence. He was sentenced to pay a fine of P5,000 and the costs. The driver was insolvent and could not pay the fine. May the driver be required to serve subsidiary imprisonment? Explain. Answer. No, because subsidiary imprisonment in case of insolvency to pay the fine, is not expressly provided in the sentence. People vs. Fajardo, 65 Philosophy 639. Art 39, Subsidiary Imprisonment 1980 No. 8. P was sentenced from 6 years and 1 day to 12 years and 1 day, and ordered to pay a fine of P2,000.00. May P be compelled to serve subsidiary imprisonment in case of failure to pay the fine? Answer. P cannot be compelled to serve subsidiary imprisonment. Art. 39 PAR 3. RPC provides that there is no subsidiary imprisonment if the principal penalty is higher than prison correctional. The penalty of 6 years 1 day to 12 years and 1 day is higher than prison correctional, which has a maximum of 6 years only. The mere addition of 1 day to 6 years is already higher than prison correctional, and in such a case there can be no subsidiary imprisonment for failure to pay the fine. Rosario vs. Director of Prisons, L03463, March 6, 1950. Art 39, Subsidiary Imprisonment 1983 No. 13. Charged with estafa in September 1983, the accused was found guilty and sentenced to an indeterminate penalty of 4 years, 2 months, and 1 day of prison correctional, as minimum, to 8 years and 1 day of prison mayor, as maximum, and to pay a fine of P3,000. Aside from the indemnification of the victim, with subsidiary imprisonment for both fine and indemnity in case of insolvency. Was subsidiary imprisonment properly imposed? Explain. Answer. Subsidiary imprisonment was not properly imposed because the principal penalty, which is 4 years, 2 months 1 day of prison correctional as minimum to 8 years and 1 day of prison mayor as maximum, is higher than prison correctional. Art. 39, PAR 3, Rev. Penal Code. Besides, there is no subsidiary imprisonment for indemnity, as subsidiary imprisonment is limited to non-payment of fine. Art. 39 as amended by Act 5465. Art. 45, when not subject to confiscation 1987 No. 15. Jose, Pedro, and Juan robbed ABC Bank of P200,000 and using a stolen car, immediately proceeded to Quezon City. The police recovered the money and the car. After the trial, during which the bank lawyer intervened as private prosecutor, the court convicted Jose, Pedro, and Juan of robbery and ordered the forfeiture of the money, P200,000.00, and the car in favor of the government as proceeds and instrument of the crime, respectively. The bank lawyer received copy of the judgment, but did not do anything. Jose, Pedro, and Juan did not appeal the judgment, and began service of sentence. 2 months later, realizing that the court did not order the return of the money to the bank lawyer filed a motion for modification of the judgment and prayed that the money be ordered returned to the bank. 2 months later, Armando, the owner of the stolen car, learned of the judgment even much later. He comes to you seeking your well-considered opinion on whether it is still possible to recover his car. A. As legal counsel, what will you tell him? Explain briefly. B. Under the facts given, would the bank be entitled to the return of the money? Why? Answer. A. As legal counsel, I would advise Armando to file a civil action for the recovery of his car against its legal custodian. The car was stolen and therefore it belonged to Armando, an innocent party, who has not participated in the commission of the robbery by Jose, Pedro, and Juan. The car is therefore not subject to confiscation. Art. 47 and 83, Death Penalty, Crimes Punishable 1988 No. 3. C. What offences, if any, may be punished with the death penalty in our jurisdiction at present? Explain. Answer. C. At present, no offence may be punished with the death penalty in our jurisdiction at present. The 1987 Constitution has abolished the death penalty and the abolition affects even those who has already been sentenced to death penalty. Therefore, unless Congress enacts a law, no offence may be punished with the death penalty at present. But until today, Congress has not yet passed a law to this effect. Art. 47 and 83, Death Penalty, Exceptions thereto 1998 No. 13. 1. Under Article 47 of RA 7659, the death penalty shall be imposed in all cases in which it must be imposed under existing laws. What are the exceptions to the imposition of the death penalty? 3% Answer. 1. The death penalty shall not be imposed although prescribed under existing laws. 1. When the accused is less than 18 years of age at the time of the commission of the offence. 2. When the accused is more than 70 years of age already. 3. When upon appeal or automatic review of the case by the Supreme Court, the required majority vote for the imposition of the death penalty is not obtained. Art. 47 and 83, Death Penalty, Heinous Crimes 1995 No. 1. 1. A. When was the constitutional proscription against the imposition of the death penalty lifted? B. When is the execution of the death penalty suspended under the revised Penal Code? C. When is the death penalty commuted under the same code? 2. A. What are heinous crimes? B. Name 10 specific heinous crimes. Answer. 1. A. The constitutional proscription against the imposition of the death penalty was lifted with the enactment of RA 7659, otherwise known as the Heinous Crimes Law, which took effect 15 days after publication on December 16, 1993, that is on December 3 L. 1993, People vs. Martin Simon, 234 SCRA 555. B. Death penalty shall not be executed, a. upon a woman within 3 years after date of the sentence, b. while she is pregnant, c. upon a person over 70 years old, Art. 83 RPC, or, 4, upon a convict who becomes insane after final sentence, Art. 79, RPC. C. When the convict reaches the age of 70 years the death sentence is commuted to reclusion perpetua, Art. 83, RPC. 2. A. Heinous crimes are those which are punishable by death for being grievous, odious, and hateful offences in which, by reason of their inherent or manifest wickedness, viciousness, atrocity and perversity are repugnant and outrageous to the common standards and norms of decency and morality in a just, civilized and ordered society. B. The 10 specific heinous crimes are, 1. Treason, 2. Qualified piracy, 3. Qualified bribery, 4. Parricide, 5. Murder, 6. Kidnapping and serious illegal detention, 7. Robbery with homicide, 8. Destructive arson, 9. Rape committed by 2 or more persons, or with a deadly weapon or with homicide, 10. Plunder. Art. 47 and 83, Death penalty, heinous crimes, 1997, number 10. A. What do you understand by the so-called heinous crimes? B. What are the instances when the death penalty could not be imposed, although it should otherwise ordinarily be meted out? Answer. A. Heinous crimes are those grievous, odious, and hateful offences in which by reason of their inherent or manifest wickedness, viciousness, atrocity, and perversity, are repugnant and outrageous to the common standards and norms of decency and morality in a just, civilized and ordered society. They are punishable by reclusion perpetua or life imprisonment to death. Whereas Clause RA 7659. B. 1. When the guilty party is below 18 years of age at the time of the commission of the crime, or when the offender is more than 70 years of age. 2. When upon appeal or automatic review of the case by the Supreme Court, the required majority vote is not obtained for the imposition of the penalty, in which case the penalty shall be reclusion perpetua. Art. 48, Aberratio Ictus 1993, number 12. Explain and illustrate the following: 1. Aberratio Ictus, 2. Impossible crime, and 3. Subornation of perjury. Answer. 1. Aberratio Ictus. A fired a gun at his father to kill him but hit instead a stranger. Art. 48, Aberratio Ictus 1996, number 2. 1. At the height of an altercation, Pedrito shot Paulo but missed, hitting Tiburcio instead, resulting in the death of the latter. Pedrito, invoking the doctrine of aberratio ictus, claims exemption from criminal liability. If you were the judge, how would you decide the case? Answer. 1. If I were the judge, I will convict Pedrito and find him guilty of the complex crime of homicide with attempted homicide. The single act of firing at Paulo resulted in the commission of 2 felonies, one grave, homicide, and the other less grave, attempted homicide, thus falling squarely under Art. 48, RPC, hence, the penalty would be for the more serious crime, homicide in its maximum period, 17 years 4 months and 1 day to 20 years. Aberratio ictus, mistake in the blow, could not be used as a defense as it is not an exempting circumstance. Pedrito is liable under the principle of Art. 4, RPC, which makes a person criminally liable for all the natural and logical consequences of his felonious act. Art. 48, Aberratio ictus vs error in persone 1994, number 2. 1. Distinguish aberratio ictus from error in persone. Answer. 1. Aberratio ictus or mistake in the blow occurs when a felonious act missed the person against whom it was directed and hit instead somebody who was not the intended victim. Error in persone, or mistake in identity, occurs when the felonious act was directed at the person intended, but who turned out to be somebody else. Aberratio ictus brings about at least two felonious consequence, i.e. the attempted felony on the intended victim who was not hit and the felony on the unintended victim who was hit. A complex crime of the first form under Art. 48, RPC generally result. In error in persone only one crime is committed. Art 48, Aberratio Ictus, Error in Persone and Praeter Intentionem 1989 Number 1. What do you understand by Aberratio Ictus, Error in Persone, and Praeter Intentionem? Do they alter the criminal liability of an accused? Explain. Answer. Aberration Ictus, Error in Persone and Praeter Intentionem are the three ways by which a person may commit a felony although the wrongful act done is different from that which he intended. In Aberratio Ictus, there is a mistake in the blow, meaning to say that the offender intending to cause an injury to one person actually inflicts it on another because of lack of precision, as for example when A, intending to kill B, fires his gun at the latter but because of poor aim or lack of precision, he hits C instead, who suffers serious physical injury. In error in persone, there is a mistake in the identity of the victim, as for instance, when A, intending to kill B, his enemy lay in ambush for the latter to pass along a dark alley. Because of the darkness, A fired his gun at a person passing by, thinking him to be B. It turned out that the person shot was C, A's father. In praeter intentionem, the injurious result is greater than that intended by the offender, the act exceeds the intent, as for instance, where A, without intent to kill, strikes B with his fist at the back of the head, causing B to fall down with his head hitting the asphalt pavement, resulting in the fracture of his head that caused his death. The presence of these circumstances will alter the criminal liability of the accused. Thus, in aberratio ictus, two offences are actually committed by the offender, that which he intended to commit and that which he actually committed. But if these two offences are both either grave or less grave, since they are produced by one single act, a complex crime will result. In the case of error in persone, the offender shall be guilty of the crime actually committed by him, but the penalty to be imposed shall either be the penalty for the crime actually committed or that for the crime intended to be committed. Whichever is lower, but the same will be imposed in its maximum period. In the case praeter intentionem, the offended will incur criminal liability for the felony actually committed by him, but he will be entitled to the mitigating circumstance of not having intended to commit so grave a wrong as that which he committed. Art 48, Aberratio Ictus, Error in Persone and Praeter Intentionem 1999 No. 6. What do you understand by Aberratio Ictus, Error in Persone, and Praeter Intentionem? Do they alter the criminal liability of an accused? Explain. 4%. Suggested answer. Aberratio ictus or mistake in the blow occurs when the offender delivered the blow at his intended victim but missed, and instead such blow landed on an unintended victim. The situation generally brings about complex crimes where from a single act, two or more grave or less grave felonies resulted, namely the attempt against the intended victim and the consequence on the unintended victim. As complex crimes, the penalty for the more serious crime shall be the one imposed and in the maximum period. It is only when the resulting felonies are only light that complex crimes do not result and the penalties are to be imposed distinctly for each resulting crime. Error in persone or mistake in identity occurs when the offender actually hit the person to whom the blow was directed but turned out to be different from and not the victim intended. The criminal liability of the offender is not affected, unless the mistake in identity resulted to a crime different from what the offender intended to commit, in which case the lesser penalty between the crime intended and the crime committed shall be imposed but in the maximum period, Art 49, RFC. Praeter intentionem or where the consequence went beyond that intended or expected. This is a mitigating circumstance, Art. 13 PAR 3, RPC, when there is a notorious disparity between the act or means employed by the offender and the resulting felony, i.e., the resulting felony could not be reasonably anticipated or foreseen by the offender from the act or means employed by him. Art 48, Aberratio Ictus, Attempted Murder with Homicide 2000 No. 14. Despite the massive advertising campaign in media against firecrackers and gun firing during the New Year's celebrations, Jonas and Haja bought 10 boxes of Super Lolo and PLA in Baco, Bulacan. Before midnight of December 31, 1999, Jonas and Haja started their celebration by having a drinking spree at Jonah's place by exploding their high-powered firecrackers in their neighborhood. In the course of their conversation, Jonas confided to Haja that he has been keeping a long-time grudge against his neighbor Japoy in view of the latter's refusal to lend him some money. While under the influence of liquor, Jonas started throwing lighted super lolos inside Japoy's fence to irritate him, and the same exploded inside the latter's yard. Upon knowing that the throwing of the super lolo was deliberate, Japoy became furious and sternly warned Jonas to stop his malicious act or he would get what he wanted. A heated argument between Jonas and Japoy ensued, but Haja tried to calm down his friend. At midnight, Jonas convinced Haja to lend him his .45 caliber pistol so that he could use it to knock down Japoy and to end his arrogance. Jonas thought that after all, explosions were everywhere and nobody would know who shot Japoy. After Haja lent his firearm to Jonas, the latter again started throwing lighted super lolos and PLA plus at Japoy's yard in order to provoke him so that he would come out of his house. When Japoy came out, Jonas immediately shot him with Haja's .45 caliber gun but missed his target. Instead, the bullet hit Japoy's 5-year-old son who was following behind him, killing the boy instantaneously. A. What crime or crimes can Jonas and Haja be charged with? Explain. 2%. B. If you were Jonas and Haja's lawyer, what possible defenses would you set up in favor of your clients? Explain. 2%. C. If you were the judge, how would you decide the case? Explain. 1%. Suggested answer. A. Jonas and Haja can be charged with the complex crime of attempted murder with homicide because a single act caused a less grave and a grave felony, Art. 48 RPC. Attempted murder is a less grave felony, while consummated homicide is a grave felony. Both are punishable by afflictive penalties. Art. 48, Complex crime, incriminatory machination with unlawful arrest 1977 No. 3b. A police officer surreptitiously placed a marijuana cigarette in the breast pocket of the polo shirt of a student and then arrested the student for illegal possession of marijuana cigarette. For what crime or crimes will the police officer be liable? Reason fully. Answer. The police officer will be liable for the complex crime of incriminatory machination with unlawful arrest. People v. Alajo, et al., L20721, April 30, 1966. The placing of marijuana cigarette in the breast pocket of the polo shirt of the student is incriminatory machination, which is planting evidence. The arrest of the student for illegal possession of the marijuana cigarette is unlawful arrest. The two acts followed closely each other. Incriminatory machination is the means to commit unlawful arrest and is, therefore, a complex crime. Art. 48, Complex crimes, applies only to felonies, Estafa and BP 22 1987 No. 8. Jose purchased roofing materials worth P20,000.00 from Pai & Sons Construction Company owned by Pedro, and paid the latter a check in the said amount. The following day, Pedro deposited the check, but it was returned dishonored because it was drawn against a closed account. Notwithstanding written demands, Jose failed to make good said check. Attorney Saavedra, counsel for Pedro, filed 2 complaints against Jose with the Office of the Provincial Fiscal, one for estafa under Article 315 of the Revised Penal Code and another for violation of Batas Pambansa BLG, 22. Attorney San Pascual, counsel for Jose, claimed that if his client was at all liable, he could only be liable for violation of Batas Pambansa BLG 22 and not for estafa under Article 315 of the Revised Penal Code because one precludes the other and because Batas Pambansa BLG 22 is more favorable to the accused as it carries a lighter penalty. The investigating fiscal, on his resolution, stated that only one crime was committed, namely, the complex crime of estafa under Article 315 of the Revised Penal Code and violation of Batas Pambansa BLG 22 because the single act of issuing the bouncing check constitutes 2 offences, one under Article 315 of the Revised Penal Code and another under Batas Pambansa BLG 22. If you were the provincial fiscal asked to review the matter, how would you resolve it? Answer. The resolution of the investigating fiscal is erroneous. There is no complex crime of estafa under Article 315 of the Revised Penal Code and the violation of BP 22. A complex crime refers only to felonies which are punished in the Revised Penal Code. Batas 22, which punishes the offence of issuing a worthless check, is a special law. The contention of attorney San Pascual, counsel of Jose, that his client should be liable only for Batas 22 and for estafa under the Revised Penal Code because one precludes the other and because Batas 22 is more favorable to the accused as it carries a lighter penalty, cannot also be sustained. Batas 22 specifically provides that liability under said act is without prejudice to any liability for estafa under the Revised Penal Code. The check issued by Jose in payment of roofing materials from Pai and Sons was worthless. Said bouncing check having been issued in payment of a simultaneous obligation constitutes estafa under the Revised Penal Code and also the offence punished under Batas 22. There is no identity of offences. Damage is not an element of the offence punished in Batas 22, whereas in estafa damage is an element. Estafa is an act mala in SE in which requires intent as an element, while the offence punished in Batas 22 is an act mala prohibita where intent is not an element. Art 48, complex crimes, applies only to felonies, illegal possession of firearms. 1975 No I. A shot and killed D with an unlicensed firearm. The fiscal filed charges against A, one for homicide and another for illegal possession of firearm. The defense counsel contended that only one charge should have been filed, the complex crime of homicide with illegal possession of firearm, as the use of the unlicensed firearm was a necessary means to commit the homicide. Is the contention meritorious? Why? Answer. A. The contention of defense counsel is not meritorious. A complex crime refers only to felonies. Art 48, Revised Penal Code, People vs. Araneta, 48 Philosophy 650. The offender will be liable for two crimes. One for homicide, which is a felony punished in the Revised Penal Code, and another for illegal possession of firearm, which is an offence punished in a special law. B. People vs. Alger, 92 Phil 227. Art 48, Complex Crimes, Coup d'état and Rebellion and Sedition 2003 No X. B. Can there be a complex crime of coup d'état with rebellion? 2%. C. Can there be a complex crime of coup d'état with sedition? 2% suggested answer. B. Yes, if there was conspiracy between the offenders committing the coup d'état and the offenders committing the rebellion. By conspiracy, the crime of one would be the crime of the other and vice versa. This is possible because the offender in coup d'état may be any person or persons belonging to the military or the national police or a public officer, whereas rebellion does not so require. Moreover, the crime of coup d'état may be committed singly, whereas rebellion requires a public uprising and taking up arms to overthrow the duly constituted government. Since the two crimes are essentially different and punished with distinct penalties, there is no legal impediment to the application of Art. 48 of the Revised Penal Code. C. Yes, coup d'état can be complexed with sedition because the two crimes are essentially different and distinctly punished under the Revised Penal Code. Sedition may not be directed against the government or non-political and objective, whereas coup d'état is always political and objective as it is directed against the government and led by persons or public officer holding public office belonging to the military or national police. Art. 48 of the Code may apply under the conditions therein provided. Alternative answer. The crime of coup d'état cannot be complexed with the crime of rebellion because both crimes are directed against the government or for political purposes, although the principal offenders are different. The essence may be the same and thus constitute only one crime. In this situation, the two crimes are not distinct and therefore, may not be proper to apply Article 48 of the Code. Art. 48, Complex Crimes, either must not be slight. 1989 No. 3. Rodolfo, a policeman, was cleaning his service pistol inside his house when it fell from his hand and fired. The bullet hit a neighbor on the stomach and a second neighbor on the leg. The injuries sustained by the two neighbors required 35 days and 9 days of medical attendance, respectively. The investigating fiscal later filed an information for frustrated homicide and slight physical injuries through reckless imprudence against Rodolfo. Is the charge correct? Explain. Answer. The charge is not correct. One single act of accidental shooting cannot give rise to two felonies, one of which is intentional and the other negligent. Frustrated homicide presupposes intent to kill. The facts do not show any intent to kill on the part of Rodolfo. At most, he was careless, and therefore only negligent. Two separate crimes of serious physical injuries, against the first neighbor whose injuries requires 35 days of medical attendance, and slight physical injuries, against the second neighbor, both through reckless imprudence, were committed by Rodolfo. Although both of these offenses were the result of one single act, a complex crime is not committed because it is only when a single act constitutes two or more grave or less grave felonies that a complex crime may be committed under the first clause of Article 48, RPC. Slight physical injuries is not a grave or less grave felony. Art. 48, Complex Crimes, either must not be slight, prescription 1980 No. X. T was charged in an information with the complex crime of reckless imprudence resulting in damage to property in the sum of P700,000 and slight physical injuries, both resulting from a single act of imprudence. The incident which gave rise to the quasi-offence occurred on November 14, 1979. The accused was charged on March 14, 1980. Should the resulting offences be considered a complex crime subject to one penalty? Answer. The resulting offences cannot be considered as a complex crime. The slight physical injuries which resulted from a single act of imprudence which occurred on November 14, 1979, prescribed already when the accused was charged on March 14, 19 so. Slight physical injuries, being a light felony, prescribes in 2 months, Art. 90, RPC. Another reason is that a complex crime exists if a single act results in two grave or less grave felonies. If one of the resulting felonies is light, like slight physical injuries, as stated in the problem, there can be no complex crime. Lontoc vs. Gorgonio, L37396 April 30, 1979. Art. 48, Complex Crimes, Nature 1999 No. 15. A. Actuated by malice and with the use of a fully automatic M14 submachine gun, shot a group of persons who were seated in a cockpit with one burst of successive, continuous, automatic fire. 4 persons were killed thereby, each having hit by different bullets coming from the submachine gun of A. 4 cases of murder were filed against A. The trial court ruled that there was only one crime committed by A for the reason that, since A performed only one act, he having pressed the trigger of his gun only once, the crime committed was murder. Consequently, the trial judge sentenced A to just one penalty of reclusion perpetua. Was the decision of the trial judge correct? Explain. 4%. B. What constitutes a complex crime? How many crimes may be involved in a complex crime? What is the penalty therefore? 4%. Suggested answer. A. The decision of the trial judge is not correct. When the offender made use of an automatic firearm, the acts committed are determined by the number of bullets discharged. Inasmuch as the firearm being automatic, the offender need only press the trigger once and it would fire continually. For each death caused by a distinct and separate bullet, the accused incurs distinct criminal liability. Hence, it is not the act of pressing the trigger which should be considered as producing the several felonies, but the number of bullets which actually produced them. B. a complex crime is constituted when a single act caused two or more grave or less grave felonies, or when an offence is committed as a necessary means to commit another offence, Art. 48, RPC. At least two crimes are involved in a complex crime, either two or more grave or less grave felonies resulted from a single act, or an offence is committed as a necessary means for committing another. The penalty for the more serious crime shall be imposed and in its maximum period. Art. 48, RPC. Crimes against persons, homicide, infanticide, parricide, murder 1999 No. 16. Who may be guilty of the crime of parricide? 3%. A. Killed, 1. A woman with whom he lived without benefit of clergy, 2. Their child who was only 2 days old, 3. Their daughter, and 4. Their adopted son. What crime or crimes did A commit? 3%. Suggested answer. A. Any person who kills his father, mother, or child, whether legitimate or illegitimate, or his ascendants or descendants, or spouse, shall be guilty of parricide. Art. 246, RPC. B. A committed the following crimes. 1. Homicide or murder as the case may be, for the killing of his common-law wife who is not legally considered a spouse. 2. Infanticide for the killing of the child as said child is less than 3 days old. Art. 255, RPC. However, the penalty corresponding to parricide shall be imposed since A is related to the child within the degree defined in the crime of parricide. 3. Parricide for the killing of their daughter, whether legitimate or illegitimate, as long as she is not less than 3 days old at the time of the killing. 4. Murder for the killing of their adopted son as the relationship between A and the said son must be by blood in order for parricide to arise. Art. 48, Complex Crimes, Ordinary Complex Crime vs Special Complex Crime 2003 No. X. A. Distinguish between an ordinary complex crime and a special complex crime as to their concepts and as to the imposition of penalties. 2%. Suggested answer. A. In concept. An ordinary complex crime is made up of two or more crimes being punished in distinct provisions of the revised penal code but alleged in one information either because they were brought about by a single felonious act or because one offence is a necessary means for committing the other offence or offences. They are alleged in one information so that only one penalty shall be imposed. A special complex crime, on the other hand, is made up of two or more crimes which are considered only as components of a single indivisible offence being punished in one provision of the revised penal code. As to penalties. In ordinary complex crime, the penalty for the most serious crime shall be imposed and in its maximum period. In special complex crime, only one penalty is specifically prescribed for all the component crimes which are regarded as one indivisible offence. The component crimes are not regarded as distinct crimes and so the penalty for the most serious crime is not the penalty to be imposed nor in its maximum period. It is the penalty specifically provided for the special complex crime that shall be applied according to the rules on imposition of the penalty. Art. 48, Continuing Offence vs Delito Continuado 1994 No. 4. 2. Differentiate delito continuado from a continuing offence. Answer. 2. Delito continuado, or continuous crime, is a term used to denote as only one crime a series of felonious acts arising from a single criminal resolution, not susceptible of division, which are carried out in the same place and at about the same time, and violating one and the same penal provision. The acts done must be impelled by one criminal intent or purpose, such that each act merely constitutes a partial execution of a particular crime, violating one and the same penal provision. It involves a concurrence of felonious acts violating a common right, a common penal provision, and impelled by a single criminal impulse. People vs. Ledesma, 73 SCRA 77. On the other hand, a continuing offence is one whose essential ingredients took place in more than one municipality or city, so much so that the criminal prosecution may be instituted and the case tried in the competent court of any one of such municipality or city. The term continued crime or delito continuado mandates that only one information should be filed against the offender. Although a series of felonious acts were performed, the term continuing crime is more pertinently used with reference to the venue where the criminal action may be instituted. Art. 48, Continuous Crimes 1976 No. 8a. X filed 50 complaints of estafa with the fiscal's office against his employee, Y, claiming that Y misappropriated sums of money on various dates representing the amounts he collected on different dates from X's customers. All in all, the fiscal filed 50 informations for estafa in court. Y questioned the filing of 50 different informations of estafa against him on the ground that the charges were components of one crime, as this was impelled by a single criminal intent. Is Y's contention tenable? Reason. Answer. Y's contention is not tenable. The 50 different informations for estafa filed against Y refer to misappropriations of money on various dates representing amounts collected on different dates from the customers of X. Misappropriation on each date is a separate crime of estafa because it is motivated by an independent criminal impulse. Misappropriations on different dates constitute several cases of estafa because each misappropriation is generated by a distinct criminal resolution. This case refers to material plurality of crimes, as the different acts committed on different dates have separate criminal resolutions which should result in different crimes which are judicially independent. The charges cannot be mere components of one crime impelled by a single criminal intent because the misappropriations were committed on various dates and not on the same occasion. The different criminal acts have different criminal intent or resolutions. In a continuous crime, the criminal acts arise from a single criminal intent or resolution which is not susceptible of division. Gamboa, et al. vs. Court of Appeals, et al., 72 OG 3658. Art. 49, Error in Persone 1983 No. 12. Julius planned to do away with Mario, a business rival. With a bolo in hand, Julius waited in ambush at a dark alley where Mario used to pass every night on his way home. When a figure came by, Julius struck him with the bolo again and again, thinking that he was Mario. It turned out that the victim was Julius' own father, who had the same general appearance as Mario. What crime was committed? Citing applicable legal principles, for what crime should Julius be punished? Why? Answer. The crime committed is parricide. The problem refers to mistaken identity because the crime intended, which is the killing of Mario, a business rival, is different from the crime committed, which is the killing of the father of Julius, the offender. Under Article 49 of the Revised Penal Code, the offender, however, will be punished for the crime intended, which is murder, as the victim was ambushed at right and therefore treachery attended the killing of the victim, the penalty of which is to be imposed in its maximum period. The reason is the penalty for the crime committed, which is parricide, prescribes a penalty higher than murder which the accused intended to commit. Art. 49, Error in Persone 1986 No. 7. Roberto Cortez is the general manager of the family corporation. Because of his incompetence, inability to control his temper, and frequent quarrels with employees, his father finally decided to dismiss him. As Roberto was about to leave his office at 6 o'clock in the evening, his father went to his room, lambasted and fired him in the presence of several members of the office staff. Thoroughly enraged, Roberto ran out of the office, and, deciding to get even, waited at the exit of the parking lot where his father always passes at the close of each working day. A few minutes later, Roberto saw his father's car approach. He fired his pistol in the direction of the driver, thinking that the latter was his father. The man died instantly. Unknown to Roberto, the victim of his fire was Tagahatid, a company messenger whom the father had instructed to drive his car home. Roberto surrendered to the authorities. After investigation, the fiscal filed an information against Roberto for murder. He alleged that the killing was characterized by treachery as the victim was ambushed. Roberto's counsel insists that if any crime was committed, it should only be homicide attended by mitigating circumstances. Was the killing characterized by treachery? Explain. B. The penalty for parricide is reclusion perpetuate to death. The penalty for murder is reclusion temporal in its maximum period to death. The penalty for homicide is reclusion temporal. Assume that you are the trial judge. Given the circumstances cited above, state the offense committed by Roberto Cortez and impose the correct penalty under circumstances. Explain why you have decided to impose this penalty. Answer. A murder is the crime committed qualified by treachery. The fact that the victim was ambushed shows that the accused deliberately and consciously adopted a means to ensure specially and directly the commission of the crime without any risk from any defense that the person attacked might make. B. The offense committed by Roberto Cortez is murder. The penalty will be for murder to be imposed in its maximum period. The reason is murder, which is the crime committed, is different from the crime intended, the killing of the father of Roberto Cortez, which is parricide. This is a case of mistake of identity. The rule is if the penalty for the crime intended is higher than the penalty for the crime committed, the offender will be liable for the crime committed, but the penalty which shall be imposed is in its maximum period, Art 49, PAR 2, Revised Penal Code. Art 49, Error in Persone, Murder and Parricide 1986 No. 7. Roberto Cortez is the general manager of the family corporation. Because of his incompetence, inability to control his temper, and frequent quarrels with employees, his father finally decided to dismiss him. As Roberto was about to leave his office at 6 o'clock in the evening, his father went to his room, lambasted and fired him in the presence of several members of the office staff. Thoroughly enraged, Roberto ran out of the office, and, deciding to get even, waited at the exit of the parking lot where his father always passes at the close of each working day. A few minutes later, Roberto saw his father's car approach. He fired his pistol in the direction of the driver, thinking that the latter was his father. The man died instantly. Unknown to Roberto, the victim of his fire was Tagahatid, a company messenger whom the father had instructed to drive his car home. Roberto surrendered to the authorities. After investigation, the fiscal filed an information against Roberto for murder. He alleged that the killing was characterized by treachery as the victim was ambushed. Roberto's counsel insists that if any crime was committed, it should only be homicide attended by mitigating circumstances. Was the killing characterized by treachery? Explain. B. The penalty for parricide is reclusion perpetuate to death. The penalty for murder is reclusion temporal in its maximum period to death. The penalty for homicide is reclusion temporal. Assume that you are the trial judge. Given the circumstances cited above, state the offense committed by Roberto Cortez and impose the correct penalty under circumstances. Explain why you have decided to impose this penalty. Answer. A murder is the crime committed qualified by treachery. The fact that the victim was ambushed shows that the accused deliberately and consciously adopted a means to ensure specially and directly the commission of the crime without any risk from any defense that the person attacked might make. B. The offense committed by Roberto Cortez is murder. The penalty will be for murder to be imposed in its maximum period. The reason is murder, which is the crime committed, is different from the crime intended, the killing of the father of Roberto Cortez, which is parricide. This is a case of mistake of identity. The rule is if the penalty for the crime intended is higher than the penalty for the crime committed, the offender will be liable for the crime committed, but the penalty which shall be imposed is in its maximum period, Art 49, PAR 2, Revised Penal Code. Art 62, Habitual Delinquency 1991 No. 6. A was charged with homicide. During the trial, uncontradicted evidence consisting of medical certificates were presented showing that the accused had sustained injuries in 10 previous occasions while engaged in fisticuffs with different persons. He was also confined at the National Mental Hospital for mental ailment diagnosed as homicidal and suicidal instincts. During his second confinement thereat, he escaped. Upon conviction, the prosecutor objected to the application of the indeterminate sentence law, contending that the accused is a habitual delinquent and an escapee from the National Mental Hospital. If you are the judge, rule on the objection. Answer. The objection should be overruled. A could not be legally considered a habitual delinquent. Habitual delinquency cannot be validly invoked without being alleged in the information and proven during the trial. Besides, there is no indication that A was convicted within 10 years from last conviction or release, 3 times or oftener of the crimes of robbery, theft, estafa, physical injuries, or falsification. Being an escapee from the mental hospital will not disqualify him from the application of the ISL, as Section 2 thereof contemplates having escaped from confinement or evaded sentence. Confinement presupposes imprisonment by virtue of a final judgment. Art. 62, Habitual Delinquency and Recidivism 2001 No. 3. Juan de Castro already had three previous convictions by final judgment for theft when he was found guilty of robbery with homicide. In the last case, the trial judge considered against the accused both recidivism and habitual delinquency. The accused appealed and contended that in his last conviction, the trial court cannot consider against him a finding of recidivism and, again, of habitual delinquency. Is the appeal meritorious? Explain. 5%. Suggested answer. No, the appeal is not meritorious. Recidivism and habitual delinquency are correctly considered in this case because the basis of recidivism is different from that of habitual delinquency. Juan is a recidivist. Habitual delinquency, which brings about an additional penalty when an offender is convicted a third time or more for specified crimes, is correctly considered because Juan had already three previous convictions by final judgment for theft and again convicted for robbery with homicide. And the crimes specified as basis for habitual delinquency includes, inter alia, theft and robbery. Art. 62, Habitual Delinquency vs. Recidivism 1986 No. 5. Give at least 4 distinctions between habitual delinquency and recidivism. Can a person be a habitual delinquent without being a recidivist? Explain. Answer. The 4 distinctions between habitual delinquency and recidivism are: 1. In habitual delinquency, the crimes are specified, which are robbery, theft, estafa, falsification, serious and less serious physical injuries. In recidivism, the crimes are embraced in the same title of the revised Penal Code. 2. In recidivism, no period of time is fixed between the former conviction and the last conviction. In habitual delinquency, conviction of any of the specified crimes must take place within 10 years from the last conviction or release. 3. In recidivism, it is enough that there be a second conviction of any crime embraced in the same title of the last or the first crime. In habitual delinquency, there must be at least a third conviction of any of the specified crimes. 4. Recidivism is an aggravating circumstance and if not offset serves to increase the penalty. Habitual delinquency provides for the imposition of an additional penalty. There may be habitual delinquency without recidivism if the 3 convictions refer to crimes not embraced in the same title code, like robbery in the first conviction, a crime against property, falsification, the second conviction, a crime against public interest and serious physical injuries, the third conviction, a crime against persons. Art. 80, Suspension of Sentence, Minors 2003 No. 8. A was 2 months below 18 years of age when he committed the crime. He was charged with the crime 3 months later. He was 23 when he was finally convicted and sentenced. Instead of preparing to serve a jail term, he sought a suspension of the sentence on the ground that he was a juvenile offender. Should he be entitled to a suspension of sentence? Reasons. 4%. B. Can juvenile offenders, who are recidivists, validly ask for suspension of sentence? Explain. 4%. Suggested answer. A. No, A is not entitled to a suspension of the sentence because he is no longer a minor at the time of promulgation of the sentence. For purposes of suspension of sentence, the offender's age at the time of promulgation of the sentence is the one considered, not his age when he committed the crime. So although A was below 18 years old when he committed the crime, but he was already 23 years old when sentenced, he is no longer eligible for suspension of the sentence. B. Yes, so long as the offender is still a minor at the time of the promulgation of the sentence. The law establishing family courts, Rep. Act 8369, provides to this effect, that if the minor is found guilty, the court should promulgate the sentence and ascertain any civil liability which the accused may have incurred. However, the sentence shall be suspended without the need of application pursuant to PD 603, otherwise known as the Child and Youth Welfare Code, RA 8369, Sector 5A. It is under PD 603 that an application for suspension of the sentence is required, and thereunder it is one of the conditions for suspension of sentence that the offender be a first-time convict. This has been displaced by RA 8369. Art 80, Suspension of Sentence, Minors, PD 603 1977 No 3A. The accused was 17 years old when he was charged of grave coercion. Because of protracted trial, he was already 21 years old when the decision was promulgated convicting him of the offense charged. The accused asked for the suspension of his sentence pursuant to Presidential Decree No. 603, for he was a minor at the time of the commission of the offense. If you were the judge, will you suspend the sentence or not? State your reasons. Answer. If I were the judge, I would not suspend the sentence. The benefits of Article 80 as modified by Presidential Decree 603, as amended, would apply only to minors under 18 years old, not only at the time of the commission of the crime but also at the time of the trial. People v. Seals Para, 82 Philosophy 399, People v. S. Capistrano, 92 Philosophy 127. The law provides that if the court grants the request of the minor found guilty of the offense charged for the suspension of the pronouncement of the sentence, said minor is ordered committed to an institution under the supervision of the Department of Social Services until such minor shall have reached his majority XXX. This means that if he is already of age at the promulgation of the sentence, he cannot be committed any more. Art 80, Suspension of Sentence, Minors, PD 603 1985 No. 1. Minority is generally a privileged mitigating circumstance which entitles the minor offender to a suspended sentence. It may, however, under certain circumstances, be considered as a mere ordinary circumstance, in which case the offender may be immediately sentenced and made to serve the penalty imposed upon him instead of being placed under suspended sentence. Discuss. Answer. Minority as a privileged mitigating circumstance is considered in the imposition of the penalty, Art 68, Revised Penal Code. However, the age of the minor at the time of the commission of the crime may be considered in suspending the sentence upon conviction. So under the Child and Youth Welfare Code, Presidential Decree 603, as amended, a minor under 18 years old at the time of the commission of the offense and at the time of the trial, if found guilty after trial, may apply for the suspension of the sentence. The only instance where there is no suspension of the sentence in spite of minority is that provided in Article 80 of the Revised Penal Code, where the minor under 16 years old at the time of the commission of a light felony, if found guilty, the sentence is immediately imposed. But Article 80 has been expressly repealed by Presidential Decree 1179, which took effect on August 15, 1977. As a matter of fact, the Supreme Court held in People v. S. Sanchez, 132 SCRA 103-1984, that there are only two instances where there can be no suspended sentence, to wit, 1. If the offense committed by a minor is punishable by death or life imprisonment. 2. If the minor is 18 years and above at the time of the commission of the offense and at the time of the trial. Art 80, Suspension of Sentence, Minors, PD 603 1980 No. 12. Under the Child and Youth Welfare Code, what is the controlling criterion to determine whether or not an accused is a youthful offender so as to entitle him to suspension of sentence? Is there any difference between the revised Penal Code and the Child and Youth Welfare Code in so far as suspension of the sentence of a juvenile offender is concerned? Answer. Under the Youth and Child Welfare Code, the youthful offender must be under 18 years old not only at the time of the commission of the crime but also at the time of the trial so as to be entitled to suspension of sentence. People v. Casiguran, L. 45387, November 7, 1979, under the Child and Youth Welfare Code, the youthful offender who is found guilty after trial, must file an application for the suspension of the pronouncement of the sentence, which the court may grant if the interest of the minor and of the public so requires. Under Article 80 of the revised Penal Code, which covers a minor under 16 years of age at the time of the commission of a grave or less grave felony and at the time of the trial, which was expressly repealed by Presidential Decree No. 1179, the suspension of the pronouncement of the sentence upon the minor where there is evidence of guilt is automatic. Art. 80, Suspension of Sentence, Youthful Offender 1995 No. 7. Victor, Ricky, Rod, and Ronnie went to the store of Mang Pandoy. Victor and Ricky entered the store while Rod and Ronnie posted themselves at the door. After ordering beer, Ricky complained that he was shortchanged, although Mang Pandoy vehemently denied it. Suddenly Ricky whipped out a knife as he announced "Hold up ITO," and stabbed Mang Pandoy to death. Rod boxed the store's salesgirl Lucy to prevent her from helping Mang Pandoy. When Lucy ran out of the store to seek help from people next door, she was chased by Ronnie. As soon as Ricky had stabbed Mang Pandoy, Victor scooped up the money from the cash box. Then Victor and Ricky dashed to the street and shouted, "Tumakbo Nako!" Rod was 14 and Ronnie was 17. The money and other articles looted from the store of Mang Pandoy were later found in the houses of Victor and Ricky. 1. Discuss fully the criminal liability of Victor, Ricky, Rod, and Ronnie. 2. Are the minors Rod and Ronnie entitled to suspended sentence under the Child and Youth Welfare Code? Explain. Answer. 1. All are liable for the special complex crime of robbery with homicide. 2. No, because the benefits of suspension of sentence is not available where the youthful offender has been convicted of an offence punishable by life imprisonment or death, pursuant to PD No. 603, Art. 192, the complex crime of robbery with homicide is punishable by reclusion perpetua to death under Art. 294, 1, RFC People vs. Galit 230 SCRA 486. Art. 80, Suspension of Sentence, Minors, PD 603/1986 No. 16. Brothers Aber and Bobbitt, 16 and 17 years old, respectively, have had no food for the past 2 days. Suffering from severe hunger, they hatched a plan to break into a store to steal some food. 5 days later, at 12 midnight, they were able to enter the store by breaking the hinges of the door. Aber took 10 cans of sardines worth P50.00. Bobbitt wandered into a nearby room where the store owner, Cosma, was sleeping. Cosma, awakened by Bobbitt's footsteps, attacked Bobbitt with a club. Bobbitt avoided the blow and hit Cosma in the chest with his fist. Aber, upon hearing the commotion, entered the room and tried to pull Bobbitt away from Cosma. Cosma, however, continued to attack Bobbitt, forcing the latter to box Cosma in the face. Cosma collapsed on the floor. Bobbitt and Aber fled. The following day, Aber sold 6 of the sardine cans taken from the store to Demas, who lives a block from the store. Earlier that day, Demas heard rumors that the nearby store had been robbed and that his friend Cosma was found dead. Demas thought of asking Aber and Bobbitt where they got the sardines to clear away this doubt, but on second thought did not. He bought the cans for P20.00 and sold them for P30.00. The fiscal charged Aber and Bobbitt with the complex crime of robbery with homicide aggravated by nighttime, evident premeditation and dwelling. The fiscal charged Demas as an accessory of Aber and Bobbitt and for violation of the anti-fencing law, PD No. J612. D. if you were the counsel of Aber, what defenses would you raise? Explain. 2. If you were the counsel of Bobbitt, what defenses would you raise? Explain. 3. If you were the counsel of Demas, what defenses would you raise? Explain. 4. If you were the judge, how would you decide the case? Explain, answer. 1. If I were the counsel of Aber, I would question the validity of the charge. Robbery with homicide is not proper crime because there was no breaking of the door but only its hinges. People vs. Lisa Ng CA 62 OG 9879, the crime is theft. Since Aber was only 6 years old at the time of the commission of the crime, he should be prosecuted under the Youth and Child Welfare Code, where in case of conviction, he could apply for suspension of sentence. If granted, during confinement upon his good behavior, he would be entitled to be discharged. Aber cannot be liable for the killing of Cosma because he has no part in its commission. 2. If I were the counsel of Bobbitt, I would invoke his age at the time of the commission of the crime for the application of the Child and Youth Welfare Code. The crimes committed are theft and homicide. Regarding the homicide, Bobbitt can maintain that Cosma hit him with a club and continued to do so, forcing Bobbitt to attack him in the face. He can also invoke the mitigating circumstance of lack of intent to commit so grave a wrong as that which resulted. 3. If I were the counsel of Demas, I would maintain that he could not be liable as an accessory to the crime of homicide attributed to Bobbitt because he had no knowledge of its commission. Regarding the violation of the anti-fencing law, he can maintain that he bought the tins of sardines in good faith without any knowledge that these were the proceeds of the crime of theft. 4. If I were the judge, I would convict Aber and Bobbitt for the crime and theft. The breaking of the hinges of the door is not the breaking of the door as provided in the law. So the crime committed is not robbery. Only Bobbitt will be liable for the death of Cosma. Aber has no participation in his death aside from the fact that the crime is not a necessary consequence of the plan to steal food in the store. Besides, the act of Aber in trying to pull Bobbitt away from Cosma is an attempt to prevent Bobbitt from injuring Cosma. In the crimes of theft and homicide, only nighttime and dwelling are aggravating. Evident premeditation is inherent in theft, which is a crime against property. It cannot be considered in homicide as there is no showing of any previous planning to commit it. However, both Aber and Bobbitt, being 16 and 17 years respectively at the time of the commission of the crime, should be proceeded under the provisions of the Child and Youth Welfare Code, if still under 18 years at the time of the trial. If convicted, they could apply for the suspension of the sentence, and if granted, they would be committed to an institution until they reach the age of majority. If they behave properly during confinement, they would be returned to the court to be discharged. But if they proved themselves to be incorrigible, then for the imposition of the sentence. Demas will be liable for fencing as he bought the tins of sardines without inquiring from Aber where he got the sardines, and under the circumstances he could have known that those were the proceeds of the crime of theft. He bought them with intent to gain, as in fact he sold them for a profit. Art. 80, PD 603, Confidentiality of Records of Minor Offenders 1978 No XB. Jose, a teenager of 16 years, was found guilty of homicide. Because of his age, he was held to be a youthful offender pursuant to Presidential Decree No. 603, as amended, and instead of passing sentence, the judge ordered him committed to the Government Rehabilitation Center in Tanay, Rizal. Jose was released after a year and a half because of good behavior. He later applied for and was appointed to the position of clerk in the Court of First Instance of Rizal. Among the papers he submitted was an application form under oath in which Jose stated he had never been charged with, much less convicted of, any crime, in complete disavowal of his previous conviction. What offense/offenses did Jose commit? State your reasons. Answer. Jose did not commit any offense. Under Presidential Decree No. 603 as amended by Presidential Decree No. 1179, the records of his case are deemed privileged, and there is no liability for perjury or for concealment or misrepresentation by reason of his failure to acknowledge the case or recite any fact related thereto in response to any inquiry made to him for any purpose. Art 200. Art 80, PD 603, Youthful Offenders 1975 No XX. What is a youthful offender as defined in Presidential Decree No. 603 amending Article 80 of the Revised Penal Code? If you were a judge and found a youthful offender guilty of a crime, how would you sentence him? Answer. A youthful offender is one who is over 9 years old and under 21 years of age at the time of the commission of the offense. If a youthful offender is found guilty, if I were the judge, I would defer his sentence and suspend all proceedings after determining the imposable penalty and his civil liability, if any. I would then order the minor committed to the custody of the Department of Social Welfare or to any training institution operated by the government until he reaches 21 years or for a shorter period as I might deem proper after considering the reports of the Department of Social Welfare or of such training agency under whose care the minor was committed. Art 192, Presidential Decree No. 603. If the youthful offender is found incorrigible or his continued stay in the training institution is found inadvisable and is returned to the court, the judgment would be pronounced. The youthful offender shall be credited in the service of the sentence with the full time spent in actual confinement. Art 197, Presidential Decree No. 608. If he behaved properly during confinement, upon recommendation of the Department of Social Welfare, his case will be dismissed. Art 196, Presidential Decree HO 608, but it shall not obliterate his civil liability for damages. Art. 198, Presidential Decree No. 603. Extinction of criminal liability. Art. 89, Criminal Liability, Corporate Officers 1986 No. 2. Two hardware stores are located 2 blocks apart along Avenida Rizal in Manila. One store is named Glorious Hardware Co. while the other is Glorioso & Sons Hardware Incorporated. 200 bags of cement ordered by Glorious Hardware were brought by the driver of High Cement Corporation to Glorioso & Sons. The driver inquired from the manager of Glorioso & Sons, a certain Pedro Mendoza, whether that company ordered the cement. Mendoza answered yes and directed the driver to the warehouse of Glorioso & Sons where their laborers unloaded the cargo. Learning of the misdelivery, Jose Roxas, manager of High Cement, went to Glorioso & Sons and met with Pablo Glorioso and Cesar Glorioso, president and vice president, respectively, of the firm. Roxas explained that the cement belonged to his company and that the cargo was intended for Glorious Hardware. Roxas showed them the purchase order and other documents indicating that Glorious Hardware had already paid for the cement. Pablo and Cesar assured Roxas that they would look into the matter. A month passed but Glorioso & Sons did not return the bags of cement. Unknown to Pablo and Cesar, manager Mendoza sold the cement to another dealer. Estafa charges were filed against Pablo Glorioso, Cesar Glorioso, and Pedro Mendoza. Pablo and Cesar contended that they took no part in the misappropriation committed by Mendoza and, at any rate, as corporate officers they are not liable for the acts of other corporate officers. Discuss if the 3 accused persons may be held criminally liable. If so, in what capacity or capacities? Explain. Answer. Only Pedro Mendoza, the manager, will be liable for estafa. A corporate officer cannot be liable for the acts of another corporate officer except if he directly took part or aided in the commission of the felonious act. Pablo and Cesar Glorioso, President and Vice President, respectively, of the firm municipality in the amount of P10,000,000 M appealed the decision of the trial court to the Court of Appeals. Pending the appeal,